at the Truth and Reconciliation Commission.
CJ, I have been a commissioner of the Small Claims Court. I am a member of the LPC. I've been the secretary of the Bishop Bar some years ago. I'm presently the chairperson of the Bishop Bar. I think that's.
And you were a commissioner of the Small Claims Court for almost 10 years. And you were a commissioner of the Small Claims Court in 2009.
Yes.
Your application form mentions that you have presided as a chairperson over disciplinary hearings for various state departments, in particular the Department of Education, for many years, since 2009.
That is correct, CJ, I have. In fact, sat as chairperson of the Labour Oversight Committee. I was appointed as such during the 101B intervention into the Eastern Cape Education Department.
And you've also presided as chairperson over an appeal tribunal for Amadola Water Board. Yes.
I in fact sat as chairperson of the Labour Oversight Committee.
So in addition to all this adjudicative
during the 101B
you have
intervention
acted as a judge.
into the Eastern. Yes, I have acted as a judge. I've acted as a judge since various stints since 2022. My first stint was in July 2022, and I'm presently acting. I started acting on the 30th of March during recess, and my stint will end on the 19th of June. So I'm acting for the entire term.
And how long would you say this entire period amounts to?
Excluding what I'm presently doing, I would say in the region of about 45 weeks. That isn't taking into consideration the returns to the court to complete part herds. So I didn't include those weeks, just the actual weeks of appointed acting.
What kind of cases have you had?
I've done all of them, CJ. I've done criminal trials, I've done civil trials, I've done motion court, opposed motions, urgent applications, recess duty, taxation reviews, full bench appeals, criminal appeals, civil appeals. I don't think I've left anything out. I think I've done it all. CJ.
And you've written judgments?
Yes, I've written 85 judgments to date, CJ.
And some of those, I understand, have been reported?
I think I've come across about 5 that have been reported, but there may be more, I don't know.
And they cover both criminal and civil law aspects?
The reported ones? CJ?
Yeah, no, all of them.
All of them. No, they do cover all the areas, yes.
All right. I think I'm going to stop here and see what comes from the other commissioners. And I'm just going to remind commissioners that we revert to our default approach of one question per commissioner. Okay. Before I hand over to Acting Deputy Judge President Dawood, I'm going to ask our Objections Committee to put a couple of things to you for clarification.
Okay, thank you, CJ. Good morning, Advocate Collett.
Good morning, Commissioner.
As you have seen, there were 2 objections against your candidacy. One from Dr. Bako, where he alleged that as a chairperson of a disciplinary committee and initiator of the Department of Education in the Eastern Cape, you delayed matters so that you make more money, sometimes in 2017, ending in 2020, and that by doing so, you abandoned your independence. You became part of this inner cabal, that's he alleges. And so you just need to give us a brief background. The Objections Committee considered it, but we just wanted you to explain it, just a little, not too long, so that at least this body can just assess whether we were correct when we said it does not have merit. The second one is the issue of your a debt review with the FNB matter. I know that you did explain thoroughly yesterday, but for the benefit of the acting Judge President, please do that so that we clear these matters out. Thank you.
Thank you, Commissioner. The objector is a lady. She was one of the many people that I was briefed to discipline by the State Attorney on behalf of the Education Department. I acted purely on instructions. Any fees that I earned as a consequence of that brief would have been generated and sent to the State Attorney, who would have checked those fees with their client, and I would have been remunerated accordingly. I have not been involved in any collusive activities, any organizations, or any way to make myself, enrich myself at the expense of anybody else. It is true that I initiated in the Education Department, and I admit that I've initiated several disciplinary hearings in the Education Department. I do not chair in the Education Department. That is of my own choice, because I felt that because I initiated so often, there may be a perception of bias if I was to chair in the same department. I do, however, state that I have chaired in the other departments. There is no factual, objective foundation for the allegations that have been made. On the contrary, I did not delay her proceedings in any way. The counsel that represented her at the arbitration proceedings, senior counsel, is in fact one of the people that recommended me to this Judicial Commission. In addition thereto, the Chief State Law Advisor, in his recommendation of me to this commission, mentioned that, quite specifically, that when I was engaged on brief, the departments were more than happy because they got value for money from me and my services. If I was indeed guilty of what the objector complained of, that certainly would not have been the response from the Chief State Law Advisor, who is aware of all litigation that is taking place regarding the government departments in the Eastern Cape Province. So, Commissioner, those are my responses to that objection. The second one was the First National Bank objection. I do not know this objector personally. I do not know how she would have any information whatsoever regarding my financial situation. It might well be because of the landmark case, Collett versus FNB. I did not litigate in court to avoid my debt. That is completely and utterly false. The circumstances were such, and I will summarize them. I found myself falling upon hard times as a result of suddenly becoming a sole breadwinner to a family of 5 children. As a consequence of that, and because at that stage I was in fact assisting debt review litigants on a pro bono and contingency basis, I was fully aware of the fact that I could go under debt review, and in fact the attorney that was instructing me in those matters suggested that I did that momentarily whilst I liquidated my movable property so as to alleviate my debt situation. I did that, or should I say I was in the process of doing that, but I didn't realize at that stage that FNB would in fact issue summons against me for one of the properties, and in fact it culminated in a summary judgment which I did not argue. Pursuant thereto, because there was so much conflict surrounding 8610, I made a decision to take my matter to the Supreme Court of Appeal so as to get some clarity on that particular section. At that stage, the High Court in Western Cape had found that it was such a serious situation, and there being so much conflict, they themselves had convened a full bench to make a decision on that 8610, which they indeed did. The issue was that debt reviews would be referred to court and you could cancel debt review within 60 days. And unfortunately, because of the backload in the magistrates' courts, the matters were not normally considered within 60 days. So on the 61st day, it gave a credit provider the right to cancel debt review, and that was the major objection. The Western Cape Court found that, or decision was that debt review could not be cancelled whilst the matter had been referred to court. Crystal J in that matter specifically said it's like giving a person an umbrella, then snatching it away when it rains. Nonetheless, that decision was not binding on the rest of the country, and it still left the conflict. So the matter was to go to the Supreme Court of Appeal, and my intention was to find a counsel who would argue it pro bono. What I didn't anticipate yet again was the fact that the bank brought an urgent application to the Supreme Court of Appeal to expedite the date, and consequently it was expedited, and I had very little time, and I could not secure the services of a person to go and argue the matter on my behalf. So I had two choices. At that stage, the settlement of my debt was imminent. So it didn't matter to me one way or the other. I could have simply withdrawn the appeal. But in the interests of certainty and in the interests of the clients that I was representing at that time, I elected to go and argue it at the Supreme Court of Appeal myself. I was unsuccessful. Pursuant thereto, we were requested or asked whether we would do an appeal to the Constitutional Court. I agreed. Fortunately, a senior counsel stepped forward and prepared that application, but it was similarly dismissed on the basis that the Constitutional Court decided that it was not in public interest. Nonetheless, thereafter, I respected both decisions. Obviously, as an officer of the court, I respected those decisions, and we proceeded forward. And there was another case that came thereafter to try and extend or soften the blow as far as 8611 was concerned, which is a referral back to court to reinstate the debt review. But ultimately, in the 2014 amendment, which came into effect on the 13th of March 2015, the legislature came to the assistance of the debt of this particular issue, and the legislation was amended to reflect that if a debt review had been referred to court, it could not be cancelled whilst it was pending before court. So effectively what happened was the legislature saw that that gave effect to the aims and objectives of the Act. So in short, the objection regarding my appearing for myself or my avoidance of debt in going to court is completely and utterly unfounded. This was the basis upon which I dealt with the matter in court. I'd also like to mention for the record that that was a financial predicament in a period of time. It no longer exists. I settled all the outstanding debts in full, and I am still the owner of the house, which was the subject of the particular case in question.
Thank you, Advocate Perez.
Thank you.
Thank you, Commissioner. Judge Dawood.
Thank you, Chief Justice. Advocate Colette, good morning.
Good morning, Judge Dawood.
What unique skill sets or expertise will you bring to our bench?
I think after 40 years of experience, I have covered most areas of law. I'm a quick thinker. I have reasonable and rational thought processes. I'm very quick with my judgments. I have a keen understanding of the law. I believe that I have always treated people with respect and dignity throughout my career. I have done a lot of pro bono work. I've stood next to the marginalized, the disadvantaged. I've frequently given people a voice. So I don't believe that I would act any differently on the bench. I would always treat people with respect. And besides that, I'm a keen upholder of the Constitution, Judge Dawood, and I would certainly make sure that in the exercise of my duties, I performed accordingly.
Thank you, Advocate Colette. Thank you, Chief Justice.
Thank you, Judge Dawood. Premier.
Thank you very much, Chief Justice. Good morning to all commissioners. Good morning to Advocate Colette.
Good morning, Commissioner.
Yeah. Thank you very much, Advocate. Just briefly on the transformation.
Yes.
Your appreciation of the transformation, particularly in the judiciary. as well as the rationalization, which was occasioned by the report of Justice Dehang Moseneke, the relocation of the seat from Grahamstown to Bishop.
Sorry, Commissioner, did you want me firstly to speak about the transformation on the bench?
Yes.
You did. Transformation on the bench is non-negotiable. Section 174 of the Constitution commands that that in fact takes place. But similarly, Section 174 enjoins the appointment of fit and proper persons with the correct integrity and skill sets. It is a given that transformation, particularly regarding gender, must take place. The bench must transform. At the end of the day, the question could well be whether my appointment would fulfill the needs of transformation. Well, I would say this. I don't for any manner of means want to say that my identity alone justifies my appointment to the bench, nor do I wish to diminish any black female that should be appointed to this bench. But what I would say is that from my point of view, what I would do for transformation, and maybe the question is rather this, respectfully, given my skill set and given the fact that I have demonstrated myself to be a fit and proper person and upholder of the Constitution, and given the fact that Section 174 alongside the transformative process demands that, would my appointment to the bench not strengthen transformation? So that is my answer on transformation to the bench, Commissioner. Your other question, as I understand it, is regarding the rationalization of the courts in the Eastern Cape. Am I correct?
Yes, you are true.
Yes. Sorry, I'm watching you on the screen. I'm not. So the transformation of the courts in the Eastern Cape. Transformation is a constitutional imperative, and it must be driven by Section 34 of the Constitution and the access to courts by communities. There has been a huge debate over the years regarding. I'm watching you on the screen. So the transformation of the courts in the Eastern Cape is required. Firstly, transformation is a constitutional imperative, consideration by cost efficiency 34 of the Constitution. Thirdly, access to courts, a proper administration of justice to the communities, and another consideration would be the closeness to the provincial legislature, because that is also something that should be taken into consideration. In rationalizing the courts, I think what needs to be paramount is the access. And one must bear in mind that the Eastern Cape Division covers a very vast jurisdictional area, and much of that jurisdictional area relates to poor rural areas. So it is paramount, as far as I'm concerned, that what's taken into consideration is the accessibility of the court. So in rationalizing, fortunately, it's not a decision that I need to make, Commissioner. I would hope that those factors are taken into consideration and not just historical issues.
Commissioners, JP Dalitse.
Thank you, Chief Justice, and good morning, Advocate.
Good morning,
colleague.
Commissioner.
Yes. I have gone through your documents that have been submitted, including the judgments that you have also attached,
Yes.
the analysis by the law bodies that have commented on your abilities and your achievements. And you come very highly recommended by these law bodies and other bodies that are involved here, which also include the council, the Bishop Society of Advocates. I wouldn't get in much in what has been said. I can even see that the Bishop Society of Advocates is so possessive that they say that they are convinced that if you are a fit and proper person to represent the profession on the judiciary, and that she will add value and decorum to the position of judge. This might create the impression that they are deploying you to represent their profession. And from what we've been saying today, what is there? You are there for the people of South Africa to serve the country and not to represent the legal profession in that area.
That is correct, Commissioner.
Thank you, Chief Justice.
Thank you, Commissioner.
DP Zwane?
Morning, Advocate Colette. I'm here.
Yes, Commissioner.
I've got just one question. It's regarding the objection arising from your participation in the disciplinary hearing on behalf of the Eastern Cape Department of Education. The objection seems to imply that upon your appointment, you won't be able to deal properly and impartially with issues involving the Department of Education of the Eastern Cape. What is your comment? The fact that you had acted for them, will that compromise your ability to, should you appoint, will that compromise your ability to judge cases objectively?
Yes, I understand the concern, Commissioner. The Education Department has not been my only client over the last 40 years of practice. I would be guided by the circumstances at the time, and I would be fully aware, and I am fully aware, that the oath of office that I swear is that I would dispense justice without fear or favor or prejudice. If there were circumstances under which litigants felt that I would not bring an impartial mind to bear, and they, on objective evidence, held that reasonable expectation of me not being able to dispense justice fairly, I would in those circumstances recuse myself. Obviously, the principles are adequately outlined in the President of South Africa versus SAFU, and I would act accordingly. But as I sit here right now, I can think of no reason whatsoever why, if an Education Department matter came before me, I would be conflicted, because the matters that I dealt with were time sensitive for that period of time.
Thank you, CJ.
Thank you, DP. Anyone else, commissioners? No. Okay. So just a couple of loose ends to tie up. You do confirm that you are financially stable, and we have no reason to worry about that.
Yes, I forgot to confirm that again, CJ. I am financially stable. It's when you are eventually having an empty nest, it also makes your life somewhat different. I'm no longer in the position that I was in those years in any respect whatsoever. So yes, I am financially stable, CJ.
You know that collegiality is critical in the judicial space. In fact, the Code of Judicial Conduct demands it.
Yes.
How have you fit in that diverse division during your acting stints?
It's interesting that you should say diverse division, CJ. My entire life has been about fitting into a society of diversity. So I can't imagine why there would be any apprehension of me fitting into a division with diverse people in it. I have had no reason to believe that I don't get on with anybody else in the division, or that there's any tension between me and anybody else in the division. I must say, Commissioner, it's very seldom that I find that people don't get on with me or I don't get on with them. So I wouldn't have any problem in that division. In fact, I've made a lot of friends in that division on the bench.
Through the years, you have been involved in a number of community outreach initiatives. Can you just pick one that you're more passionate about than the others, and tell us briefly, very briefly about it?
I don't think I can say I'm more passionate about one than the other. I'm passionate about everything that I do. I think Eastern Cape has talent is very close to my heart. It was a community outreach program that I started in King Williamstown to give a platform to all persons who wanted to come and demonstrate their creative and artistic performing abilities. I set about it as a fundraiser for the Alexander Playhouse, which is a historic Eastern Cape historic theatre in Kugompo, and it doesn't receive government funding. So I thought that I would develop this initiative as a twofold purpose. I kept the application fees low, and it's run purely on donations, and it has been a platform, an amazing platform, where people have been able to come at a very low cost of 50 Rand and come and demonstrate their talents, be seen, be creative, and it's open to all members of the public, regardless of age, regardless of gender, regardless of what their speciality is. And we've run it for 3 years now, and I managed to get a prize of 10,000 Rand donated for the winner. And for the past 3 years, we've had young people win from different schools in Kugompo, and they've been receivers of 10,000 Rand, and their careers have taken off just by the visibility and the giving back to the community. And it's such a feel-good project that it becomes so all-encompassing. I've even managed to persuade some of my colleagues and even members of the bench to be involved in this initiative and just be engulfed in something positive and beyond the bench in the interests of community outreach.
And lastly, we understand that you finally applied for silk, and that application was approved.
Yes, it was.
Is that so?
That is correct, CJ. I finally applied for silk. As I've said before, my practice never went along the normal silk trajectory. It was not something on my radar. I was more devoted to service-driven, professional advice and litigation. I was walking a completely different path to everybody else, doing what made me affirm my commitment to the profession, and it might not have been the same as anybody else's. And like I said yesterday, I'm very encouraged by the fact that there are new considerations when it comes to silk, because a career like mine will now be recognized at an earlier stage than perhaps mine has been. I was satisfied with having clients that were pleased with what I had done for them. That was enough status for me at that time, but I did later apply, and I have been awarded. So, well, the Silk Committee has approved it. It's on its way. It has gone to the AJP, or the AJP's office, and it takes its path from there. Yes.
Well done, Advocate Colette, and thank you for throwing your head in the ring and coming back here again this morning. You're excused.
Thank you, CJ. Thank you, commissioners.
Good morning, Professor Kruger.
Good morning, Chief Justice.
How are you?
Good, and you?
I'm fine, thanks. Shall we do this? Are you ready?
Let's do it. We've been waiting.
All right. You hold 3 academic qualifications from Potchefstroom University. Hold 3 academic qualifications from Potchefstroom University. BA with distinction, BA honors with distinction, and a certificate in labor law.
And an LLB.
And importantly, an LLB.
Yes.
That's where you got that from. And then you went on to do a postgrad diploma in higher education.
That is correct, yes.
What brought that on, if I may ask?
It was,
How did that come
at
about?
the time, it was about roughly, I would say, it started in 2001. It was a pilot project that was launched at it was at Rhodes University as a whole. But the idea was the fact that you have a qualification in a particular discipline doesn't mean that you're a teacher. So it was to upskill people in professional disciplines with the ability to teach, particularly at the tertiary level. And so I was part of the first group of people who participated in that qualification. And I mean, since then, I think many universities have set that as a requirement for their staff to teach at the tertiary level, yes.
All right. You also have a PhD?
Yes.
In what's your area of specialty?
I focused on discrimination law. I particularly looked at the implementation of the Equality Act in various equality courts at the magistrates court level. So it was quite a practical application of the law and particularly focused on complaints of racism. And I did the sort of fieldwork part of the work from, I would say, roughly 2006 to 2008. I visited the Cape Town court, magistrates court, sitting as an equality. No, I'm not telling the truth. I think it was the Blue Downs or the. It's a long time ago.
Yeah, that's what happens when you.
So I went around to equality courts, and I only found the Durban court to be really active.
Among the courses you teach or have taught is constitutional law and constitutional litigation.
Yes.
What else have you taught?
I'm teaching civil procedure at the moment. And I have taught customary law, but that was a very long time ago. I taught the law of life partnerships, which is family law. Taught law of persons a long time ago. But at the moment, my focus is on civil procedure and constitutional litigation.
You've written widely on constitutional and equality law. That seems to be your pet area.
Yes.
How many papers, conference papers?
I would have to consult my CV.
You mentioned 25.
Yes.
But you've also authored book chapters. You've written journal articles.
Yes.
On various subjects.
Yes.
But before your life as an academic, you were an attorney as well.
I was for a very short time. I think I set it out in my application.
Yes.
I was a student at the time of the big change in South Africa, and I was swept up, and I'm still there, in the promise of what law can bring positive change to our society. So that interaction between law and society, and how law sometimes pulls society and how society sometimes pulls law to transform or in a positive fashion, that really captured my imagination as a LLB student. And then I thought, okay, let me try this in practice, but I was very young. And then when an opportunity came available to pursue this in a more academic, systematic fashion, I thought, okay, let me become an academic and study the law and see that interaction between law and social change, because that's really at the nub of my motivation to go into academia, because that idea that the law that oppressed people was changed fundamentally to bring about a change in our society that promises a better life for all. And I have to say, I mean, 30 odd years down the track, it's 30 years from the 96 Constitution this year, I don't think we have seen all of those promises realized. And sometimes I wonder whether we pin too many hopes on law to bring about those fundamental changes in our society. But that's an academic discussion, which I think should also inform practice, to be honest.
Yeah. After you got your LLB, you did community service.
Yes.
Before the articles of clerkship.
That was part of my articles. That was my articles.
I see.
Yes.
All right. And you were a professional assistant for a brief period.
Very brief period, yeah.
That brief period is important. What kind of work were you exposed to?
Mainly
you
discovery.
did appear in court, I understand.
But it was mainly discovery, preparation for discovery that I did in that short period of time. But as a candidate attorney, I appeared in criminal court, and I did divorce cases and maintenance and things like that. But so that was sort of my appearing in court part.
So you became a lecturer in 2001, rose through the ranks, senior lecturer, then associate professor. Mm-hmm. Are you a full-time professor now?
No, I'm an associate professor.
I'm not even sure what that means.
I have been told that I should have applied. At our university, it's an ad hominem promotions process, and you have to apply for that process, and it's quite a rigorous process of vetting by your colleagues. And I intended to do it at the beginning of this year, and then at the time I was acting, and my papers were not in order for submission at the time. So I will, in due course, attend to that.
But you've been involved or held membership and even led a number of associations.
Yes.
You've been a member of the African Network of Constitutional Lawyers, mm-hmm. And a committee member of their teaching group steering committee since 2008.
I'm no longer holding that position.
Okay,
as the
that position
teacher.
you held between 2009 and 2012, you say?
Yes.
All right. But you are still a member of that network. And since 2019, you've been a member of the Berkeley Center on Comparative Equality and Anti-Discrimination
Yes.
Law. What is that about?
That is a network of lawyers around the world who are interested in discrimination or anti-discrimination law. And they bring out publications, they share information about the latest developments, what is happening in Europe, what is happening elsewhere in Africa, what is happening all over the world. And they send out a newsletter and opportunities for collaboration, and they host a conference ever so often. The one conference that I intended to attend was right in the middle of COVID, so it happened online. But it is a wonderful opportunity to network with people with similar research interests.
All right. And of course, you are a member of the South African Law Teachers Association.
Yes.
Member of the South African Society of Legal Historians between 2007 and 2009. Why did you leave them?
I probably didn't remember to pay my dues, to be honest. And obviously that doesn't preclude me from going back and looking what is the historical roots. And I have to say that is something that I find really interesting, is to see how the laws developed over time. And it also plays out in some of the judgments that I've actually produced. But I know that it's not an academic discussion. I know it's a very different discussion, but where it comes from really is important.
You were once a dean of the law faculty of
Yes.
university. You were a member of the South African Law Deans Association, I suppose, by virtue of that position.
Yes.
Okay, that was for 6 years.
Yes, I was the dean from July 2014 to August 2020.
And then Vice President of...
Yes, during that time that I was the Dean, yes.
All right. For 5 years.
Yes.
You have acted as a, well, before we get there, you were a commissioner of the Small Claims Court.
No, of the CCMA.
CCMA.
Yes.
Confusing you, the previous candidate. For how long?
From I actually could only complete the training in 2012. So it was 2012 to 2022. And it was, in terms of as a part-time commissioner, you have to commit a number of days per week. And it was sort of at that time that I was acting and I was unable to commit the number of days, not per week, per month. And I was unable to commit the days. So I thought to myself, it's unfair to try and keep something going while I'm actually not fully invested in it.
You have acted in the High Court?
Yes, since 2021.
And how many weeks have you totted up by now?
I have by today, as of today, 57.
And what kind of cases have you sat in during this period?
I have dealt with, I would imagine, most things. I have done a duty, so opposed motions and just motion court, unopposed motions. I've done 5 criminal trials, done 11 civil trials, done criminal appeals. I've had 2 unopposed applications that I actually had to hear and determine. Reviews from the Magistrates Court. I've done 6 bail appeals. I've done a review of taxation. I've done civil appeals, and I've also done an automatic appeal. And then the Mental Health Care Act assessed reviews of coming from the review board. I've also dealt with those.
And I would imagine you've had duty weeks in those things.
Yes,
which is when you are suddenly alone and you.
Yes. I've had duty I've had a 5-week stint at the beginning of this year, and I had 2 weeks of duty as part of that in Makanda, and I've also had duty at the other seats of the court.
Have you sat in all the seats of the division?
Yes.
All right. I'm going to hand over to... Oh, wait. You have been interviewed by this body before. I have been interviewed. How can I forget that?
In 2022.
In 2022, all right. And then you didn't really have any acting experience?
No. As I read, obviously, through my transcript, I realized that, I was very incredibly nervous, more so, not that I'm not nervous, but more so than I'm today. And to some extent, I'm thinking, it was 22 weeks and perhaps premature.
Yeah. I take it that you are confident now that you are up to the job.
I'm confident that I'm up to the job for the most part. And I am also well aware that this is not a lone journey. One hears counsel in a matter, and you take on board what they say. And in the Eastern Cape Division, I have found the collegiality of the judges absolutely incredible. People are always willing to hear an idea, to say, but have you considered that? It's really a conducive environment to do your work.
Okay, I'm going to ask the ADJP of your division to put questions to you, if she has any, that is.
Thank you, Chief Justice. Good morning, Professor.
Good morning.
Just following up from the Chief Justice's question, last one. Do you feel you have acquired sufficient experience and expertise in all areas of law as an acting judge, particularly, and also as an academic?
I think where I sort of questioned myself, particularly at the beginning, was in relation to procedural law. And as I've indicated now, I have taken on teaching procedural law. So and through my involvement or through my acting, and I've particularly appended, one of the judgments that I've appended to my application is one on procedural law. Because strangely, and not strangely, it's because of my interest in constitutional litigation, it resonates with me. It's something that I find really interesting, to look at a procedural point and really investigate, what is this all about? So I've written a judgment on Rule 28.2, and I think that demonstrates, hopefully, my ability to manage procedural points and procedural issues that may arise.
Thank you, Professor. Thank you, Chief Justice.
Thank you, Judge Dawood. Premier?
Thank you very much, CJ. Good morning, Prof.
Good morning.
What challenges does the Eastern Cape High Court face in your own experience?
I think we face challenges of efficiency sometimes, in the sense that perhaps caseload and efficiency going together, in the sense that we have, and it's particularly in what I saw in Makanda and in Mthatha, it is road accident fund matters and claims against the Minister of Police. And these routinely come before the court, and then the matter doesn't proceed. And then it may or may not be that for a whole week, there's not a single matter that proceeds. And the judge basically takes on a very administrative, sort of postponing. So I think there are ways and means, and I think with sufficient support, the electronic justice, the e-justice system that's being rolled out may alleviate some of that. But I do think at this point in time, for example, in Makanda, the last time that I was on duty, I accessed the records from home very sufficiently and adequately because my internet was fast enough. But I cannot do that in court because the Wi-Fi is not strong enough to support me accessing at the same time as what the practitioners are standing there. So then we revert to paper, which unfortunately increases the costs for litigants because someone has to carry that cost. So I think that is one of the challenges, and I think just generally also access to justice for the people in the Eastern Cape is a problem.
Thank you, Premier. JP Tlaletsi, followed by Commissioner Mangena, the Minister.
Thank you, CJ. Good morning.
Good morning.
Jeremiah. Yes, thank you. Just one question from your previous interview.
Yes.
Yeah, I think you may have seen it when you revised the transcript.
Yes.
It is mentioned at page 23, and I'm going to read it for you for convenience. The General Counsel of the Bar says that there is generally, they say they are not happy with how you conduct. Some practitioners are not happy with how you conduct trials. You seem to be, you stray from the facts presented, in fact, from the evidence presented, and you are easily distracted by irrelevant issues. What is your comment? And for completeness sake, you did respond at the time. And
yes.
You said that it is impossible for me to comment without a practical or concrete example. I'm not able to respond to that. I can simply say that I can't think from the top of my head. If there was an example given, I would have been able to respond, but I cannot respond in the abstract. Now, this is the situation that was placed before you and your response.
Yes.
Now, having had the opportunity to act further
yes.
and had more stints at the court, have you reflected on this aspect which was raised, and do you have something to say, and whether you identified something that you have even corrected, if there is such a thing that required any correction or improvement?
I have completed or dealt with multiple more civil trials in the meantime.
Yes.
And I think that it is, once again, it's quite difficult. And I saw the GCB made the same comment this time around. And I don't know whether it's a revision of the previous comments or just simply a repetition after, I would say, at least 6 more stints after that. I would think that my experience in subsequent trials have definitely benefited me and to focus. And I think in particular as a person who has not done this as a lifetime commitment,
Yes.
the idea of one being confined within the four corners of the pleadings is something to bear in mind. And I am very well aware of that. Yes. That a case is set out in the pleadings and a person must be the case set out in the pleading. And the court also is guided by that. And I try to align if I ask any questions or engagement with counsel within that framework. I think that is the best way in which I can answer it.
Yes, but also what we could learn from this is that as a judge, you are open to criticism, to advice. You don't become defensive if something is raised. You accept it and you see. Thank you. Thank you, CJ.
No,
thank you, JP. Commissioner Mangen.
Thank you, CJ, and good morning.
Good morning, Commissioner.
Professor. I need to ask you a question in relation to your judgment, KGA Life.
Yes.
Versus Multishow.
Yes.
You were part of the full court panel.
Yes.
That said to hear section 18(4)
yes.
automatic appeal.
Yes.
Section 18(4) sub 3 says that an automatic appeal should be heard as a matter of extreme urgency. And the order that was before you was made on the 21st of June 2022.
Yes.
But you heard the matter on the 7th of November 2022. Then you were the scribe.
Yes.
You handed down the judgment on the 14th of December 2022, which is a month later. Would you say that you have dealt with this matter as directed by section 18(4) sub 3 and dealt with it as a matter of extreme urgency?
I take your point. I think there is definitely something to be said for it to have been dealt with faster. Absolutely.
Yeah, but why wasn't it done? If you can just share with us, what was the difficulty? I cannot fault you with regard to it being set down.
Yes.
Maybe those were logistical problems, but because you were the scribe, one would have expected you to appreciate that the agency of the matter and make sure that at least the judgment is given within reasonable time.
As I cast my mind back, and it's very, I must apologize, I have to cast my mind back to that. I remember it was a full week of appeals. I cannot remember what the other appeals were, but initially I was not supposed to be the scribe on this matter. And then as matters unfolded, I was assigned the duty, but shortly after the hearing, I cannot fault my colleagues for any delays. And then thereafter, we circulated the judgment, there were comments, and we finalized it. I'm terribly sorry, I don't know what's going on. Take a sip of water.
Space yourself.
No, it's fine. So I cannot, with great certainty say what caused the delay, but I absolutely take it on board that the directive in the legislature, from the legislature, is to deal with it expediently.
Thank you, CJ.
Thank you, Commissioner. Minister?
Thank you very much, CJ. Good morning to you. Good morning, commissioners.
Good morning.
And good morning, Prof. Kruger.
Good morning, Commissioner.
My first question of Superior Courts or the CJ rolled out Court Online.
Yes.
And came live across the provinces and just to check from your side, how has been your experience and your affair with the system?
Yes, I think it was in August of last year, or shortly before I started acting in August of last year, there was a training session which I attended. And then the last week last year of 20, I think it's September, I was in Gqeberha on duty, and I had calls in a limited number of matters. I think there were 5 or 6 matters on court online, but then there were some teething problems. As I said, I think the system needs to be properly supported, and there needs to be buy-in from practitioners and the OCJ to support it properly. Because my understanding, and I mean, is that it works very well in Gauteng. Now, if it works very well in Gauteng, I cannot see why in the Eastern Cape, as it is currently, it is not working optimally. Because we end up receiving paper copies in addition to the material that is online. And as I said, that just adds to legal costs for litigants.
So from your experience as a person who's working, now I was asking your personal experience and whether this does help in terms of making sure that the work flow happens well and all that. That's what I was more looking at. But I think the feedback does help. As you say, other provinces, I think it has been rolled out across the country. I just wanted to understand, because it seems it's not where it's supposed to be in the Eastern Cape. No. So I wanted to hear that feedback.
Thank you.
Okay. Coming to my next question. In your thesis,
yes,
your doctoral studies, your research project was titled Racism and Law, Implementing the Right to Equality in Selected South African Equality Courts.
Yes.
And you touched a bit about it. One of the issues when we look at the Equality Court, we see the volumes are not at the level that one would have expected in a country of ours where there are issues. Tell me, in terms of what's your experience there, why do you think that majority of the people are not utilizing, especially in the context of access to justice?
I think it's awareness on the one hand, and then I think it's awareness from the normal, the man in the street, the so-called man in the street, woman in the street. They're not aware of the fact that there is a mechanism to address something, to address racism or to address any sort of unfair discrimination that one suffers if you want to access a service. I think that is part of the problem. And at the time when I conducted my work, research, there was a requirement that the presiding officers had to be trained. And whereas the legislation has subsequently changed and any presiding officer can hear it, I think the clerks of the court are pivotal in the potential success of these courts. Because I think there is clearly a problem in our society with unfair discrimination, harassment, and hate speech. And that legislation, when it was enacted in 2000, an MP commented during the process, this is the second most important piece of legislation apart from the Constitution. And we haven't seen that. We haven't seen that play out in practice. But it's a confluence of factors that play in. And I think the first being awareness, and the second being that when it comes to the clerk of the court, if the clerk is aware of what needs to happen, because the process is supposed to work like a domestic violence protection order. It's as simple as that. But unfortunately, it becomes a very complicated matter that's drawn out over months.
Thank you, CJ.
Thank you, Minister. Prof?
Yes.
Thank you, CJ. Good morning, Prof. Kruger.
Good morning, Commissioner.
I don't know you. We've never met, so I don't have anything to declare because we are in the same profession. Before I ask my question, in your view, is there a difference between judgment writing and academic writing?
There is a difference, but I think it is important to produce judgments that have a scholarly underpinning, that comes from a philosophical underpinning understanding of what the law is and what it ought to be in the light of the Constitution. But the process, I understand, if I may just divert for 3 seconds, that there was a judge in the Eastern Cape Division that said academics should only get as much time to write their commentary on judgments as judges have to write their judgments. Because I think you will know, one can look at a paragraph in a judgment as an academic and ponder it for weeks. Whereas the judge wrote that judgment in 3 months allocated. And one could pick on a word and as an academic and really analyze it. Whereas I think that the judicial role requires a different approach, but still underpinned by scholarly work.
Okay, thank you. Then take us through your process of judgment writing. What informs it?
Okay. It depends. If it is an application, I would obviously read the papers beforehand, make sure that I know that what I understand the parties, the issues to be, read the heads of argument, go through the cases that the parties have identified as relevant to the process, read those judgments, and make notes as I go along. And then my first notes I make with a pen and a paper. I prefer to do it that old-fashioned way, and I like to have my little markers. And then I read the judgments, I flag the relevant parts of the judgments, and then I go and take those issues and do my own independent work, research, checking all the databases, checking SAFLI, making sure, is there perhaps a newer judgment? Is there perhaps something else that is relevant that could feed into my understanding of the particular problem? And then I will start with headings. And then obviously I don't complete that before I've heard the parties, because you may think in one way or the other as you go into court, and then you are swayed by the argument. And then I also take extensive notes while I'm hearing a case, so that I can refer back to that and then bring together. And I think that's where the academic background benefits, to bring those things together in a cohesive. The arguments presented, the heads of argument, the case law, and the independent research, to bring that together, tie it into a whole that reads logically.
Thank you, Prof. Thank you.
Thank you.
Commissioner Trollip.
Thank you, Chief Justice. Good morning, Professor Kruger.
Good morning, Commissioner.
Judge Moseneke made a determination about rationalization of courts, and in the Eastern Cape, the determination was that the High Court should move from Makana to Bisho.
Yes.
It's been controversial, and there have been 4 initiatives to prevent that happening. What is your feeling about the relocation of the High Court from Makana to Bisho?
My feeling or my thoughts? Because I do think there's probably a disjunct between my feelings and my thoughts on this. I have lived in Makanda for more than 20 years. It's my home. It's got many issues, but it's my home. And I realize that apart from the university, the legal profession, that's the attorneys, the advocates, that's part of the economy of our town. But I also am quite sensitive to the idea that it's not necessarily about a town, it's about a community, it's about a provincial interest. In sort of on my own, I have thought to myself, I mean, obviously, we sit with the legacy of apartheid. That is, and colonialism. That's why we have the courts where we have the courts. And then I've thought, I mean, this is my own independent, not tied to any official reports. Perhaps to steer clear of any apartheid and colonial history, we should establish a court in Kugompo, because it doesn't have that baggage. It doesn't have colonial and apartheid baggage. The seat. But as I say, my feelings, Makanda is my home. But my thoughts, I realize access to justice require us to think beyond the interests of a single city, but to think about the province.
Thank you, CJ.
That is an honest answer. Please, want?
Morning, Professor Kruger.
Good morning.
I'm here. My question relates to the matter that you dealt with. It's the matter of Kaya Ntunja and the Minister of Police. And in particular relates, well, it's a matter that concerns the application for the condonation for the late filing of the consequential plea. Is that correct? You still remember that matter?
Oh, you're talking about which one?
It's the matter of Kaya Ntunja and versus the Minister of Police.
Yes.
It's a matter that concerns the condonation for the late filing of the consequential plea.
Yes.
You dismissed that application.
I did.
And you dismiss it with cost, including reasonable cost of traveling, accommodation, 2 days appearance, reservation, and the cost. Well, my concern is the cost that you granted relating to, well, the 2 days appearance reservation. Just for the application for condonation, I mean, it's something that normally would take at most 2 hours. Application for condonation, it's something that takes 2 hours. Why did you allow 2 days reservation? And the matter, it will seem, was just argued. It was just a 1 day matter, but you allow reservation costs.
It's not that long ago, but I must tell, it is that long ago. It's December 24. I would imagine that the parties, this is a long-standing matter that goes back to, I can't remember, 2018 or something like that. And the parties have, no, 2022. Okay, I'm making it more exciting than what it is. The parties have had, so the plaintiff has really struggled to get the matter off the ground. And I recall that at a previous occasion, but I stand to be corrected because it is some time ago, that the parties had agreed that the costs would be decided at some point. But as I say, the only reason that I could imagine that I would have made such an order was because it was set out and requested. I cannot think that I would have made a costs order completely independently of the argument and the notice of motion that served before me. I'm trying to think whether the 6th of December, no, I cannot recall what date it was, and whether this was a matter that rolled to the next day because of it being last on the roll. I'm going to mislead you if I'm trying to answer that with great particularity. I'm sorry.
Yeah, you are dealing with cost at paragraph 55 of that judgment. You say there is no reason why cost in this application should not follow suit. But you do not explain why you granted reservation costs, because reservation cost is something else. It's not something that you ordinarily grant. And more especially for such a matter, application for condonation, which is 1 hour.
Absolutely, absolutely. But the truth be told, then the gap in the judgment is clearly that I did not address the award of costs appropriately.
All right.
Thank you, TP. Commissioner Poso.
Thank you, Chief Justice.
Good morning, Commissioner.
Good morning, Professor Kruger. Are you aware that there is an anti-sexual harassment policy?
Yes.
Have you acquainted yourself with the policy?
I've read the policy with great interest. Yes.
Have you, having read it with great interest, have you been able to make some input for the Office of the Chief Justice?
I have not. What I found quite interesting is that it places an obligation on any person in the judiciary, in the system, who thinks that they observe harassment taking place to make a complaint, which I think is not necessarily something that one sees in every sexual harassment policy. But I think it is a positive development for the judiciary and a positive development in any workplace to have such policies in place to protect vulnerable people. And not only vulnerable people, also empowered people, because there's a stigma, there's still a stigma around sexual harassment in particular. And a policy like that empowers victims.
You did not, however, see that it required any improvement, that it needed the filling of any loopholes in the policy?
I think, like with any policy, one would have to see its implementation in the first instance and then revisit to determine. I recall at the university we had a sexual harassment policy which required revision and refinement as we went through different iterations. But I think it is a very good position to start off. And as an academic interest, I will definitely have a look at it again. I had a student 2 years ago who completed a master's on harassment, not only sexual harassment, but harassment and the link with unfair discrimination. So I think in collaboration with that student, we can have a look at the policy and perhaps see what comments one could make for consideration by the Chief Justice's office.
Thank you, Professor Kruger. I'm sure the Chief Justice would welcome those inputs.
Thank you.
Thank you, Commissioner Foster. Commissioner Jivan?
Thank you, Chief Justice. Professor, one of the cases you've added to your list that you've given us is Arnaldus, Abraham, Terblanche, and the state.
Yes.
I think it's your second case. You partly granted the applicant's request.
Yes.
For further particulars. And you said, yes, he's granted some of it, but not all of it.
Mm-hmm.
There's no order as to cost. Any reason why there's no order of costs in favor of the applicant?
I think what I found was that cost orders are not ordinarily granted in these matters. Because because the state is the opposing party, and from what I recall is that a costs order is not ordinarily granted in these type of applications for further particulars in terms of the Criminal Procedure Act.
That's the practice of the division, perhaps.
I'm not entirely sure, but it was also not a point that was particularly argued.
Thank you.
Just one last aspect, Professor. As you would be aware, the law bodies who have sent in comments on the candidates generally support yours. And that includes the GCB, which does, however, raise an issue of concern. They say, despite your extensive academic experience, your appointment might send a message that it's not a priority to appoint candidates with practical litigation experience that is necessary to ensure efficient and effective case flow management. Would you like to comment on this?
I think that it is not necessarily the case that someone in my position would not be able to ensure efficient case flow management. I have had experience while in these 57 weeks that I've acted dealing with case flow management. And I think case flow management is one of the ways in which we can deal with efficiencies and inefficiencies in the system. And I'm confident that I could do that. I think the signaling of a priority also perhaps misplaces the idea that the criteria does not necessarily require practical experience, nor does the Constitution. So I would imagine that if someone has demonstrated their ability to do what is required, I think the question is whether that is an appropriate fit for the division at this particular point in time. And my candidacy is simply to make myself available and for the Commission to determine what is in the interest of the Eastern Cape Division of the High Court.
Have you had any difficulties presiding in the motion and civil courts?
I haven't experienced difficulties in the motion court. In the motion court, as you know, it's fast-paced and you have to be well prepared. And I think that is something that I have demonstrated, and the GCB comments on that, is that I am well prepared. I make sure that if there is something that is of, and I think that's the academic background, to be able to know where to look. So I find the answer, I make my notes, I try to ensure that the court runs as smoothly as possible. And I haven't experienced that as a challenge simply because I don't have practical experience.
Thank you, Professor. Thank you for making yourself available for these vacancies.
Thank you very much.
I don't know if there's anything you want to raise with us.
No, thank you. Okay. Thank you very much.
You're excused.
Thank you for the opportunity and all the best for the long day ahead.
Thank you. We do need it. Moloni, did I pronounce your name correctly? Please switch your mic on. Oh, there you go. How are you?
That's very loud. I'm very well, thank you. How are you?
I'm fine, thanks. Just relax. It will be fine. You're an advocate, practicing advocate.
Correct.
Since 2003.
I haven't been in practice the entire time. You would have seen from my CV and the application form.
You did take a holiday at some stage.
I took a working holiday, yes, for approximately a year. And then I also was an acting magistrate for, I think, between 3.5 to 4 years. In between. But since 2013, I have been in full-time practice.
All right. What did you do during that working holiday?
I worked in London for a maternity wear company, selling products online It was certainly something different for me. And then I worked for Deloitte as it's called a file builder position, but it was basically a data entry position. Unfortunately, law degrees don't seem to travel very well. So those were about the only jobs I could get without doing some kind of conversion.
Still valuable experience, especially the first one, selling maternity wear online, I would imagine. You studied BA and LLB at Rhodes.
Correct.
And you were on the Dean's list for academic merit.
Yes.
Was that just for the LLB?
It was in 2001 and 2002, if memory serves, so yes.
Right. So you've practiced as an advocate in the Eastern Cape.
Correct, yes.
Since 2003, but the short break to date.
Yes.
What kind of work have you been doing?
Well, perhaps what I said is not entirely correct. I did take a year off from September 2023 to July 2024 to have cancer treatment. So it was not without break from 2013. But prior to that break, because I have acted more than practiced since 2024, I did a smattering of criminal work. I did predominantly civil work in the realm of medical negligence, administrative law, the odd road accident fund matter, quite a chunk of family law at one point. It really was a general practice, so to speak.
And you acted as a magistrate for about 4 years?
Almost 4 years, I think, yes, give or take.
In the district court?
Pardon?
In the district court, of course.
Yes, in the district court.
What kind of cases did you adjudicate?
I did civil trials, criminal court, maintenance court, domestic violence court, traffic court. What else? Yes, at a certain point, the Child Justice Act required those preliminary inquiries that have to happen in regard to child offenders or alleged child offenders. So I did quite a few of those. And the children's court as well.
Did you get to write any judgments during these acting stints?
I did. I won't say many were written as opposed to extempore. The volume is large, probably not as large as other divisions, but to us it was large. So especially for the criminal work, most of the judgments were extempore. The civil matters, if they did not settle, if they ran, I wrote judgments.
You have acted as a judge.
Correct.
On 14 different occasions. Since when?
Pardon?
Since when have you acted as a judge?
You mean when did I start?
Yes.
In 2017, I think.
Mm-hmm. And how long would you total up the entire acting stints to date?
I attempted to do a calculation. I came up with roughly 64 weeks. I think it's probably, or will by the end of June, be closer to 70. But I have excluded weeks during the vacation, which were utilized to finish part-heard matters.
And that's a long time. I would imagine that you sat in all the cases, done motions, opposed and unopposed.
Correct, yes.
Criminal court, trials,
yes,
and appeals.
Yes.
Civil trials and appeals.
Correct, yes.
Special reviews.
Yes.
All right. appeals you've done. Okay. Have you written any judgments?
Have I, sorry?
Written any judgments as an acting judge?
Yes. Yes, I have.
How many?
When I submitted my application, I believe it was about 70. A recent calculation showed it to be around 90. There are a few that I'm sure I've forgotten, but that includes excludes ex-tempore judgments.
Your questionnaire lists 71.
Oh, well then, 71.
Are any of them reported?
No, none of them are reported.
Not yet. All right. Any reserve judgments? You listed 6 in your questionnaire.
Yes, I did. Those have all been delivered.
All of them?
Yes.
All right.
I currently have about 6 from this past term, one of which is an application for leave to appeal, I believe, from one of the judgments on the list. Yes, but that is the current situation.
How is your state of health?
Sorry?
How is your state of health?
My state of health?
Uh-huh.
I'm pleased to say it's very good at the moment.
Good to hear.
My scans have all been clear. I've graduated to 6 monthly checkups as opposed to 3 monthly. So yes, everything looks good so far. Started attempting to exercise and eat more healthily. Not always easy when you're traveling a lot.
Yes.
But yes, that is my situation currently.
You have not struggled with the workload at the High Court during your acting stints, have you?
No, I don't believe so. I find it, what's the word? Invigorating, I suppose, to be busy all the time. And perhaps my over-eagerness to help occasionally leads to one too many reserved judgments. I will confess that. But I've thoroughly enjoyed it.
All right, I'll hand over to Acting Deputy Judge President Dawood.
Thank you.
Good questions to you. ADJP.
Thank you, Chief Justice. Good morning, Advocate.
Morning.
Just one question. How long on average does it take you to pen your judgment?
I tried to do a calculation, obviously only since about 2023. I didn't go as far back as 2017 because I don't think I have that information anymore. It varies between the same day, the following day, a few days later. I think the longest has been about 5 months, but I attempted to draw an average to see on average how long, and the majority are within 3 months.
Thank you.
Premium.
Thank you, CJ. Good morning, Ms. Maloney.
Morning.
Assuming that there should be challenges in the Eastern Cape High Court space, from where you are, what could be those challenges, and what do you think will be some challenges that you can help in resolving, and what value would you be able to add in the Eastern Cape Division?
Well, I don't have experience directly in terms of court administration. As an acting judge, you don't really form part of that. We aren't included in the beginning of term meetings, so you don't really know what's going on. But in terms of the value I could add, I am always there and I'm always available if needed to do the work if there is a gap. And I've managed to fill a few gaps last year for that reason. I do think I bring practical experience. To the extent that you asked me about court space, I do believe we need more courtrooms. That would certainly be helpful. It does prove to be a limiting factor on occasion. I think the registrar's staff, and I know this doesn't fall under the auspices of the judiciary in terms of funding, or I'm not sure. I think they need more staffing. I think they need more assistance. And I do, while I'm on a small tangent, believe bodies like legal aid require far more funding as well. But obviously not my decision to make.
Thank you, Premier. Anyone else, Commissioners? Commissioner Trollip?
Thank you, Chief Justice. Advocate Maloney, you live in Makanda, so I'm sure you're aware that there is some controversy and defensiveness around the Moseneke Commission recommendation around rationalization and moving the High Court to Bishop. What is your opinion on this controversial matter?
My opinion is probably informed a lot by my feelings. I am born and raised in Makanda. So save for my small working holiday in London, I've essentially lived there for 46 years. The economic impact on Makanda, and I don't know if that's disputed or not, I don't think it is, will be horrific. And obviously, to the extent that we have a significant previously disadvantaged community within Makanda as well, they would be significantly disadvantaged. I believe, and I speak according to what I see in the media, so I don't have any specific amounts that are verifiable, but I believe it would lead to about 5,000 job losses, and that in order to prepare the Bishu Court for its role as the seat, I think would require in the realm of about 310 million rand. And of course, offices like the Master's Office and the National Public Prosecutor's Office would need to move as well, I believe. So I think in principle, yes, I can understand why it's important. Obviously, I haven't lived the experience of other people. I can understand that it is important, and maybe I don't understand how important because I can't. But if there was a way to do it simply without having to disadvantage an existing community that is already hanging on by a thread because our municipality is not exactly doing us any favors at the moment. I apologize to them in advance for that, but it's true. So yes, I will and always will be loyal to Makanda, and I believe that the seat should remain there. If it has to move, of course, I don't know necessarily that all of the consequences have been considered in terms of actual cost, but also the practitioners who appear in Bishu, most of them live in East London, or Makanda, or Port Elizabeth. So there will be, I believe, a concomitant increase in travelling costs for legal representation, which may not have been readily foreseen. So, yes, those are my thoughts on the matter.
Thank you, Chief Justice.
Thank you, Commissioner Trollip. Commissioner Mangena, Prof, Commissioner Matolo, and Minister.
Thank you, CJ. Good morning.
Good morning.
You're not Professor.
No, I'm not a prof.
Advocate Maloney.
Yes, thank you.
Yes. Just one comment that you should make in relation to what the BLA says. The GCB says they are happy with your understanding and knowledge of the law and how you apply principles. So is AFT, so is LSSA. NADEL supports you as well. Giving credible assessment, but they're saying that they don't support your candidature.
Correct, yes.
The one that I want you to comment on is the comment by the BLA where they say that it's difficult for them to assess you on the basis of the cases that you have submitted. It appears they've got a difficulty in accessing your judgments, either on SAFLI and or on case law. And I heard you saying that you have written close to 90 or so judgments. Any comment on that?
I did. I read the comment, and I did a search on Jutastat online yesterday to see how many of my own judgments I could find. I found over 20, all of them unreported. I know there are a few on SAFLI, but I can't, for some reason SAFLI was not being helpful yesterday and wouldn't let me in. But I do know that there are a few on SAFLI. So I'm not entirely sure where that view could have come from.
Fair enough. Can I now ask my question?
All right.
One.
Okay.
You wrote a judgment on Ntebe.
Correct.
You remember that one? It was on
2017, I think.
2017, yes. It was on a rescission of judgment.
Correct, yes.
Or an appeal on a refusal to rescind a judgment arising from the magistrate's court.
Yes.
I've got no problem with the way you, or the outcome of that judgment, but I've got slight problem with the manner in which it was reasoned. It appears you dismissed the appeal on the basis that the affidavit was deposed to by the attorney,
Yes.
who, according to you, was raising technical points and not dealing with the factual points as to what happened.
Yes.
According to you, is it wrong for an attorney who is steeped in the matter to depose to an affidavit?
No, not necessarily. It often happens in interlocutory matters, particularly where condonation is sought for something. The attorney who is steeped in it will know perhaps better than the client. But every single matter I've ever seen of that nature has at least had a confirmatory affidavit from the client. This particular matter was an appeal against a refusal to rescind a judgment. So it was, I think, more than your run-of-the-mill condonation. And obviously the practice rules in the Eastern Cape say that attorneys who are appearing should not depose to an affidavit unless it's purely of a, I think, technical or practical nature. So it's not something that's encouraged, put it that way. But what concerned me at the time about that affidavit in particular was that point, but there were other factors, including that it was essentially and quite obviously a pro forma that he'd used. And filled in other details. And there were a significant number of exactly the same applications for a number of other plaintiffs, or sorry, rather defendants. And it was all very cookie cutter, and some had the incorrect facts because they'd cut and paste from someone else's. So it wasn't a situation where things were set out properly or where the affidavit itself was prepared carefully and in regard to the matter. And what was most concerning is that there was absolutely nothing in the file, if I remember correctly, it was a while ago, to confirm that the applicant in fact knew it was happening.
Thank you. Thank you, CJ. We are limited in terms of time, yes.
Yeah. Prof?
Thank you, CJ. Good morning, Advocate Moloni.
Good morning.
Oh, excuse me. Just flowing from Commissioner Mangena's question, please take us to your process of judgment writing. What informs it?
It depends on the matter, obviously. With a civil trial, for example, you go through the file, you familiarize yourself with the pleadings, determine what's in dispute, make sure that all the papers that need to be there are there. Occasionally something's missing and it's on a shelf in the registrar's office and you have to ask them to retrieve it. You make sure there is a Rule 37 minute of some kind so that you can verify what is in dispute and what isn't, because obviously that will lend itself to expeditiously finalizing the matter. And then obviously once I've identified what the law is in regard to what is in dispute between the parties, I will go to the rules, I will make sure that I remember everything that's important, and then do research. And obviously I form a prima facie view, but then you go into court and you hear the evidence. Obviously with a civil matter, you don't really know much until you've heard the evidence. With an application, a similar set of circumstances, except everything is on paper, so you already know what everyone's argument is going to be in essence, although during oral argument it is often, certain points are abandoned. And again, some heads of argument are missing, perhaps you have to go and hunt them down. But yes, you read through everything, familiarize yourself with the relevant law involved, etc. But with commercial matters in particular, I do find them a bit fascinating. I do a mind map of where all the companies fit into each other, because I always find that to be a very interesting exercise, but it also allows my brain to connect the dots when there is a complex matter happening. Once the matter is over, with a criminal matter, obviously you want to deliver judgment the day after closing argument. That's non-negotiable unless agreed otherwise. And so you will, in the evenings, perhaps summarize the evidence of the day and have it there in typed form so that when it's all over, you can edit as necessary, and you have the entire picture before you. So the thought process perhaps won't be as lengthy as it would be otherwise. But yes, aside from that, I have to do my best to make sure I'm up to date on the law involved, preferably before we go into court, which I try very hard to do. And then judgments are a structured exercise, introduction, middle, end, analyze the relevant law, apply it to the facts, etc. Thank you.
Thank you, that was interesting. Thank you, CJ.
Thank you, Minister.
Thank you very much, CJ. Good, is it still morning? Yes, good morning, Advocate Malani.
Good morning, Minister.
I'd like to take you to page 23 of your questionnaire. Just to get clarity, I see here on B, you are saying that you have been appointed as a prosecutor in terms of matters, whether it's, well, is this within the university dealing with gender-based violence itself, or is this within the courts? Because when I looked at your record, I couldn't find you listed as a prosecutor. But when I read this, and also in the manner that it's written, maybe if you can clarify that for me.
Yes. I've only ever been a prosecutor in domestic tribunals. So yes, for Rhodes University on occasion.
Mic closer to you. I can't
Apologies.
hear.
I've always only been a prosecutor in domestic tribunals. It's been for Rhodes University. There were one or two school matters. There was one matter, I believe, for two matters for the bar. Yes, that's been the extent of my involvement. I did have high hopes once upon a time of working for the National Prosecuting Authority. That was many years ago, though, and my attempts were unsuccessful. So yes, that is the only capacity in which I have been a prosecutor.
Just wanted that clarity. Can I ask the question? Okay, thanks. It was, they are laughing. I'm not abusing my apologies. It's just that I picked it up, so I was worried about the correlation with the. My question relates still with the issues of sexual violence, Advocate Melanie. As we know, all of us in the country, we're battling with the high levels of gender-based violence and femicide. And quite a lot of work continues to be done, but despite that, we still see more incidences, but again, the outcry in terms of prosecution, that we don't see high levels of success in terms of convictions. In your view, having worked in this area for some time, what do you think are measures that still need to be done, or where are we getting it wrong from your perspective as a practitioner?
I think that, obviously this is an offence which affects women predominantly, but not only women. But those who have been affected in that way, whether you want to call them victims, survivors, complainants, I do believe need to be empowered to not be afraid to speak up, because a very significant part of the problem, as I understand it, is that it's underreported, because it is such a personal violation, and people are generally ashamed, whether it's their fault or not. We need to take away that shame, and I'm not entirely sure how we're going to do it, but we do need to be more open about issues of that nature, which is why I'm going on a little segue here, but why I was so impressed with the public initiatives for sanitary pads for schoolgirls. Most people are terrified to speak about that in public, but girls were staying at home because they didn't have access to those sorts of products and didn't want to risk, obviously, being shown to be bleeding at school. And we can't be afraid to talk about that. We can't be afraid to talk about sexual offences. We can't be afraid to talk about the words involved. In the Eastern Cape in particular, there was a time when there was a shortage of rape kits. So there weren't, in fact, enough to do the necessary. I don't know yet if that's been remedied, but obviously, as with a lot of things, funding is an issue. I believe there is an extensive backlog within the relevant laboratories in terms of DNA evidence. Obviously, funding and more capacity would be very beneficial. I hope that answers your question.
Thank you. I don't want to abuse CJ. JB?
Thank you, CJ. Good morning.
Good morning.
Good morning. Just one question. In your legal career, have you had an opportunity to deal with matters relating to customary law and or indigenous traditional issues in the Eastern Cape? And what is your view regarding the roles that such systems should play in our society? What would the source of such systems be? And given the demographic of the Eastern Cape and the country as a whole?
In terms of the first part of your question, my own personal exposure to customary law has not been extensive, but I have been involved in one or two matters where the legitimacy of a customary union has been in dispute. This was, I think, pre-legislative amendment in terms of the Recognition of Customary Marriages Act. And so you would have a situation where perhaps a man would be civilly married to one woman in one province, but then have a customary marriage in another province, would pass away, and then things would get complicated in terms of the estate and obviously the requirements of intestate succession and how that would devolve. So that has been my exposure to it. Usually you end up going to oral evidence, to find out whether the necessary has occurred. I'm not going to pretend that I have intimate knowledge of what the customary requirements are, but I'm certainly interested to learn about them whenever I do come across them. There have also been, it being the Eastern Cape, the issue of burial is often in dispute, and the customs surrounding it and how they need to be respected and maintained. They often, from my own personal perspective, in such matters seems to be disagreement as to what the deceased's last requirements were or what their dying wish was in terms of where they were to be buried. So that is often disputes of fact more than anything else. The role it can play, it is recognized in the Constitution as a system of law that is followed and respected by many people. There is legislation governing traditional leadership. And the best I can do to summarize it is what I was taught by Professor Nkeke at Rhodes University a very long time ago, which is the customary law and the Constitution run parallel. But when there's a conflict, the Constitution always wins, because it's the Supreme Court of the land. So to the extent that customary law is constitutionally compliant or capable of interpretation that allows it to be constitutionally compliant, then it is an active area of our law. And I do think it gives credibility for people who, I've perhaps said this incorrectly, but there are many out there, particularly in rural communities, who respect customary law, customs, traditions. And so it does give them a form of dispute resolution which is recognized and credible by the rest of us, essentially. I don't know if that answers.
Yeah, in cases where you say you had a dispute of facts, how do you resolve those disputes of facts? Do you import now civil law into those disputes to resolve them?
Depends on the matter. Sometimes you refer to oral evidence, and so then it becomes a, I suppose, credibility issue and the manner in which people testify. Or it can be referred to trial, depending on how extensive the dispute is. As far as I know, in application proceedings, there's no reason not to apply the Plascon-Evans rule if necessary. But I speak subject to correction. There may be something I'm not aware of there. I haven't had a lot of exposure to customary law.
Thank you. Let's leave it there. Thank you, CJ.
Thank you, CJ. Good morning, Advocate Maloney.
Good morning.
I'm looking at your practice as an advocate and your role in the profession. I don't see much, but I just wanted you to maybe share with us whether, as an advocate, have you ever played a role in empowerment and transformation initiatives of the young Black female advocates, or, or what role did you play?
My response to that is actually going to be informed a lot with a conversation I had with one of my previous pupils yesterday. I've had 2 Black male pupils, and he said to me, transformation is as much about opportunity as anything else, and reminded me, because I do things without thinking sometimes, or getting them sometimes, that in many of the internal disciplinary matters for Rhodes University, there will be young Black women who are law students, who come along, who get to see the law in action in a trial context, a slightly informal setting, but not quite a trial, but a disciplinary tribunal. And so can see how leading a witness, cross-examining a witness, submitting evidence actually works. And there have been a few of those. I know that I've encountered a few students that I've lectured in the past who have gone on to become legal practitioners. But I think primarily my contribution is a bit like my personality. I'm very quiet and I stand apart from the rest. And so it's little acts over a lengthy period of time that I hope have helped people, particularly Black women. Unfortunately, I think we only have 2 at the moment at the Makanda Bar. We have had more. Sometimes they move on to larger centres. But yes, it's something we need to work on. Not sure if that answers.
Commissioner Muiman.
Thank you, CJ. Good morning, Advocate Malone.
Good morning.
Just one from my side in relation to one of the judgments that you have attached, Kula versus the Ministry of Education. In particular, the detailed structural interdict that you gave. Amongst them, the judgment, the interdict talks about communicating the decision within the prescribed time scales, providing individualized reasons for refusal, and then catch-up plans for students or learners that might have missed schools due to lack of school transport. This detailed structural interdict, is it not a way of the court descending into the arena of what rightfully belongs to the executive? Is this not overreach because the department, the issues around the budget, whether the government or the department can afford, particularly when they raise issues around budgetary constraint, is it purely a matter that falls within the executive? Is that not the court overplaying its hand, blaring the separation of powers?
Stepping over the line in the separation of powers.
Yes.
It was one of the arguments raised, yes. But ultimately, all that the applicants were asking was that the department do what it had already undertaken in its own policy to do. And the only reason it wasn't doing it were budgetary constraints, which were raised, but not in any way that was meaningful or helpful in terms of deciding the matter. There was also the fact that several years previously, the South African Human Rights Commission had done a report on the matter. And there had been another similar application that served before Judge Plaskett, who later became Justice Plaskett, wherein they sought similar relief, but he limited them to the specific schools that were listed amongst the applicants. So he did grant the relief. On this particular occasion, they once again raised the same issue as they had before Mr. Justice Plaskett, which was, we have a policy, but we need to revisit it. But we don't know when we're going to do it. We don't know when it will be ready. Essentially, it was a brush off. So I think under the circumstances, given that we're dealing with children who have a right to education, that's the role of the court, is to say to, or is to oversee and say, you've undertaken to do this, please do it.
Thank you, Advocate. Thank you, CJ.
Commissioner Post.
Thank you, CJ. Good morning, Advocate Maloney.
Good morning, Commissioner.
Yes. AFT is concerned that although you seem to subscribe to issues concerning gender-based violence, socio-economic rights litigation, you do not in your questionnaire employ explicit transformative language, and you also don't claim membership in any of the legal transformation organizations, and they are concerned that this would hinder you in understanding systemic judicial transformation. What do you say to that?
I don't think it would hinder me at all. I am yes, I haven't joined any initiatives. Had a lot to do in the early years with trying to earn a living, as opposed to, I suppose, utilizing time according to other initiatives. I know that sounds selfish, but one has to feed one's children occasionally. I like to be as independent-minded as possible. I don't want to be beholden to any particular groups with any particular views. And I think that, in fact, uniquely qualifies me.
Then I will proceed to ask the usual question that I have asked every other candidate. Are you aware that there is the anti-sexual harassment policy?
Yes, I am.
Have you acquainted yourself with it?
I have.
You have. And do you think that it is implementable in its current form?
I do. It is a very comprehensive and clearly drafted and obviously well-researched document. It covered every aspect that I could think should be included. It is broad, and I'm assuming intentionally so, because there are going to be various efforts made to promote understanding of what is in fact available in that regard. So I'm assuming there will be posters on walls simplifying the procedure, because it is a 25-page document, and so your average person who isn't used to reading as many documents as the lawyers do won't necessarily be able to understand what they're supposed to be doing in a particular circumstance. But yes, I do think it's a very good document. I think obviously there needs to be some implementation over time to see what happens and how it works. It does set some very stringent timelines. Complainants are required to be, particularly if it's a formal complaint, I think, required to be responded to within 3 days. And I'm really hoping that that is something that is stuck to, because it is important that victims of sexual harassment, sexual violence, do receive that acknowledgement and support. Otherwise, obviously, the whole system loses its credibility. If I had to add anything to it, the only thing I would say, and this only occurred to me very recently, purely from having seen similar policies in other institutions, is that relationships between persons in position of power versus subordinate employees are discouraged, and that's fine. But I would suggest consideration of, if there is in fact a serious consensual relationship between two such people, that it be declared for record purposes. If it may have been in there, I may have missed that, but I just looked at it and suddenly thought to myself that might be helpful.
Thank you. Thank you.
Commissioner Jibran?
Thank you, Chief Justice. In Advocate Maloney, in the case of Atwealth, Pty Limited and others versus Koenig, which you were taken on appeal and successfully overturned your judgment, it appears that, do you think that you have it seems that you are lacking in financial assessments of situations, perhaps Would you like to comment on that? That's what the judgment clearly said. It was taken to the Supreme Court of Appeal.
My understanding of the Supreme Court of Appeal's decision was that I placed emphasis on a factual aspect as opposed to another one which was more significant. So it was that form of misdirection. Could I have lacked some commercial knowledge? Possibly. It was written in 2017. And obviously I've come a long way since then. So I do sincerely doubt I would make a similar mistake. But having said that, it is one of the few matters where I granted leave to appeal because I thought another court may well come to a different conclusion. And it did.
Thank you.
Commissioner Nkonyan?
Thank you, CJ, and good morning, Advocate Maloney.
Good morning.
In response to Commissioner Baleti initially about your knowledge of customary law, I was impressed by your honesty and your willingness to learn in this field. But I picked up one thing that perhaps may empower you and other people that have actually addressed us on this question. By referring to our customary marriages as unions. I know some academic writers also do the same, so I cannot fault you on that. But I want just to indicate that it's a term that does not sit well with some of us, which remind us of the past, particularly of women that are married in terms of customary law, as opposed to those that are married in civil law. Find that our wives are actually referred to as concubines unions. Just want to give you that advice. I don't seek any response to that because we are honest.
Thank you, I appreciate that.
Thank you, CJ.
Thank you, Commissioner. Anyone I'm forgetting? Right. Just one last question from me. The BLA and NADEL have raised concern about your state of readiness for this job. And the NADEL says, while you show clear potential and professional merit, it is recommended that your appointment not be supported at this stage, pending the accumulation of further judicial experience and demonstrable jurisprudential output. Would you wish to respond to this recommendation?
I accept that more experience is always a good thing, Chief Justice. You always learn something new every single time. They didn't provide me with any concrete information to underpin their concern. I also can't really say that that is necessarily what would come if I went back into practice now. Essentially, I closed my practice to some extent in 2023. I went through a year of treatment that I would not wish on my worst enemy, and then gradually started, but then tried to start again, but then was lucky enough to be asked to act and have essentially been acting for the majority of time since then. So whether or not I would ever get that experience, I don't know. But I don't consider myself, given the amount of time that I've been an advocate and what I've been exposed to, whether it's through being a junior or not, I don't consider myself unready for that purpose, or for this purpose, for that reason.
So you have no practice, so to speak?
I have the odd bit of work. Rhodes University is always very supportive. And so when I'm not acting, I do some work for them. But by and large, no. I'd have to restart.
All right. It does not appear that there are any further questions for you.
Thank you.
Thank you for applying for this position, and I wish you all the best. You're excused.
Thank you, Chief Justice. Thank you for having me.
Commissioners, I propose that we do one more and then take the tea adjournment. Good morning, Professor Ntlama Makanya.
Good morning, Chief Justice, and also to the commissioners.
How does it feel to sit at the other end of the
Good
table?
morning, Chief Justice, and also to the commissioners.
How does it feel to sit at the other end of the table?
I have stomach cramps.
That's good to hear. Poetic justice. I remember how hard it used to be on candidates sitting right there. It's good to see you. How are you?
I'm fine, Chief Justice. Thank you very much.
Good.
And you?
I'm fine, thanks.
Thanks.
All right. Are you ready?
Yes, I'm ready, Sir.
Okay. You have a string of academic qualifications. A BUris, an LLB, an LLM, and an LLD, and several certificates on subjects varying from comparative human rights to competence in preaching and evangelism and Bible studies.
That is correct, Chief Justice.
Where did you obtain each of these qualifications? I struggled to tie them to the various institutions you list.
The BUris and the LLB are from Forte. The Masters and the Certificate in Comparative Human Rights are from Stellenbosch. And the LLD from UNISA. Plus the Assessment Certificate in 2011.
Yes.
From UNISA. And the other one as well on competence in preaching from TEC. And then the one on evangelism from the Education Ministry of the Methodist Church.
Okay. You have always worked as an academic.
Yes, that is correct, Chief Justice.
Since 2002.
That is correct, Chief Justice.
Okay. Can you just take us through where you've been, just quickly?
As an academic, Chief Justice?
As an academic.
Okay. Thank you very much. I started as a junior academic at the University of Forte in 2002, and I was immediately promoted to the lecturer position. And whilst I was at Forte as well, I coordinated the outreach programs at the Oliver Tambo, UNESCO Oliver Tambo Chair of Human Rights. Then after 3 years, I left Forte for the Human Rights Commission, where I stayed for 2 years. But I left after 2 years for UNISA. I stayed for 5 years. After UNISA, then I left for UKZN. I stayed for 5 years. Then I rejoined Forte in 2018. And I must express that at UNISA and UKZN, I was promoted to an associate professor position. Then when I rejoined Forte, I was appointed at full professor position. Thank you, Chief Justice.
All right. And you are currently a senior professor of public law at Forte.
That is correct, Chief Justice. After I delivered my inaugural lecture.
You are also an established C3 rated researcher that was awarded by the National Research Foundation in 2022 already. Can you explain what that means, what that is?
That is correct, Chief Justice. NRF, which is the National Research Fund, I applied when I was nominated by the university. Then what does it happen that I have to provide all the necessary information relating to my experience as an academic. Then what I do is to provide the possible 6 reviewers. Then NRF provides their own independent reviewers. So they undertook their own process based on their evaluation on which category they should place my research status. It is where now the reviewers determined that I was in the C3 category. which means that I am an established researcher, and amongst my peers, they've shown that I have that level of competency of having contributed to scholarly knowledge. Thank you, Chief Justice.
And following this rating, you were awarded a Vice Chancellor's Research Medal and another award as a senior researcher in recognition of this, this rating.
That is correct, Chief Justice.
You also mentioned that you wanted to go on.
Yes, Chief Justice.
Please do.
The research award by the Vice Chancellor is in recognition of the highest level of having achieved in your research or in your specific area of focus, which is my constitutional law. I've just forgotten to mention that my specific area where I was assessed was in constitutional law. So that medal was reference to that award. And having received the award, then the research status as well was awarded in recognition of the award itself, because the award was by NRF, and then the senior research status was by the university. Thank you.
And the icing on this cake is that you were nominated for the 2025 Male and Guardian Power of Women Achievers Award and was voted as one of the winners in the category of Law and Justice.
That is correct, Chief Justice.
That is a stunning resume. I won't go into all the other things you've done. We don't have enough time for that. So the subject of your LLD was constitutional law? Or am I wrong? The LLD?
Yes, it's an intersection of constitutional law and human rights, and then customary law, because they are interrelated. So that is why the focus was on gender equality in post-apartheid South Africa, looking at the impediments.
What subjects, we do know that you are in the Department of Public Law, but what other subjects have you taught during your career?
I started with criminal law, criminal procedure, and bit of evidence. And then I moved to constitutional law, but today I'm teaching almost all the subject boards. I taught medical jurisprudence, I taught jurisprudence, I taught introduction to law, I taught juridical interpretation. Then there are master's programs, comparative human rights, the theory of law, equality and difference, and the fundamental human rights. Thank you.
All right. And you have served and continue to serve in various leadership positions, including head of research at Forte School of Law, acting dean at that university, and on the board of the University of KZN School of Law.
That is correct, Chief Justice, because I started at UNISA as an ad hoc, because I was not a formal appointment. But that was one of the approaches by the head of department. And at the time, the view was, it was that developing your own timber. So it was not a formal appointment, but at UKZN, I also acted as a dean of research for a year. Then when I rejoined Forte, I acted as the chairholder of the UNESCO Term Board Chair of Human Rights, and also as head of research, and also the deputy dean's position.
You've written extensively, peer-reviewed articles, published articles, book chapters, papers that were published in accredited journals. How many articles have you written in all, would you say?
Inclusive of chapters, Chief Justice.
Everything?
Yes. There are more than 50. Then I've participated in national and international conferences. Thank you.
All right. You have acted as a judge in various divisions of the High Court.
That's correct, Chief Justice.
Since 2016?
Yes,
Am I
that
right?
is correct.
Mm-hmm. And you've acted in the Eastern Cape where you want to be permanently appointed. You've acted in KZN. You've acted in this division as well. Did you sit in both Johannesburg and Pretoria, or were you assigned to just one of the seats?
In both stations, Chief Justice, Pretoria and Johannesburg.
Mm-hmm. And in the Eastern Cape, did you get to sit in all the seats?
Yes, the last stint was in all the seats, but in 2016, it was Bishop in East London.
And you have written judgments, of course.
That is correct, Chief Justice.
All right. In which courts did you sit? Did you sit in all the courts? And what kind of cases did you get to hear?
When I started in Bishop in 2016, I dealt with a civil appeal. And on its delivery, I was surprised to learn that it was already court media attention. And I had a trial as well of a civil trial of a long run, which took me 2 weeks. And I must also express that I felt like running away when I received that file with the 3 interlocutory applications in between. And that judgment, which I referred to, and also I carry great pride in that judgment because I was a pure academic, not even a background on how I should handle a civil trial. But my theory of law enabled me to handle the case itself. And I was appealed to the Supreme Court, and the Supreme Court granted an appeal to the full court. And the full court, on considering the application for appeal, it also dismissed the appeal. And since I didn't deal with the part B of that application, which was whether there was a contract between Buffalo City and the applicant. So the full court had to deal with that aspect. My part, which I dealt with, was on whether a deregistered company has a capacity to sue. And the full court agreed with me that I was perfectly correct that what it says in paragraph 41 of that judgment, and even the legal analysis which I provided in that judgment was not challenged by the appellant. So that is why I'm saying I'm holding great pride with that judgment. Thank you very much, Chief Justice.
And how many judgments would you say you have written in all?
There are 49, excluding the electoral court judgments.
Yeah. Okay. And you have acted for a cumulative period, that's what your questionnaire says, of 41 weeks.
That is inclusive of this last stint of 10 weeks.
And a further 10 weeks?
The last, Chief Justice.
Is it 41 weeks including the 10 weeks?
It's 36 plus 10 weeks.
Oh, I see. So it's 46 weeks. All right. In addition to this experience in the High Court, you also sit in the Electoral Court. You were nominated for membership of that court from 2022 until this year.
That is correct, Chief Justice.
You sit with Deputy President Zondi.
Yes, he's our chairperson.
All right. Have you had an opportunity to write judgments in that court?
Yes, Chief Justice. And I must also express or indicate to the Commission that what makes that court unique, or the way in which it functions, it also provides an opportunity that you are allocated a judgment where you are writing a memo that sets the ground, if I put it that way, on the key issues that has to be considered by the team members, so that an allocated member or an allocated judge, when we discuss the memo, at least we have an insight of what the application is all about. Thank you.
As I hinted at the outset, you were a member of this body for a period of 5 years. I want to mention that I am a Christian myself. I come from a long line of Anglicans and am a practicing Anglican myself. So do understand when I ask you this question that I'm not biased at all. But with your particular interest in matters religious, I just wanted to ask you if you are aware that South Africa is a secular state, and you can promise us that your religious inclinations won't interfere with the execution of your judicial functions.
That is correct, Chief Justice. I'm a staunch member of the Methodist Church, and I'm a Christian, and also as a judge, if I'm given an opportunity, I'll have to decide any matter that have to come related to religious issues objectively and in a fair and impartial way.
Okay. I'm going to hand over to Acting Deputy Judge President Dawood, who represents this division you want to join.
Thank you, Chief Justice. Good morning, Professor. Professor, you have an extremely illustrious academic background. Well done on all your achievements. My question is, on a practical level, do you believe that you have acquired sufficient experience and expertise in all areas of law during your acting stints?
Thank you, AJP. I wouldn't say it loud that I've acquired enough experience in all areas of the law. But what I can point out is that those matters that have been tabled before me, then I was able to deal with them. For example, I never dealt with copyright law, even at university, but I had a matter that came before my table related to copyright law. And that judgment caught national and international media. And it was even quoted as a judgment from South Africa, which means that theory of law was able to be integrated into the practical aspect. So that's the judgment that I can put forward, because I have the other 3 as well that were quoted by the media, like the one on the role of the municipality with reference to eviction, and the other one with reference to customary law in determining the validity of a marriage and condonation. Thank you, AJP.
Thank you, Chief Justice.
Thank you, ADGP. Premier.
Thank you very much, Chief Justice. Good morning to Professor Ntlama Makhanya.
Good morning, Mr.
I'm not sure, Chief Justice, whether must I say this just in case one person will be mischievous about it. We once served together in an SRC more than 25 years ago. I'm happy to see her again.
Thank you, Mr. Premier.
Prof, thank you so much for the opportunity. I would like to check your understanding of what is probably currently happening in our court situations in the Eastern Cape. Surely there would be challenges, and my interest will be, which of those challenges from where you are would you assist in resolving, and what value would you add to the High Court division? Thank you very much, CJ.
Thank you very much, Mr. Premier. Being in the division, what I can first express that there is an opportunity, if I'm given, that I will bring to the division of that scholarship, which I have a background, that I will have to use it into the practical application of the law. In terms of the challenges that are facing the division now, I must also say from 2015, I've been a commissioner here. And the issues of infrastructure and human capacity had always been the answer, the challenge that each candidate from the province will raise. And it's quite saddening that even in 2026, I will raise issues of infrastructure and human capacity. But as an acting judge in the division from 2016 and to date as well, there are still some teething problems relating to the way in which the division should be integrated from PE, from Gqeberha and also to Amtata, because the 4 stations, they provide that opportunity of that geographic vis-a-vis the socio-legal culture that enables each one to bring more life in respect of the way in which he or she handles the matters that are presented before her. So in terms of ensuring as to what value would I bring to the division, then the value that I would bring to the division is the fact that we have the support staff. And the support staff are the face of the division that enables the quality of access to justice. So in terms of ensuring that the division continue to remain with a motivated admin staff, there has to be efficiency in terms of how we deal with matters. There has to be transparency on how we reach decisions. There has to be accountability in relation to the way in which we care ourselves. And what I also would like to bring to the Commission as well, which is not also the Eastern Cape province, the Eastern Cape division. What we do, we always track the performance of each division through monitoring or how many cases or judgments we produce per quarter. But we are lacking in terms of evaluating the extent to which that monitoring actually contributes to this social change perspective that each and everyone who goes to court will feel that the law has actually spoken to him or her. So that's the challenge. To have a judgment in your favor, then it does not have an impact on how it changes the socio-political status of the person, then it will remain a pie in the sky. I'm saying this, Mr. Premier, we have this tripartite model that when in criminal matters, for example, you have to consider the interest of the accused, the interest of the survivor, and also of society. But my issue is, to what extent does that judgment that favors the survivor of any criminal conduct will also offer benefit to the way in which he'll also be happy about the outcome of the judgment? So that is why we're speaking of evaluating the extent to which that monitoring or that many judgments that we produce each quarter will also contribute to the objectives of social change. Thank you, Mr. Premier.
Anyone else? DP's one.
Hey, good afternoon. Sorry, what is it? Oh, sorry. Good morning, Professor Ntlama. Must immediately point out that Professor Ntlama is a member of the Electoral Court, which is the court that I lead. The ECB, in their comment, that's paragraph 6.4, they are saying that more recent judgment by the candidates do not reflect that the candidate has become more comfortable with what may be described as a commonplace application in the High Court. And in support of these propositions, they rely on two judgments, well, Minister of Police versus Matondo and HAC versus SIM. And finally, they conclude that you lack court experience, and that lack of court experience manifests itself during the court proceedings. What is your reaction thereto?
Thank you, DP. Let me also respond by saying, I will never water down any assessment of the quality of the work that I produce. Otherwise, I'll be limiting myself in terms of capacitating so that I learn each time when there's an assessment of my capabilities. But what I want to put to the attention of the Commission as well, that judgment, the Madolo judgment, is in fact, it emanates from a reported judgment. And that paragraph 19 that GCB refers to is not contextualized in the sense that I've made reference to Judge Nugent in the Simo case, where Judge Nugent says the award of damages is fraught with difficulties. And the use of comparable cases must be considered holistically. And if we have to consider those comparable cases, as of equal application, we must be careful because the precedent is of value, but it remains nothing more than that. That's what Judge Nugent said in that judgment. Then my interpretation was, having learned from that paragraph 19, my opinion was, because of the independence of the judiciary, so each judge or in each matter, then the court must determine its own case based on its merit. Because that precedent, as Judge Nugent says, it remains of value, nothing more than that. So that was my interpretation of the Madondo judgment. And secondly, I forgot now the second before the third one. The second question.
Yeah, they also rely on HAC versus SIM.
Thank you very much, DP, as well. Even that one, Judge Smith says the introduction of Section 17(1) in the Supreme Court Act relating to those factors that determine whether a judgment is appealable or not, because we have those two principles, whether there's reasonableness in the outcome or whether there are compelling circumstances that warrants the granting of an order. So Judge Smith says 17(1) has become onerous because it captures that word would. So that would now has to be interpreted in a way that will enable to determine whether now to grant a leave or not. And she was saying, as she said, that word would will make it difficult, not difficult as such, but will require the judge, whose judgment is being appealed, to again, objectively so, assess whether a different court now will come to a different conclusion. That's what it says. Then my interpretation again, if Judge Smith says the granting of leave to appeal has become difficult, because of the introduction of Section 17(1). So this court as well is also persuaded by the fact that before I grant a leave to appeal, I must also look internally, in the sense that that internally has evaluated the extent to which the particular facts or the grounds within which they have been put forward will result in a different court reaching a different conclusion from the one that I've provided. And also I've addressed that one. And also the third concern about the way in which I conduct the proceedings. That one, as I've said, I'm a pure academic, but it's not the way within not to accept or not to concede that I might have committed those issues that are of concern. But as I've said, with the theoretical background and having studied how the proceedings should be conducted, I will not sit before this commission and say, no, I was good, because there are mishaps, nobody's perfect. But as the ongoing process in terms of skilling myself on how I integrate the theory and practice, tomorrow, let me say boldly to the commission, I'll be a better judge. The reason why I'm saying this without blowing a trumpet for myself, from a junior lecturer position to a professorship provision, professorship, it took me 7 years to get there. That excludes the 2 years I was with the Human Rights Commission, because even the LLD itself, it took me 2 years to complete it. So if I'm given an opportunity and come in as a junior judge, I will invest much more of my energy using that theory in order to upskill what I've learned into practice. Thank you very much, Judge John.
Thank you, CJ.
Thank you very much, CJ. Maybe just following up on that one. Is it still morning? Good morning, Prof.
Morning, Mister.
Yes. Do you think you are unfairly assessed on the basis that you are a pure professional rather than being a legal practitioner? That the mistakes that would be made by a legal practitioner, when you can make them, they would be viewed differently. I'm just following with what Judge Deputy President was asking you.
Thank you very much, Commissioner Minister. I must also raise my concern with that assessment, because it was not fair, because it was not contextualized. GCP just quoted without taking it back as to why I was saying what I've said in that judgment, because my interpretation was informed by what I've read, which I substantiated. That is my concern with that comment. And besides, having the theoretical background as well will not be a bar in terms of translating that scholarship and infusing it into the practical approach of the law. Thank you, Mr. Minister.
Thank you, CJ. I'm going to give the round. If you have space for me, I have one question that I didn't ask. Should I ask it? Okay, thanks. The question I have, Prof, it's in relating to the case in Madibeng of the illegal occupiers of land that went and took, and Madibeng came for an interdict. Having looked, and I'm talking from an experience in terms of illegal occupation of land, denying proper planning from government, and therefore spatial development gets affected. Looking at that judgment, do you think that it does encourage continuous of illegal occupation, Or do you think that they could have been, because I look at it from a point one, that the municipality, in terms of the constitution and also in terms of legislation, do not have, unless if it's delegated by the Minister of Human Settlements, do not have the powers to build houses. And Madibeng, in terms of its standing as a municipality, doesn't have that delegation. So I was looking at it from that point, looking at that in terms of the interpretation, but also generally in balancing between legal requirement, but also socio-economic development in the country and the financial burden that the state most of the time have to carry.
Thank you, Minister. Let me start here. Nobody has a direct right in the country, because that section 26 of the Constitution says everyone has access to adequate housing. And that adequate housing is subject to progressive realization. And that progressive realization, it depends on the financial muscle of the state. So within that context, when we speak of that right to access to housing, considering the history where we are coming from, where issues of land, where issues of access to that housing, and with the current challenges now that the government is faced with, those are the things that we need to balance. And the purpose of that judgment as well, in balancing how the municipality, as a local sphere of government, vis-a-vis the ordinary people who do not have roof over their heads, and then the municipality comes and apply for their eviction. And I was of the view, and I still continue, that that road bomb judgment served as a framework within which to determine those socio-economic rights issues with reference to housing. Because the Department of Human Settlement at the time, which was Department of Housing, the court found that the state did not provide or did not have policy that will cater for people in emergency situations. And issues of socio-economic rights has been my interest, because even my academic, my master's was on court orders. Because even that judgment, it took 8 years before it was finally implemented. With the Madibeng case as well, we are not promoting this unlawful occupation, but what we envisage that the state, despite its limited resources, must try and provide an alternative accommodation to the people who are in dire situation. And in this context, the municipality came before the court and says it's going to move people to a community hall. That is where I was. The municipality comes, is going to move people to a community hall. I thought of issues of human dignity. I thought of issues of equality. I talk of issues of freedom and security, of people being clamped in a hall, community hall. Is that an alternative accommodation? So that was my issue when I said the municipality is the cold face of ensuring that those socio-economic issues are addressed, not to come to court and apply for an eviction. And what makes that case distinct is the fact that the municipality came with senior councils, and the ordinary people came by themselves. They represented themselves. So I even referred to that judgment. It was an elephant and an ant, which meant that the scales were far balanced, because the state has financial muscle to get them out of that piece of land. And then the ordinary people come to court, on their own. Thank you, Mr. Minister.
Thank you very much, Prof. Thanks, CJ.
Thank you, Minister. JP Tlaletsi, followed by Commissioner Mangena.
Thank you, CJ, and good day, Professor.
Good day. Oh, I can see. Good day, Commissioner Tlaletsi.
Yes, I must say and disclose that I'm also a member of the Methodist Church of Southern Africa, Khaleshiwe Second Centenary.
Okay.
Yes, mine relates mainly to ethics and conduct of a judge. In your article in the US-China Law Review, the heading is the Hlophe Saga, the question for the institutional integrity of the judiciary. And then on the conclusion in that article, quite well written and recent article, you conclude that it is worth reiterating that the purpose of this paper was its primary focus on the manner in which the controversy involving Hlophe JP was handled in its initial stages. The controversy has plunged the institution of the judiciary into a crisis. It has tainted the image of the judiciary and raised doubts about the legitimacy of the claim against Hlophe JP and the decision of the JSC, which is still the subject of court challenges. The manner in which this matter has been handled has undermined public confidence in the administration of justice, as evident by the public spat amongst the highly respected people of South Africa. It further created uncertainty as to acceptable standards of judicial behavior, since the outcome of this matter is viewed with suspicion and subject to further contestation. The proper handling of this matter could have provided a deeper insight into the guiding principles in relation to what is expected of a judge. The controversy took South Africa by surprise and requires a deeper scrutiny on the regulation of judicial conduct. The Constitutional Court judges' activism in this matter has resulted in a brazen wave of discontent which has cast doubts over the legitimacy of the judicial processes and tarnished the image of the judiciary at large. Close quote. My question is, I understand it also, you really wanted to focus on the process that was followed in handling this conduct. But there seems to be a suggestion that the conduct of the Constitutional Court judges was unwarranted. Whether they should have, well, just as an example, whether they should have reported that incident or not, and that there is doubt and judges are in doubt as to how they should conduct themselves. Maybe you could just clarify that. Thank you.
Thank you, Commissioner Tlaletsi. I can safely say, and I still do, that the judiciary is the one that keeps the glue of this country together. So if public loses that confidence, then the walls of the democracy are likely to collapse. Reason being, when that matter came out for public knowledge, it was reported that when judges of the Constitutional Court presided or discussed this matter, Judge Hlophe was going to be advised first before it is reported in the media. And Judge Hlophe comes out and says, he only learned about it in the media. And what makes it worse is that during the meeting as well, the two judges that were actually approached by Judge Aubrey, other judges were asked not to ask them any question because they were too stressed. So the question that I have, if the two judges that were actually approached by Judge Aubrey could not express or share the impact of the approach by Judge Aubrey amongst the judges themselves, because I am of the view they were in a safe space where they were going to discuss the do's and don'ts or the way in which the matter was handled. But the two judges, they need not to express any view because they were too stressed. And on top of that, the two judges, when the matter went to court, they were differently represented from the court. So it meant that now we have the Constitutional Court that was divided in terms of how it upholds its own integrity. Two junior judges, they were junior, two junior judges vis-a-vis the rest of the judges, going to court with different legal representatives. So that is the basis of that article. I might have been loud at the time as a junior academic, but that was the concern that I had at the time relating to the way in which that case was handled. Thank you very much, Commissioner.
Thank you, CJ. Yes, you may.
Good morning, Prof. I'm over here.
Okay, morning.
I'm wondering, I'm not sure I'm quite following your answer. I'm wondering what you thought the Constitutional Court judges should have done. And I'm also wondering if part of your criticism is of the JSC's handling of that matter.
Sorry, I didn't catch the last part of your...
If part of the criticism in that article was of the JSC's handling of the matter. So it's a two-part question.
Yeah.
What should the Constitutional Court judges have done? And was the JSC part of the problem?
Thank you very much, Commissioner. As I've just explained, that the Constitutional Court judges were supposed to be in unison in terms of how it handled the former JP's matter. But we ended up with a divided Constitutional Court. Secondly, the JSC itself, the way in which it handled this issue when it was reported to it, well, it is public knowledge that it took longer before the matter was finalized. Thank you, Commissioner. Let me also take the bait, because during that period, I was also the Commissioner here. Thank you.
Commissioner Mangen?
Thank you, CJ. Good afternoon, Professor.
Good afternoon, Commissioner.
Yes, you can be rest assured that I'm a strong defender of academic freedom. But it appears it is that freedom that you are going to lose once you ascend, because you will not be able to freely express yourself on certain matters. But you were in a safe space when you expressed yourself as an academic. And I must say at the outset as well that I'm actually impressed by the manner in which you graciously deal with the criticism that is being leveled at you as an academic and how you take it in your stride. And like you say that you learn every day, I've got no doubt that you will make a future judge, because the Supreme Court of Appeal tells us that there is a threshold to be met by any litigant who seeks to appeal a judgment. And the Supreme Court of Appeal also tells us that lower court judges should not give leave to appeal willy-nilly, right? So there's just nothing faulty with what you have done. But Nadel says to us about you, I don't know if you saw that letter, their comment, paragraph 3 of their letter, and I'll just quote the paragraph because it's a 10-lined paragraph. They are saying practitioners have raised concerns about the candidates' time management and court proceedings and suggesting that somehow you are not able to be in control of the proceedings. And in their penultimate paragraphs, they tell us that perhaps you should be given more acting stint, notwithstanding that you have done 52 weeks. Your comment?
Okay, thank you, Commissioner. As I've said earlier on, I'm open to critique. And also in the context, if I'm given an opportunity as a junior judge, the judiciary's role is not a safe space because the judiciary determines what is law. And the academic stands there and says how law should be. So if I'm appointed, then I'll have to tone it down. And also the judgments that I have produced since 2016 are indicative of that toning down of that academic freedom vis-a-vis the practical side. Because the judgments that I've produced so far are within the decorum, if I put it that way, of the judiciary, as opposed to the articles that I've already produced. Because those ones, as you have said, Commissioner, they were published in that context. But when it comes to judgments, then those judgments have been written in a way in which it also upholds the principles and values that are needed from a judge. Thank you very much. Secondly, with Nadel's critique as well, I must also say, Nadel has not considered my work holistically. I do concede that I fell through the cracks in terms of how I manage the motion court, because I have this patience in me that let me allow the counsel to present their case, and I'm still limiting myself in terms of saying, counsel, please stop. So I have that reluctance. So I allow both parties to present their case so that I listen to it properly. So that is my weakness, which I do concede, which makes another to have a concern about. But as I've said earlier on, as I grow from junior to become a senior judge, I'll be able to improve that technical skill on how I manage motion court proceedings. Because as a junior, I always felt that let me give them an opportunity, which, as evidence today, it came back to bite me. So that is why I was saying that toning down, I thought I'm living in the academia so that the judiciary itself, I'm holding its own principles. Thank you.
Thank you, Professor. Stay focused. The future is bright. Stay focused. The future is bright.
Oh, okay. Thank you very much, Commissioner.
While we're on the subject of law bodies complaints, before I forget, the GCB also does raise a concern, although I'm not entirely sure I understand what they're trying to say, because they point out to the fact that that division has lost a bulk, if not all, its most experienced judges in a short space of time in the recent while. Now, they say your appointment would send the message that capacitating seats with experienced judges in instances where senior judges with significant experience retire or leave the High Court for roles in the appellate courts is not a strategic priority in order to bolster the effective administration of justice. And I say I don't understand what they're trying to say, because we are filling an ordinary High Court judge vacancy. So we are going to pick from academia, from the professions. We are not going to pick this experienced judge they want us to find to replace the experienced judges who have left. I don't know if you want to say anything to it.
Thank you, Chief Justice. Yes, I would love to say something and comment on that one. The country has progressed so far. If I would not be a strategic appointment, because the station has lost senior judges, it was a very unfair critique, because I could not be compared as a pure academic with senior judges who have been in practice, that got all the practical skills that they needed to become a judge. And I have also shown my capabilities on how that theory actually contributes to the practical application of the law. If GCB says, Judge Pickering, Judge Abeshe, Judge Smith have left the division, in that cheeky matter which I hold very high, Judge Pickering agreed with me in that judgment. I was right. That's why I'm saying if you go start from paragraph 25, 26, 27, then in 41, they say, Drama HA was correct. I'm not sure of this strategic appointment, that it will not be beneficial to the division, because it looks like it limited its assessment of my abilities to be a junior judge that has the potential to grow within the judiciary. Thank you, Chief Justice.
Thank you, Prof. Professor Janimhangu.
Thank you, Chief Justice. Before I ask my question, I must declare that I know Professor Nkamama, lest people see our picture having dinner flying around. We've known each other since our master's days in the Western Cape, you in Stellenbosch and me at UWC, and we've gone through this academic ladder in different institutions until full professorship, which is a very rare species as Black women academics in law. So that is, and I also know you other than being an academic as a friend as well. So we put that aside.
Do you assure us that you will not be biased?
I will not be biased at all. And I haven't seen you in a while. For 3 years now. So Professor Nkamama Kanya, I see that it doesn't seem like transitioning from academia is an easy thing at all, hearing the discussions that we have had now. So how did you navigate that transition? What are the lessons learned?
Thank you very much, Commissioner. As I've just noted, it hasn't been very easy getting into an arena where mostly judges were appointed from the ranks of practitioners. And when I was nominated by the Society of Law Teachers to be the commissioner, My interest deepened in the sense that I was in the sifting committee of this commission, which provided an insight on the caliber or the qualities that are needed of a person to become a judge. But at the time I was still young. And when I was nominated as well to attend the aspirant program in July by former Judge President Sangon of the division, my heart beat hard because I was looking forward that one day when an opportunity presents itself, I will raise my hand. And in November that year, when I received that call from Judge Van Zyl, I said yes. And my dean at KZN released me. Navigating through in terms of how do I now, being a judge, from that background, I had to learn fast. And what that learning fast is because of the capacity that I had in my research, in my writing, in the way in which I present my classes to my students, in my supervision. So those research skills, those teaching skills, those other attributes that I acquired in the academia, I was able to carry them over. Then I needed to panel beat them within the context of the judiciary. For example, writing a judgment. I will write a judgment, but now each time when I make a statement, I need to supplement it as to why I am making this statement. Because in academia, that's what is needed when we write an article. That you are making this statement, why are you making the statement? Now, in the judiciary, you have to limit yourself on how to make your opinions, because you have to draw a balance on the already jurisprudence and also how it applies to your matter at hand. And when you draw or when you write that judgment as well, there's a certain structure that you need to follow, that you briefly introduce what the case is all about, your brief facts, and then the parties' submissions. And from the parties' submissions, then you identify the issues, and then you go on to the legal framework. After the legal framework, now you deal with the analysis of the law. So that is the structure that you need to follow. Because in the academia, you have your own standard on how you structure your own paper. And also, in terms of the formatting as well, we comply with the certain requirements of a journal. But in the judiciary, there's a particular format as well that you need to format along the requirements that are needed. But the two, they are not distinct from each other. Because drawing that from that experience, bringing together, then you are able to produce a good product. Yeah, thank you.
Thank you, Professor Makanya. You've also answered my follow-up question about the process of judgment writing. Thank you, CJ.
I have to work out the logistics of these operations simultaneously with minding the proceedings. Thanks, Prof. Then it's Commissioner Trolley.
Thank you, Chief Justice. Good afternoon, Professor Makanya.
Good afternoon, Commissioner.
My question is, I also need to make a declaration, seeing that everyone's doing that. I'm from the Eastern Cape, born and bred there, have represented it for a long, long time, so I am parochial. Professor, as an alumna of Fort Hare University and a sitting professor of this distinguished institution, What is your opinion of its embroilment in the national curse of corruption and related crimes like murder and executions? Because the judiciary has to deal with it, but so too do the students who have gone there to learn, have to deal with it, its impact. Thank you.
Thank you, Commissioner. That question conflicts me, and it makes me to be unable to respond decisively to it. Because I'm the sitting professor of the institution. And being a sitting professor of the institution, as they've just made reference to the corruption and all other issues that emanate from the university, if a matter that is coming from Forte and also having been appointed as a judge, and I'm not only a sitting professor, I have attachment to that university as a student because my junior degrees were studied at Forte, and also my academic profile started at Forte. So the best that I could do when a matter from Forte comes before my desk is to recuse myself so that the acting Deputy Judge President or the JP appoints another judge, so that you remove that perception of bias. Because the issue is no longer about being biased, but the perception of bias in handling of the matter. Thank you, Commissioner.
Thank you. Chief Justice, if I may, could I ask just a generic question that I've asked all the candidates from the Eastern Cape? Professor, the Moseneke Commission made recommendations about the relocation of the High Court from Makana to Bisho. It's controversial, it's been dragging on for a long time. What's your opinion on that?
I'm from a village, Commissioner, a Kaga location. Today, we are sitting with the history of the demarcations that have not yet been reviewed. All the villages from the former Siskai, for example, they still go to Zolisha for their cases, whilst there are magistrate courts in King Williamstown or in the central town. So there are rationalization as recommended by the former Deputy Chief Justice. It pains me if I put it that way, because in the last stint, I had to sit on default judgments, just on default judgments, all the way from Mount Frere, Mount Elif, that people had to travel from that far to go to Grahamstown. There's some Tata, but they went to Grahamstown just for default judgment to be confirmed. So when the seat now is moved to Bishop, it will cater for access to justice on a balanced scale. And in balancing this interest, I understand that the economic being of Gqeberha is one of the fundamental issues that have been raised.
Makanda, rather, not Gqeberha. It's the people of Ekheni who are...
Thank you, Chief Justice. The people of Makanda, the economic being of that area. That is the one that is foundational to these objections against the move. But if we are taking the recommendations holistically on the extent to which it can contribute to the advancement of justice, so that those people from Alwa North, they also enjoy the quality of the democracy that we've attained in 1994. Thank you, Commissioner.
Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Poso.
Thank you, Chief Justice. Good afternoon, Professor Makanya.
Good afternoon, Commissioner.
I just have one question for you. Are you aware of the anti-sexual harassment policy that has recently been introduced for the judiciary?
I am aware, Chief Commissioner, thank you.
Have you acquainted yourself with it?
That is correct, I have.
Do you subscribe to it?
I do, Commissioner.
Do you believe that there is any way in which it could be improved?
Thank you very much, Commissioner. Each policy or each law or each rule, its effectiveness determines by the way in which it is tested. For example, just if I can bluntly say, the policy is victim-centered. But I would say it needs a review or an amendment. Because when we refer to the survivor of a sexual abuse, and then we still label him or her as a victim, that's the continuation of that suffering, because it does not give, this is my opinion on the policy, it does not give him or her that dignity of being an ordinary citizen that is entitled to equal rights and responsibilities, because she is already tagged by the policy that she is a victim. On the other side, the definition itself, that it is of a sexual nature. So to what extent do we determine that the policy actually addresses issues of sexual harassment or sexual abuse, because it has to be of a sexual nature? What constitutes the sexual nature? Because now it would require whoever who presides over that sexual complaint has to traverse to determine as to what constitutes the sexual nature. So as I'm saying, the policies, they will be reviewed as the time goes on, which shows that there's a gap here, so that gap needs to be fixed, so that we have a strong and effective policy that will also address all the issues relating to sexual abuse. Thank you.
Maybe you are not aware, but the Office of the Chief Justice has invited input from members of the judiciary, and I guess even acting judges, to assist with pointing out any loopholes in the policy and making any suggestions at this stage, and not waiting until it's implemented and then there are problems going forward. So it would be helpful if you were to make your input and perhaps inquire from the Secretariat how these would be, who would receive those inputs.
And then I am aware, Commissioner, it's just, I must just admit, because it came on my table when it was falling off. Because my academic work as well was taking a toll on me On the other hand, I had judgments to write. So I needed to balance it up until, I must say, I forgot about it. But I've taken note. Now it will be on my desk. It will be my priority that I make my submission on the policy itself. Thank you.
Thank you, Chief Justice.
Anyone else? All right, just to round off, Prof, I forgot something quite important on your CV. You are an elite athlete. You played for Netball South Africa and represented the country even at the Commonwealth Games and elsewhere. And then more recently, you chaired the body's disciplinary appeals committee.
Thank you very much, Chief Justice. Let me start by saying, at Forte, I'm actually the chairperson of the tribunal of the Senate Committee on Plagiarism. Coming now to netball, it goes back to the old Sky. But when the federations of both black and white merged in 1994, I was one of the first 4 players that played for border netball. Then in 1997, for the first time in the history of Forte, had a national player when I was elected for the SA universities that went to Zimbabwe. After that, we were invited to the national team where I played until 2002, where I had to give up competitive netball because of work commitments and also this operation that I spoke about in my form. So since 1997, Forte today does not have any other player that followed me. I'm breaking Chief Justice.
Entitled to.
Because I went to Stellenbosch. Stellenbosch had me for the first time. The Western Cape had me for the first time. Because we were still divided in the Eastern Cape. We had the Eastern Cape, we had Eastern Province. Eastern Province had me during that time as a netballer. So I've made those great strides. And what I want to mention as well, I've been involved administratively in rugby up until I resigned. But now I am doing it on an informal basis because of work commitments as well. So that is where I am and also what I have achieved so far.
All right.
And Chief Justice and Commissioners, the University of Forte has the first time African woman professor who's sitting in front of you today, not in law, in the university.
In the entire university?
Yes. In the entire university, not in law. The University of Forte has this full professor for the first time, the African one.
That might actually work against your candidacy because if we recommend your appointment, then Forte will be left without a black woman professor.
I have done Chief Justice so well for the university, for the university, in fact, not even for Forte, but the academia itself. I've contributed, I've made inroads in terms of ensuring that my academic skills and attributes,
Indeed,
contribute to its advancement. Now I need to cast, if I'm given an opportunity, to cast the net wide and ensure the transmission of those skills in the judiciary. Thank you.
That's fair enough. And on that note, I must just express my own profound pride in what you and our fellow commissioner here, Professor Gianni Mhango, have achieved. It's You are both stellar academics, and we're proud of you. We're very proud of you. Lastly, you did raise the issue of a health issue just now, and I remember that I think it's the LSSA that asked us to get an assurance from you that you are in a state of health that will allow you to execute your judicial functions ably. Do you give us that assurance that you are healthy as can be, and will cope with the demands of this job if you are appointed?
Thank you, Chief Justice. I had this operation in 2004. And in 2008, when I got better, is when I registered for the doctorate, which it took me 2 years to complete. And the appointments now, the judicial appointments, they're growing in the academia. I undertook them with this operation. And the operation now is under control. I'm using medication. So my state of health will not hinder the functioning of the judiciary because I have done so and I will continue doing so. I did take note, the Law Societies and SSA note that I should provide a confirmation of my state of health. But I think I will have to do other than relying on my lip service, that I get a formal confirmation from the doctor that my state of health is under control. Thank you.
Thank you, Prof. That brings us, are you raising your hand, ADJP? Oh, no. That brings us to the end of your interview then. Thank you very much for throwing your head in the ring. I wish you all the best. You're excused.
Thank you very much, Chief Justice, and also to all the commissioners. Thank you.
Commissioners, I'm told that lunch is ready, and I propose that we just get that out of the way. Maybe we've done pretty well in terms of time. So maybe we can break until 1:30. 1:30, we are back here. The candidate will be sitting there. We don't leave the dining room at 1:30. All right.
Afternoon, CJ.
How are you?
I'm good, CJ. Thank you for asking. And how are you?
I'm fine, thanks.
Yes.
Are you ready?
I think so, CJ.
All right, that's good enough. You have a BU recent LLB degree. How are you?
I'm good, CJ. Thank you for asking. And how are you?
Fine, thanks.
That's correct, CJ.
And are you ready in income tax law from
I think
UNISA?
so, CJ. Yes.
All right, that's good enough. Are you ready? You have a BU recent LLB degrees from University of Hotel.
That's correct, CJ.
And a certificate in income tax law from UNISA.
Yes, CJ. Postgraduate certificate.
You were admitted as, well, you had a stint, you were a volunteer at the Institute for Research on Criminal Justice and Human Rights in SA. Was that your first job?
Yes, after leaving university.
Thereafter, you started your articles at the State Attorney's Office.
Yes, CJ.
In 1994.
Yes, CJ.
And you went on to work permanently in that office.
Correct, CJ.
Until when?
I left in 2001, CJ, to join SARS.
And you were already a senior state.
I was already a senior assistant state
attorney by then.
Yes.
All right. Then you went to SARS. What did you do at SARS?
I was employed as a legal advisor. For the first few months, I was sitting in the office attending meetings. And because of my background, litigation background from state attorney, I requested my supervisor that I was not comfortable with attending meetings and strategies and all of that. So in one of our meetings, we were joined by another gentleman that was working for SARS. And so he was introduced to us as being the prosecutor in the tax court. So I approached my supervisor to say, is it possible that I get also allocated to do the prosecutions? Then my request was granted. Then we applied for a delegation from the NPA, which did not take long. Within a week, I was granted the delegation to do prosecutions for income tax and VAT matters. Then I did that for about 2 years.
And you then left to join a management consulting firm.
Yes, I was
a forensic investigator. What kind of management consultancy was this?
Yes, I was recruited to join the firm. I had a certificate that I did at the University of Natal, as it was then known. Then that certificate, I was not able to use the experience that I got or the information that I received from that training. So when I was approached by this consulting firm to say that they are beefing up their forensic and litigation department, I took that with a stride because I wanted exposure in terms of doing the actual forensic and applying what I have learned. So I took up the position. The first project that I did when I joined the firm was we were doing contract reviews for SARCC, which is now called PRASA. From the contract reviews, we were also doing asset verification for the stock for a branch of SARCC. And in that project, we were working with accountants because part of forensic investigation has got to do with the financial part. Then for the legal people coming from the legal background, we were only assisting in terms of collecting information, reviewing policies and the law, and then assisting them in terms of application of the law to the facts, and also crafting their the findings and recommendations in the reports.
You worked your way up in that firm into the position of executive director and left in 2007 to start your own practice.
Yes, Sijay.
All right. And that was in November 2007.
2007.
And you struck it off on your own in 2012 as executive director of this reconstituted firm.
What happened, Sijay, we started a law firm, I had a partner. Then in the course of my practice, I had friends who started a law firm but could not sustain the law firm. So when they got appointed, the process of winding up a law firm takes a long time. So they requested me to be a caretaker. So in terms of the rules of the Law Society at that time, you were allowed to hold directorship in more than one law firm. So I assumed directorship in the second law firm, which ultimately I ended up proceeding with and resigning from the initial law firm that I established, and ultimately having to change the name from Maiji Putuzo into Mabece Tilana Incorporated. This is the law firm that I am still with currently.
So how long have you actually practiced as an attorney?
I started practicing as an attorney when I was still a state attorney, about 5 years. And then from 2007, I was practicing on my own account until currently. If my calculation is correct, I think it's about 22 years.
And what kind of work does your firm do?
We've been fortunate enough to do work from government and state-owned institutions and municipalities. We do administrative law, we do corporate and commercial law, municipal practice and local government. We do forensic investigations, including due diligence, and also workplace investigations. We were also fortunate enough to have instructions from unions. So in that fact, we do labor for unions. Like if I may mention that at some point we're doing work for PSA, at some point we're doing work for NEHAW. And we also do labor for government departments and state-owned institutions, as I've indicated. We also do property law and conveyancing. We do debt collection. Our debt collection is limited in the sense that we collecting debt against companies that have been liquidated, under liquidation, and others are going through business rescue proceedings. So the practice is diverse in that regard. And
any criminal law work?
Before I get to criminal law, I was going to say also there's also the issue with tax. I do tax as I sit also in the tax appeals board. Criminal work is very limited, CJ. The criminal work that we do is mostly on a pro bono basis. The clients that we had in the past 2 years, it was matters for domestic violence, fraud, few divorce, no, I'm sorry, I'm making a mistake now to say divorce and criminal matters. What I meant to say is that in terms of the pro bono work that we do, we also assist with with divorce matters. And whilst I'm still on the pro bono aspects, we also do assist with the NCA matters. We have done a lot of rescissions wherein orders were granted to execute properties. I'm trying to think what.
That's all right. I was more interested in whether you have any experience before you joined the bench in an acting capacity in the criminal law field. But then you do mention in your questionnaire that as a junior attorney in the state attorney's office, you did appear frequently in the magistrate's court.
Yes, we're doing a lot of criminal work, especially for SAPS. There were less serious crimes and more serious crimes. With more serious crimes, senior counsels were always on brief. But for matters like your negligent driving and other less serious matters, we were appearing as members of the Office of the State Attorney without the instruction of counsel.
You've chaired, I don't know if you still do, chaired the SARS Tax Appeals Board, as you mentioned a little earlier.
Yes, I am still. I'm still in the current panel of chairpersons for Tax Appeals Board. I've been a member since 2012, 2013, if I'm not mistaken.
You're from since 2013, all right. And you chair the NHBRC.
NHBRC,
and
yes.
The PSIRA disciplinary committees.
Yes, I am still doing PSIRA as well. NHBRC, I last did the hearings, I think it was 2023.
So you have a fair amount of experience in adjudicative work, even if it's in a quasi-judicial capacity.
Yes, CJ, I've been very fortunate in that respect.
You started acting as a judge in this division. You want to join permanently now in 2016 already?
2016, yes, CJ. It was after I attended the training courses. The first training that I attended for aspirant judges was in 2012. Then we graduated to the advanced training for judgment writing. And there was a further training wherein a few number of us were invited to attend an intense training on judgment writing. Then that was after I've undergone the training that I started receiving invitations to come and act. But I must mention that at that point, even though I did receive invitations from other divisions, I could not take such appointments at that time because I had prior commitments in the law firm.
You have held membership in a number of law bodies, including SAULA, which is one of your nominators, not so?
Yes, CJ.
Okay. You are aware that an objection has been lodged against your candidacy?
Yes, I am aware, CJ.
All right. I'm going to give our objections committee representative an opportunity to tease that out with you and give you a chance to give your side of the story. Commissioner Matolo Lebu.
Thank you, CJ. Good afternoon, Ms. Mapeta.
Good afternoon, Commissioner.
You are aware of the objection by the GCB.
Yes.
Accordingly, the objections committee considered the objection.
Yes.
And just felt it was a bit serious. We need to explain to the JSC what really happened. The objection states that sometimes in 2018, you entered into an agreement with another attorney with the aim of circumventing the legal practice council in that this Mr. Basson did not have a fidelity fund certificate. And this matter went to court because your firm, I don't know how they interdicted it, under case number 504 of 2020. And Judge Mapoma really was just not happy about what happened. And the objections committee's concern was that how come you entered into an agreement with somebody you know that doesn't have a fidelity fund certificate? And secondly, did any client suffer as a consequence of that agreement? Or did the same Mr. Basson collect money to the prejudice of the client? I think I'm giving you an opportunity to explain more, especially the contents of that agreement and what really happened, because from what it says, we were a bit concerned. Thank you.
Thank you, Commissioner. Let me first explain the circumstances surrounding the contract and the working relationship. Indeed, I did enter into a contract with Mr. Basson. At the time, it was an association agreement that we entered into in terms of it was going to be a joint venture. It referred to as a joint venture because in essence, it was going to be a combination of two law firms. Enzo Maya's attorneys law firm in Grahamstown and Mabece Tilana, also known as MTI attorneys in Grahamstown. Those law firms, the two law firms in Grahamstown were going to be combined and operate under one name, Mabece Tilana attorneys. I've seen that there are aspects that are raised in terms of the trust account and monies paid into. I want to state categorically that ever since I started practicing, I have registered only one trust account with the Law Society and also with the central supplier database. Since I'm doing most of my work is from government. So there were no monies that were paid outside. There were no monies that were paid directly for Mr. Basson's benefit. And as far as I know, no client has suffered any prejudice as a result of that. Coming to the issue of Mr. Basson not having a fidelity fund certificate, I was and I am still the only director of that company. If you recall, Commissioner, during that time, the fidelity fund certificate was issued in respect of the law firm after all the members of the law firm, the directors, were compliant. So if one of the members, if there are 17 directors in the law firm and one member doesn't comply, then the law firm would not get a certificate. Basson was not a director in a law firm. Mr. Basson was employed, was an assistant. In those days, we call them professional assistants or sometimes associates. There's no requirement that associates in terms of this, even under this new dispensation. Because now what is happening is if you are a director in a law firm, the certificate is issued now under your name, not under the law firm. Before I started working with Mr. Basson, I followed the processes of the LPC. I registered Mr. Basson in the company. And in the process of working with Mr. Basson, unfortunately, I could not get the confirmation that I received from the Law Society when I was registering Mr. Basson, because it was not only Mr. Basson that I registered, it was Mr. Basson and Mr. Goremosandu. So I applied for a certificate of good standing. In my understanding, the LPC will only issue you with a certificate of good standing if you are compliant in terms of your financial obligations and there are no issues that are pending in terms of disciplinary. During all those times that I was working with Mr. Basson, And all the time that I have been practicing on my own account, every year I have been issued with the Fidelity Fund certificate, either in terms of the old legislation that required the Fidelity Fund to be in the name of the law firm, and even now that I'm practicing as sole director in this law firm, on a yearly basis, I get to be issued with the Fidelity Fund and comply with all the requirements. Same applies with the issue of the certificate of good standing. I have always, in my practice, in my conduct as a professional, I have always conducted myself in a manner befitting of the office. I have complied with all statutory requirements required by the Law Society and other law bodies. Even when I came from the Eastern Cape to practice in Gauteng, I fully complied with the requirements for the Law Society of the Northern Province. And also moving to the issue of the comments that were made by the judge in the case, to give a background to the issue of the matter. After working with Mr. Passon for a few months, there were some disagreements. So the relationship was terminated. I gave Mr. Passon a notice to that effect. So when I wanted my files, my office furniture, my computers, he refused to give me my stuff back in terms of the files and also the office furniture. So I was forced, before I went to court, at the time Mr. Passon was already working for another law firm. So I approached the director of that law firm to say, this is the problem. My interest, more than the files, it's getting my computers and my furniture. Because insofar as the files, I understand that I carry the risk, but if the files are under your firm, then it means you are going to take responsibility once you enter notices that you are now the attorney of record. But then the attorney indicated to me that those files are not with him, they are not in his office. They never brought those files along with them when they joined the firm. So I had an obligation, therefore, because now, in all those matters, as the attorney that carries the risk, I had to make sure that either I withdraw or I get the files back. Because for as long as the files were not known where they were, I was carrying the risk. And this issue, therefore, brings me to the comments that were made by the judge that was presiding on the matter. The comments were made because counsel was trying to make a case to say, Mr. Passon and Mr. Koromesand, they now work for a different law firm. And in terms of the court processes, they have not yet filed notice of substitution, they were not notice of withdrawal or notices of acting, so that the risk now can be transferred from Mabetsetilana to Zilwa Incorporated, because that was the new firm that they were now working for. So counsel was trying to make a case to say, for as long as those files and Mabetsetilana is still an attorney of record in the matter, if anything wrong happened in those matters, then I will be the one who's going to have to take responsibility. If there are monies if in the event that there would have been monies, but the nature of my practice does not allow us to keep client monies in trust account. The nature of this business, Mabetetilana Incorporated, we bill clients for services rendered. They pay us for the services. But we are only using one account. All monies, they come into one account, the trust account. So the monies will be paid into the trust account. And since by the time the money is paid into the trust account, we would have rendered those services. Then we simply transfer the money from the trust account to the business account. So at no stage there were monies, trust monies for clients that were sitting in the trust account. That is not the nature of our business. And I'm saying that it has been the case then, and it's still the case even now. And to show that the business model has not changed, even when we were required to submit the risk management, the RMSCP by FICA, we indicated that our challenge is that we do not handle trust accounts or trust monies in the true sense of the word, because all the monies that get into our trust account are monies emanating from invoices for work that has already been done. So in that sense, there is no risk that people will be adversely affected in any way. And in this case, there were no clients affected because there were no monies that were sitting in the trust account that were held in the name of clients, whether individual or government or SOEs. I'm not sure if you still need me to expand more on the issue.
Yes, I think I just want to, you said before in the old dispensation, yes, law firms got fidelity fund certificate. When was that?
When, before the introduction of the Legal Practice Act, fidelity fund certificates were issued in the name of the law firm.
Have you checked that?
Yes, I know. I still have my old fidelity fund certificates. They were issued in the name of the law firm. It will say Shirley Tilana Mabete, an attorney practicing under Mabete Tilana Incorporated. But now it does not include the law firm at all. It only talks to the legal practitioner. Yes. And at that time, as I indicated, because I was practicing with somebody else, I think there was a time when we could not get the fidelity fund certificate because my partner, there was something with the way that he filled in the form, because then we were filling in those forms. It was not even done electronically. There was those forms that each one of us will need to fill. And the only difference will be your personal information, but every information will be the same because we are practicing under the same law firm. The details of the trust account, the monies that are in the trust account, and the dates of the balances in the trust account. And also, it will also ask you the areas of practice where your income is coming from in terms of percentages. And I guess that was speaking to the issue of the insurance.
Thank you. I just wanted to correct you. The Fidelity Fund will never issue a Fidelity Fund certificate in the name of the law firm. A person who's insured is the practicing attorney. You may be practicing under a firm, a particular firm. I know that they don't write a name of the firm now, but the insurance, the person who gets insured, it's you as a
Yes.
practitioner. I want to just, it's not the law firm. Secondly, I wanted to find out the relationship, you say it was an association agreement?
Yes.
A joint venture. And how was it structured? How was it structured?
The issue of the joint venture only related to the combination of the offices. But for all intents and purposes, it was operating as a law firm, Mabete Tilana Incorporated, as I indicated, that I had to, before they start to sign any documents in my office, I had to register them with the Cable Law Society at the time.
So the files that this Mr. Basson took, whose files were they?
The files were coming from, Mr. Basson was working for Enzo Maya's attorneys. So when they separated, what I was advised was that Mr. Basson was given the files by Mr. Enzo Maya's.
Did you subsequently get the files back?
Come again?
Did you get the files back? Because
I never got my files back. I had to withdraw as an attorney of record because the issue, I would say it started to get ugly when we went to court. And my only interest now was to get my computer because the heart of my law firm was in those computers. The issue of the files for me was neither here nor there because I knew that I was going to be able to get new work, but the only challenge for me was to have the information on the files so that I can withdraw as attorneys of record. Because one of the reasons why I could not insist on the files was because Mr. Basson went behind me, spoke to the clients, misrepresented the situation to the clients, and some of the clients sent an instruction to state attorney to say to state attorney, take all these matters and give them to Mr. Basson. So state attorney as the client, when they issued that instruction, I could not fight with that. And when I tried to approach the state attorney, one of the reasons they gave me was to say, we've been working with Mr. Basson for a long time. We know Mr. Basson. So we are choosing that our files must go with Mr. Basson. So that's how the issue of the files ended. And at the time when the matter went to court, I gave instructions to my attorney to say, let's not pursue the issue of the furniture and the computers, because on the morning when we were supposed to go to court, those items were delivered. Then when it comes to the issue of the files, I advise him that if this is the attitude of the clients and the state attorney, there's nothing that I can do. Because we received those instructions from state attorney. If now they feel that those files are not, for a lack of a better word, they are not better placed in my hands, they will be better handled by Mr. Basson. I could not insist on that, but what I had to fight for was the fact that in the process of all of this, Mr. Basson said to the clients that I have closed my firm, so their matters would not be handled, and but as a result of that, I had to seek an interdict to say that this is not true, because now clients are saying, because you have closed your firm, so why should we keep their files with you? And that was not true. I never closed the firm. I just wanted back my files, back my furniture, so that I can proceed and operate my firm like I did even before Mr. Person came into the picture. I know that at face value, the contract, as the GCB put it, might seem to have some questionable standard. But I wish to place before this commission that there has never been anything untoward. I haven't done anything untoward. And of course, the matter when this issue with me and Mr. Person, it did give me sleepless nights. And I tried to put it at the back of my mind because I went through a lot. Because at the time, I was faced with a situation where I was the only person fighting against Mr. Person, Mr. Zilwa, the people from state attorney from both offices. And what is said is that it so happened that all of them were males. They could not even give me an Audi for me to address the situation, to say, what Mr. Person has told you is not true. And also I would like to get an opportunity to present my case. But at that time, I was not given that opportunity. So that's why I decided to let go and started from the beginning.
Thank you. I just want clarity. Did Mr. Person had a fidelity fund certificate when you entered into an agreement with him?
No, Mr. Person did not have a fidelity fund certificate.
Secondly, did you report this matter to the LPC?
Mr. Person did not have a fidelity fund certificate because he was not required to have a fidelity fund certificate. He was not required to have a fidelity fund certificate.
This is my challenge. You enter into an association agreement with a person who does not have a fidelity fund certificate. The fidelity fund is, firstly, it says risk. Number two, the clients are at risk. And you don't report this matter to your own regulator because they could have resolved this issue. And if Mr. Person is walking around without a fidelity fund certificate, he's got clients, then the clients are at risk.
My understanding is that Mr. Person did not have clients. Mr. Person, the clients were for Enzo Meyers, the attorney, the law firm. Those were not for me. Those were not Mr. Person's clients. This was one of the issues that I had to fight for when I was asking for my files back. Because Mr. Person cannot say that these are my files because these are my clients. Hence, I said when I was trying to explain that when Mr. Person left me, he went to Zero Attorneys. So when Zero Attorneys said, I have no idea about those files were never brought to my office, then at that point, then it is when I had to take it upon myself that because I had the fidelity and I am the attorney of record in those matters, Mabetsa Tilana is the attorney of record. So I had to make sure that those files belong somewhere to somebody who can take responsibility. So when Mr. Zilwa said the files are not with Zilwa Incorporated, so those files could not just exist in a vacuum. That's why I had to go to court.
I'm sorry, Commissioner Matolo, this all sounds like great to me. I was never in this sphere, and I'm thoroughly confused now. Just clarify one small aspect for me.
Yes.
I thought you said at some stage there are clients who said they want their files to remain with Mr. Person. They were moving with Mr. Person.
The state attorney, yes. The state attorney said the files must move with Person. Person was at that time with Zilwa. But Zilwa denied knowledge of the files.
All right. Okay.
I'm still not satisfied. I will suggest that you report this matter because it has a potential of those same clients be at risk who are floating without Mr. Basson, without a fidelity fund certificate, and you are aware of that.
Okay. Can I just allay your fears, Commissioner, in that respect? Since then, the matters are fully with Mr. Zilwa. Mr. Zilwa filed notices of substitution, substituting me as an attorney of record. And lately, when the state attorney introduced this new system of work allocation, they came back to me to say, we never instructed Zilwa in those matters. Then I had to produce the letter that was, the email that was given to me to say, those files, we want Mr. Basson to remain in the files. The state attorney made the choice. I could not force state attorney to say, state attorney, the files. State attorney made the choice to take the files from me.
All right. I'm going to allow follow-ups, just follow-ups. We'll revert to the traditional order of questioning. Commissioner Mangena, Minister, and JP Tlalit.
Good afternoon, Ms. Dilan.
Afternoon, Commissioner.
Let me see if I can really help in getting this thing out of the way. Yes. This issue out of the way. My apology for referring to it as a SFA.
Yes.
As I understand it, you got into agreement with Mr. Basson.
Yes.
Who, at the time of the conclusion of the agreement, was not in possession of a fidelity fund certificate.
He was working for Enzo Meyers as a professional assistant, and he was not required to have a fidelity fund certificate because he was a professional assistant.
Yes. But what was the essence of the agreement? What was he bringing? Was he going to be your employee, professional assistant, as we refer to them?
Yes.
Was he the only person to be the professional assistant you had an agreement with, or all other professional assistants had similar agreements?
It was him and Mr. Goromesando.
As I understand the objection, it does suggest like Mr. Basson had access to the trust account. Is that correct?
No, never. Never.
Thank you, CJ.
I have submitted my audit. As you know, it's a requirement. I have been the sole person. I can never abdicate my responsibility and get somebody else to be involved in a trust account. If that was the case, probably I will be facing a lot of charges for misconduct from the Law Society. Mr. Basson has never been part of the trust account. I am the sole person. Even my accountants do not have access to my trust account. They just received the bank statements to prepare the audit statements that are required by the LPC.
Thank you, CJ. Thank you,
Minister. Thank you.
Thank you very much. Good afternoon, Advocate. Oh, Miss Tengan,
Tilana
Mapete. Sorry
yes.
about that.
Yes.
Just to clarify, you are saying that State Attorney gave the files to Basson,
yes,
who in terms of the law and requirements of State Attorneys was not in compliance because he's not an attorney, as you say, he's an assistant. Is that what you are saying to us?
Yes.
Which State Attorney office is that one?
It's PE and East London.
PE and East London.
PE and East London.
So they took the files. So Basson says, we're taking the, how did the files end up with Basson and not you as an attorney of record?
Let me first explain this, Minister. Once Mr.
And please,
Basson...
may I ask that you just keep your explanations crisp?
Yes, okay.
And
Thank you.
if we don't have enough information, you'll be asked further questions.
Yes. Once Mr. Basson was outside the umbrella of MTI attorneys and outside the umbrella of Enzo Mayas, he did not have the protection of the LPC or the Fidelity Fund certificate. The state attorney took that risk. They took the risk to give the files to Mr. Basson. And I am not sure, probably, Minister, you might be aware. I think it was last year, Mr. Basson sued them for payment of fees on the matters that Mr. Basson took from me to Zilwa, and now he was not paid by state attorney. But even though Mr. Basson, as Mr. Basson, is not supposed to
I ask you not to introduce new things. I've asked a specific thing. I will deal with the issue of payments and all that.
Yes.
I have asked a question. How did Mr. Basson end up with the files when he was not the attorney of record?
Yes.
Because a state attorney can take the file from you and give without you knowing. You had the file, you are the attorney of record. Why are the files being with Mr. Basson, who's not the attorney of record, but you are? That's the question I'm asking.
Oh, yes, okay. The office is in Grahamstown. My practice is in Johannesburg and Grahamstown. I have an attorney responsible for the Joburg office and an attorney responsible for the Grahamstown office. So I am between the two offices. Mr. Basson was responsible as a senior attorney for the Grahamstown office. Hence, when I went to get my files, Mr. Basson refused to give me my files because he was the attorney who was in charge of that office. And
But Basson was an attorney.
Yes, he was an
attorney.
attorney. Yes, in charge of that office.
Basson is an attorney
Yes.
responsible for an office, but without Fidelity Fund certificate.
Yes, it happens, Minister. The requirement of the LPC is that you need to have an attorney with a certain number of years who in your absence as the director can look after the firm. So, as I'm saying, 2018, even though I had an office here in Joburg and Grahamstown, I am between the two offices, but I have senior attorneys that are assisting in the running of the law firm. And the LPC or the Law Society, hence you are required to report and register the people that are under your name.
Last one, follow-up, CJ, just my apologies. And then when Basson refuses with the files, did you report to anywhere? Did you go and write to state attorney to say, I'm the attorney of record, and notify the client, I have the following situation that this person is refusing with the files? Did you do that?
I
Can we have
did.
record of that?
I did. It's a pity I did not. I did. I wrote to, it's Ms. Mugi at the state attorney in PE, and also it was Mr. Mnyande. And a state attorney in East London, it was Mr. Mkujulwa and Mr. I can't remember the surname now, but we're calling him Doug Moore. Because when I approached them, I approached Mr. Doug Moore because he was the acting state attorney. And then I received an email from Mr. Kujula to say, Mam Chawe, why are you not telling us that we have since closed your firm? That is one of the emails that I received when I started to know that Mr. Basson has been spreading the word that I have closed my firm. So I approached state attorney. State attorney in East London said, you will have to speak to the police in Grahamstown because the work was coming from the loss claims department in Grahamstown. and also in Zwelitsha. So I sent an email to the head of the legal, and I can't remember the name. He told me in no uncertain terms that he is not going to give me an Audi. He has decided that the matters must go to Mr. Basson.
I think you have answered my question. As CJ asked that you be short, I want to hand over to other commissioners. If you can share the letter with us, I would appreciate through CJ.
The letter for?
The one you said you've got record of writing to the state attorneys to say Basson has given,
I
have
do
taken
have,
it.
but unfortunately I did not bring them.
No, you
because
can bring it later, it's fine.
Okay.
You are entitled to send it to the secretariat.
I will check my records. Means I'm hoping that I'll be able to retrieve, because I was able to retrieve some of the information.
Judge President Ledwaba.
Thank you, CJ, and good afternoon, Ms. Tilane Mabekte.
Yes.
Yeah, just want to confirm that I have known for many years, maybe it's a new practice, a fidelity fund certificate is issued to a practitioner.
Yes.
In a firm, all of them must have their own fidelity fund certificates. But now, I think the real issue here is the origin of your relationship with Mr. Basson. And you say this was a joint venture.
It was an association agreement.
So it was not a joint venture of two entities coming together for a specific project.
Well, in the agreement, we framed it as a joint venture.
Yeah.
But in actual fact, it was an association agreement that we're going to be working together.
Yeah, the labeling was a joint venture, which is misleading.
Yes.
From what you are saying. And for the association, was he having his own practice or entity to practice in association with you?
No, Mr. Basson was not practicing. He was employed by.
So it was not an association, it was your employee?
Yes.
Yes. If Mr. Basson was not your employee, he would not have been in a position to practice?
Not for his own account.
Yes.
Yes.
For him to practice, he would have had to be with you, register him under you, but you couldn't have been in a position to practice.
Or any other attorney.
Yes. Anywhere else, anywhere.
Yes.
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 So a requirement for him to practice is that he had to be under your wing, register under your firm.
Yes.
See, that's where the difficulty is. That for him to be practicing, he had to be under you. And that's where the problem started. Did you check whether from where he came from, the books were properly closed?
No, there was no need for that because the law firm Enzo Mayers is still in existence.
Yeah, you did not check whether he had any issues, whether he had handed over back the certificate that he would have had at the time.
No, Mr. Basson did not have a fidelity fund certificate because he was practicing as an PA under Enzo Mayer's attorneys. My understanding of the law and how it operates is that professional assistants are not required to have fidelity fund certificates.
See, I understand. Thank you.
It is on.
Thank you, CJ. Ms. Tilane Mabekte.
Yes, yes,
Good afternoon.
Good afternoon, DP.
Now, the agreement that you concluded with Mr. Basson, what did it say? Was it saying the relationship between you and Mr. Basson, it's a joint venture or an association? What did it say?
As I indicated, Commissioner, it's unfortunate that the agreement refers to
yes.
A joint venture. But
the agreement says this agreement is a joint venture between Tilane Mabekte and Mr. Basson. That's what it says. What did it say? Maybe you can help us.
The agreement says Mr. Basson is an attorney practicing as an associate with Enzo Maya's attorneys, operating the firm's Grahamstown branch office.
So, but how was the relationship between you and Mr. Basson regulated? Because that agreement was supposed to regulate the relationship between you and Mr. Basson. How did it characterize the relationship? Is it a relationship? Is it a sale agreement? Or how did it characterize that relationship?
The relationship,
because that was the purpose of the agreement.
The relationship was, I was the director of the law firm. Mr. Basson was a professional assistant.
So you mentioned a joint venture, and then you mentioned association. So that's why I'm getting confused. Because these are two different concepts, meaning two different things.
Yes. I do understand that the contract might really be confusing and also might cause some misunderstanding, but it's deeply regretted. There's nothing that I can do about it.
Well, that is the problem that the GPC is having, and that's the reason why they've raised these issues, because it will seem to me that you entered into a simulated transaction. The transaction is characterized as A, when in fact it was not A transaction, but it was B transaction. And this was a simulated transaction.
Well, if your understanding is in that way, Commissioner, I cannot argue with you. Yes. But what I can say is my understanding at the time that I was entering into this agreement was the fact that Mr. Basson is assisting me in the firm as a professional assistant, like I had a professional assistant even here in Johannesburg. So both of them, I was treating them the same way. But the difference with Mr. Basson was that he was coming from Enzo Maya's.
Well, I think that we've been through that road. So yeah, you understand the difficulties that we're having here, because our understanding of the nature of the transaction is based on what you are telling us. And based on what you are telling us, it will seem to us that, for me personally, it will seem to me that this was a simulated transaction, because it is characterized as something else, but in practice it's something different. Thank you, SCJ.
I would actually like you to respond to what DP Zondi has just said.
All right. Commissioner, I accept your interpretation. I was wrong in my own interpretation. I accept that. But what gives me solace in the issue is the fact that when the matter came before court, there were no adverse findings that were made against me or my law firm. That is the only thing that gave me solace. I might have erred, but the fact that my name was not tainted, I'm not saying that it's an absolute absolution that I was found probably, not to have committed misconduct. But the fact that the court did not make any adverse findings against myself and my law firm, it's what comforts me. I accept the interpretations. I accept the fact that other people might view this in whatever way. If it was wrong for me, I apologize. I never intended any prejudice. And in fact, up to date, there has been no prejudice that has been brought to my attention, wherein it has been said that because of what you did with Mr. Basson, then we are suffering these consequences. And as such, I've never even been brought before the LPC for any kind of misconduct. That's how I have conducted myself in this profession. Thank you, DP.
Thank you, CJ.
Thanks, DP. Ms. Mapek, but before we leave this aspect, we still have other candidates to interview.
Yes.
But this is quite important. You do accept that the court was unhappy with this agreement, this simulated agreement. You've conceded that.
Yes, yes, CJ.
And stated that it was actually in contravention of the Legal Practice Act. Is that not so? Was that finding not made?
No, no such finding was made, CJ.
What did the court say about this agreement?
If probably you can take me to the specific, because this was a long.
Well, it's you were in the case. I was not there. You tell us what did the court find? You brought this case. You're a lawyer seeking to be a judge. Surely you can tell us what happened there.
No, the judge did not make a ruling on the actual agreement. There was no finding in terms of this agreement, if my recollection serves me well.
All right, I'll leave it at that. You had finished objections committee, not so?
That was the only objection. I just wanted to advise you to report this matter to the LPC.
Yes. Can you come again, Commissioner? I didn't get you.
I'm advising you to report this matter to the LPC. The reason why, if Mr. Basson is doing what he's doing, clients are at risk. And the state attorney is doing wrong things themselves. And the state attorney falls under the LPC.
So if I understand what you are saying, Commissioner, is that I should report both the state attorney and Mr. Basson. Well, if I may just also mention something, but if it's going to help. At the time, I even tried to report the matter to the office of the Solicitor General. There were people that were prepared to assist me to get a meeting with the Solicitor General, because at the time I felt that the state attorney, what they were doing was not right. Other than them discriminating me, I felt that even their internal processes, they are not following them, because my knowledge is that you cannot appoint A
Ms.
and then pay B.
The advice to you is simple.
Yes.
Report the matter to the LPC, which is the regulator in terms of the law. Otherwise, clients are at risk. Do you have a problem with this advice?
No, I don't have. I will do that.
Thank you. Acting Deputy Judge President, do you have questions for the candidate?
Yes, thank you, CJ. Good afternoon.
Good afternoon, ATG.
How often have you acted as a judge?
I started acting in 2016, 2017, and I think early 2018, if I'm not mistaken. And then I again started acting in 2023. Then intermittently from 2023, 24, 25, 26, I've acted for intermittently from 2023 up to my last stint was first term, and I'm also going back again. In fact, I'm starting on Friday. Tomorrow, I'm supposed to start duty.
What unique skill sets or expertise will you bring to the bench?
ADGP, I would like to think that I've already, other than what I'll be bringing, I think I've already made a difference in the division. As I'm sitting here, I have 2 judgments that I've penned that have an impact in the practice in Grahamstown and also in Mthatha. I have the experience One, I did my articles within State Attorney. Litigation has always been part of my life. It's what I am passionate about. More than that, I have the experience that assists me wherein I did forensic investigations. That skill comes in very handy when I am analyzing the law, collecting my facts, collecting the evidence. It also assists when I am in trials in terms of directing, because as a judge, it doesn't mean that you need to sit down and let the parties control the proceedings. So it assists me in terms of directing the proceedings. I do not mean that I will step into the arena of the proceedings, but because of the experience I have, I am able to direct the proceedings. And more than that, I have been fortunate that in my practice, the kind of litigation and the kind of cases that I've handled. I have also been fortunate enough to work with senior judges who have mentored me, who guide me in the process of judgment writing, in the process of handling the court and dealing with practitioners. I've also, as a practitioner, I've also done my part in terms of uplifting other practitioners and training other practitioners. I have in my belt about 7 candidates that I have mentored. I have mentored students. I was part of the South African chapter of International Women Judges for 3 years, where I was mentoring students. I am bringing the wealth of experience as a practicing attorney. I have sat in the tax court. I've sat as a member of the DC for SAFA. I have done prosecution work. I have been an attorney. I am an all-rounder. I have sat on all sides of the judiciary.
Thank you. Thank you, CJ.
Thank you. Premier?
Thank you very much, CJ. I really don't have much except, good afternoon, Ms. Tilana and Mabete.
Good afternoon, Premier.
Thank you so much. My legal interest, based on what has already been asked, would be in you understanding the Eastern Cape. I hear that you have been in Gqeberha, Mthatha, etc.
Yes.
From where you are, what could really be challenges that are facing the high courts in Eastern Cape? What do you think needs to be done?
From my experience, Premier, the first challenge is the infrastructure. As an acting judge, we have a challenge. If you have a particular head matter, you are not able, once you leave the establishment, you are not able to come back and finish your part head matters because there are no courts that are available for acting judges during the term. So you can only come back to finalize your part head matters outside the term during recess. That is the first challenge. The second challenge that, for me, I think the judiciary might benefit if it could be looked into. Having sat in appeals where the court depends on the record, on the transcribed record of the proceedings. The issue is with the translation, which is recorded in the transcribed records. I feel that sometimes the litigants do not get, their cases are not properly put when they are translated. I'm saying this because when I'm doing trials, with the benefit of the language, I am able to say to the translator or interpreter to say, this is not what the witness said. The witness said ABC and confirm with the witness. So In instances wherein someone does not have the benefit of the language, and what is recorded transcribed in the record, it's what is said by the interpreter, which sometimes says the opposite of what is being said by the witness. So, to me, I think the courts can benefit if the very system that is used in Parliament to translate between the various languages can also be introduced in courts. I know it's got a cost implication, but in terms of access to justice and the dispensation of justice, it will go a long way. The other aspect that, to me, it's a challenge for the courts, especially in the Eastern Cape. The Eastern Cape is comprised of 3 erstwhile areas: the erstwhile Republic, erstwhile Ciskei, erstwhile Transkei. I'll make an example because you understand the area, Premier. I'll make an example of Ginsberg, Bisho, and King Williamstown. People in Ginsberg can't litigate in Bisho. They need to take their matters to Grahamstown when they are less than 10 kilometers to Bisho. Similarly, if you go to Mdantsane and Fort Jackson, they are separated by a road. But Mdantsane, it's Bisho. Fort Jackson, it's Grahamstown. So to me, that's a huge challenge, which I am hoping that through the rationalizations of the court, also the demarcations will also be revisited so that people will be able to access the courts. And because Bisho covers a lot of the villages around King Williamstown, even with those villages, if one has a matter in the magistrate's court, it's Zwelitsha, but there is King Williamstown before you get to Zwelitsha, there's King Williamstown. But because you're coming from KwaMasele, you can't go to King Williamstown. And in all of this, there's an issue of transportation. You take a bus to King Williamstown, you take a taxi to Zwelitsha. When in honest fact, you could have just taken one form of transportation and get to the place where you are supposed to get help. Those are the challenges that I can think of right now, Premier.
Any further questions for this candidate, commissioners? No. Thank you, Ms. Oh, is that you, Commissioner again?
Yes.
Okay.
Thank you, CJ.
Yes.
Ma'am, just so that this gets out of my way. The GCB says that in paragraph 6.3 of their comment,
yes,
they say that you may have misrepresented the facts
yes,
in response to a question whether you were an attorney of record or the correspondent for the state attorney.
yes.
What is factually, what is the correct position?
Thank you for that question.
They make reference to 2 matters.
Yes.
So I guess you are aware of those matters.
Yes, I am aware of that. The comments are unfortunate. I will start by saying, when I responded to the objections, I did include some documents that showed that indeed we were instructed in these matters. I will start with the matter of Loni. Loni is a matter that was done in the Constitutional Court. It involved the matter of prescription. In this matter, we were working with 2 councils. One council was situated in Grahamstown, and the other council was situated in East London. As being instructed by state attorney to act on our behalf, because the matter is here and they are in East London. So our involvement was, we were not post boxes. We were
No. Do you have a letter from your client or a power of attorney authorizing you to act for the client, or were you the correspondent? I do know that in certain instances, correspondent may be requested to perform certain acts, but there is a difference between being a correspondent and an instructed attorney. What were you?
Commissioner, my understanding, when you receive instructions from state attorney, they become your client. That is my understanding. Hence, in most of the matters, as I indicated earlier on, that most work that I was doing is for government, and those instructions are coming through state attorney. So in my understanding, when you get instructed, when state attorney instructs a law firm, that law firm versus state attorney, there's the relationship that state attorney is the client. Because when you work for state attorney, you don't communicate directly with the clients. Everything is done through state attorney. So hence I'm saying the comments are unfortunate. And we have done work in these matters. We have attended court. We have, I'm not going to say we drafted documents and appeared in court. No, we did not. In both matters, they were cancelled. In the matter of Boxer, I was working with Advocate Mbagani. Advocate Mbagani prepared the documents. We sorted out the annexures, prepared the documents, and we filed the documents in court. We did everything that an attorney does when he gets instructions in a matter. We even attended court in both of these matters. And if I might also again refer to the Loni matter, I see that they are saying that because I left state attorney a long time ago, and there's no mention that I might have had a relationship with Mark Mahonen. That's why I included in this, in my response, documentation that was coming from the Constitutional Court indicating that we were attorneys of record in the matter. I'm not sure if I've answered your question.
No, certainly.
Yes.
Commissioner Poso-Hirotol.
Thank you, Chief Justice.
Yes.
Good afternoon, Ms. Tilana Mabeka.
Good afternoon, Commissioner.
I note that in 2017, 2 of your judgments were overturned by the Supreme Court of Appeal.
Yes, Commissioner.
And these concern serious matters. The one, S versus Boyson, involved a femicide.
Yes.
And the second one, S versus Bailey, involved the rape of a 6-year-old child.
Yes, yes, Commissioner.
And these both were overturned because the Supreme Court of Appeals had no quibble with the conviction, but however, they found the sentences to be grossly lenient.
Yes.
And also not complying with the Minimum Sentences Act. What is your comment?
Thank you, Commissioner. The cases flow from 2017. I accepted, and I still accept, the criticism in terms of how I handled the sentencing in the matters. What I want to say to this commission is that since then, I have grown, I have developed in the area of the criminal law, and since then, there has never been another matter that has been taken on appeal and overturned. If I may also, in terms of the appeals, just disclose before the commission that I have only one matter now that is currently sitting before the SCA. It's not a criminal matter. It's a civil matter. So since those matters, I have never had any matter that was upset by the SCA.
Thank you, Chief Justice.
There are no further questions for you, Ms. Ilana Motbet.
Thank you, Sejay.
Thank you for taking the time.
Okay. Thank you, commissioners.
Good afternoon, Mr. Ngunse.
Good afternoon, Chief Justice.
Are you well?
Surprisingly, I'm well, Chief Justice.
Oh, good to hear. First, apologies, we're running behind schedule. Apologies for keeping you waiting for a long time. In fact, you were supposed to be interviewed yesterday already.
Understood.
Thanks for bearing with us.
Thank you.
You are a magistrate.
Correct, Chief Justice.
With a BProc from the University of Fort Hare.
Correct.
And an advanced diploma in labor law from UJ.
Correct.
And a postgraduate diploma in criminal justice law obtained from NMU.
Correct, Chief Justice.
And the last two qualifications you obtained whilst you're already in the job market.
Correct, Chief Justice.
All right. You started working in the Department of Social Welfare and Pensions. I imagine you've been fresh from university in 1986.
Yes, Chief Justice. At that time, I had not yet obtained my qualifications.
Then in 1992, you joined the Department of Justice as a state prosecutor.
Correct, Chief Justice.
You were there for 2 years, then joined the magistracy in 1994 at the dawn of democracy.
Correct, Chief Justice.
And that's where you've remained until now. You have acted in the High Court.
Correct, Chief Justice.
Since when?
I've acted since 2018 in the Eastern Cape Division of the High Court. And then in 2021, I acted in the Gauteng Division of the High Court in the Pretoria High Court.
For how long?
It was for a term and a half, Chief Justice.
All right. Are those the only stints you can?
Yes,
lay
of course.
claim to?
And then I acted again in the Eastern Cape, directly from North Gauteng High Court. I went back to the Eastern Cape, and then I acted in the Eastern Cape 2021, 2022, and 2023.
Was that your last acting stint, the 2023 one?
That was my last acting stint, save for going for party
Part
matters.
heads,
Yes.
yeah.
Yes.
So how long in all have you acted as a judge, that is?
I would say that I've acted about 9 stints.
Okay. What kind of cases have you done in the magistracy?
Well, in the magistracy, Chief Justice, I firstly started as would be the case in the criminal law. That was 1994, and not really much on the civil. But when I moved from Ngoshwa to Komani, then I started to immerse myself in civil litigation, and I never stopped thereafter. And that was, I would say, mostly my forte was in the civil litigation, much as I would do criminal work as well. And of course, family law, that would be your maintenance, your domestic violence, protection orders of harassment, children's court. So I had then, as a magistrate, a variety of work, but as I said, mostly in civil.
Did you write judgments as a magistrate? Well, you still are a magistrate. Have you written judgments as a magistrate?
Yes, I did quite a lot of judgments as a magistrate.
In civil law, which is
in civil law, I did quite a lot, and in the other spheres of our work.
What kind of cases have you dealt with in the High Court?
In the
High Court.
In the High Court. In the High Court, Chief Justice, once again, I remember when I started in the Bishop High Court. Incidentally, the first day I started, I was thrown in the deep end of motion court. And of course, I had all kinds of applications which I had to deal with that week, I remember. And from there, I went to the Makhanda High Court, where I had to deal with a number of different kind of matters in the civil litigation, your administrative law, your applications, civil trials of different kinds, and then of course in the Mthatha High Court, similarly in the Gqeberha High Court, similarly your RAFs, and any other matters, delictual claims that would come my way.
So you've sat in motions, you've done appeals, you've done trials, and everything else in between.
I've done a couple of, all of them, Chief Justice, and as a result, that would be borne out in the number of judgments which I had produced in a very short space of time. And as I was counting my judgments in the Eastern Cape, are no less than 76, which I inscribed in Pretoria, or rather Tshwane, or North Gauteng High Court, where it was even a shorter stint. I crafted judgments which are no less than 20 in all the various kinds of work that one can expect in the North Gauteng High Court, which is a very busy court, as we all may know. And I was exposed to a variety of work, your immigration, your mines, minerals, and all other kinds of work that one can expect in North Gauteng High Court.
Among your list of accomplishments outside your work, you list having assisted with the establishment of the University of Gauteng Law Clinic.
Yes, Chief Justice, that was during my time there. We established a law clinic for the residents of Gauteng.
You also sit as a small claims court commissioner.
Yes, I do.
Still?
I do assist in the small claims court as a commissioner because we don't have the luxury of many practitioners who avail themselves for that duty.
You're a senior magistrate now.
Yes, Chief Justice.
And I know that you've acted as a regional court magistrate for a spell.
Yes, Chief Justice.
May I ask why? Well, we know the traditional trajectory is to ascend from the district court to the regional court, all the way up to regional court president. Why, in all these years, why have you remained? I suspect you were asked this very question last time you were here.
Yes, Chief Justice, I remember that question. As we may all know, the regional courts were predominantly dealing with criminal work. That is the first reason. And I was not so much interested in depriving myself of the civil litigation, which is mostly available in your magistrate court, which is your district court, and which has assisted me a great deal. That is the first part. The second part is that in the magistrate's court, you have the opportunity to deal with various kinds of matters that affect your people. You would be approached for a simple, maybe not as simple, but almost an awkward request that we would like to know what can we do to have a reburial of a member of our family who was buried maybe whatever many years. Those things, you would get an application or a request that we want to picket, we want to march, and we are told that we must come to the magistrate's court. It allows you that opportunity to interact to a larger extent in the magistrate's court, and that has assisted me because it was, to me, an exposure and an experience to know the plight of our people more at that level than in the regional court, where probably I would be in isolation of dealing with criminal work, which I accept now that the civil jurisdiction has been extended. And of course, I must say that for a regional court magistrate who has never had the advantage I've had, it takes years. It takes years for one can affirm herself or himself to say, I understand civil work. So those are the advantages that I had, which did not really prompt me to easily say, let me leave the magistracy or the magistracy in the district court and go and sit in the regional court, much as I've acted in the regional court.
Thank you, Mr. Ngomse. ADJP, do you have questions for this candidate?
Thank you, Chief Justice. Good afternoon.
Good afternoon, ADJP.
I just have one question for you.
Yeah.
How long on average has it taken you to pen a judgment? On
average, I would say 2 2.5 months. In some instances, it would even be less than that. I say that, ADJP, owing to my experience when I was in the North Gauteng High Court, where one had to, as a policy, say, I'm not going to sleep. And it proved benefits for me because I was able to produce those judgments within weeks. As a result, when I went to the Eastern Cape Division, I had hardly had matters which I carried along.
Thank you. Thank you, Chief Justice.
Premier?
Thank you very much, Chief Justice, and good afternoon to Mr. Mumse.
Good afternoon, Premier.
Sir, I don't have much, but I will just be keen in case you are considered by this SC. What value and contribution do you think you can add to the Eastern Cape Division?
I think, Premier, amongst the innovations, probably I'm using a wrong word to say innovations, but amongst other things that we need to look at, it is to emphasize on the case management, insist on Rule 37A, which is a mechanism meant to try and shorten the matters that appear before us in terms of really issues that are not supposed to be delaying us, not to delay us. I think that's one thing that we should look at. It is to try and shorten matters that we deal with. To the extent that I know this question arose at another interview, that even on appeals, we would be able to shorten what is usually delaying in order to try and expedite matters. This is one of the dreams that one has. The other one is, I am used to rural areas in my work, and I have enjoyed it. I have started to work as a magistrate in Ngushwa, as you have heard, and I went to Komani, semi-rural, but under Komani I have a number of other most rural areas, about 9, which I go and sit often in those areas. I cannot see why, as court, I'm referring to the High Court now, why I cannot leave the comfort of Bisho, the comfort of Makanda, and go to Stainsburg and sit in Burgerstock and sit in Molteno. I cannot see why we could not look at that as well. That is something I would certainly advocate for, to bring access to justice closer to those people. And not only that, I'm dealing with a case in Dabankulu. It's a murder case. The accused persons come all the way from Mount Fletcher to that case in Dabankulu. But not only that, it becomes an empty room, a cold room, when there's not a single member of the victims that can attend that court. They can't attend it because how would they travel from Mount Fletcher to Ndabankulu now and again or every day to go and listen to that case? So it becomes an empty room. Now, when that case gets finalized, even were I to convict, even were I were to sentence They will only hear it in newspapers. They are not part of the court. So in my view, those are things that we should look at in trying to realize the access to justice.
Commissioner Training, followed by Minister.
Thank you, Chief Justice. Mr. Ngumse, you are a magistrate in Komani, and you've mentioned where you work and the rural villages that you've serviced. The Moseneke Commission made a finding about court rationalization that the High Court should move from Makhanda to Episho. What is your opinion on that controversial matter?
When we look at the socio-economic dynamics, particularly in a province like the Eastern Cape, that would not be a bad move. Besides the fact that, and I think it's just an ideal that the seat of the High Court must be where the seat of the province is, in this case, Bisho. Besides that, but if you look at the geographical setting, I think Bisho would be more central or serve its people in a better way than it is now. I know, Commissioner, that this is a sensitive issue because there are proponents for the seat not to move. But I think if we are selfless, we would see the benefit of everybody enjoying the access to justice nearer. That's my view.
Thank you, Chief Justice.
Anyone else, Commissioners? JP Tlalitse? Oh, sorry. I forgot Minister. Then you, JP.
Thank you very much. I wanted to follow up on this issue because I'm noting that you've got experience almost over 25 years. My apologies, I must greet first. Good afternoon, Mr. Ngumse.
Good afternoon, Minister.
I pronounce it correctly?
Yes, you pronounce it correctly,
Okay.
Minister.
My apologies, it's been a long week and long day. Just to say, because I'm really listening to you talk about the access to justice.
Yes.
And the impact, especially in remote and rural areas. I think that's why I want to go to, and following what Commissioner just asked now about the rationalization, though he calls it a controversial, I don't know why he calls it a controversial proposal. But the issue that I wanted to maybe for you to elaborate, because I think from the point of being a magistrate, not only even in terms of those who participate, the issues of the police who have to transport, how has the current environment impacted on even the time it takes to conclude the cases, arrival of the prisoners if they have been kept somewhere in time because of the distances?
Indeed, Minister, that is another huge challenge that we grapple with in the rural settings. I will make an example to you now. Prisoners for Alwal North are kept in Gqeberha. Prisoners for Burgersdorp, which is 50 kilometers away from Alwal North, are kept in Middelburg. Those prisoners would arrive in more often than not after 11 o'clock. The court, therefore, is hamstrung because those prisoners have to travel with the police from those far-flung areas. So certainly, the issue of distances and access to courts, coupled with the other nuances, like the one that you are bringing, Minister of Prisoners traveling, it's a huge problem that has to be also factored into and be dealt with if we are realistic about this access to justice. If I were to go back just a little bit, in the Tabankulu case I'm talking about, the police would assist with transporting those accused from Mount Fletcher to Tabankulu. Definitely, if those accused are not there by 10 o'clock, you'll have to understand, because they are still traveling with police. And you take it, in fact, as a bonus if police do that, because in that case, the accused are out on bail. But it's a bonus in that when the police stop doing it, then those people must travel on their own. When do they arrive? It's anybody's guess. Case I'm dealing with in a place called Venterstad. Many people won't know these places I'm talking about, but I've grown to have passion for them. Venterstad, it's on your way to Colesberg. It's close by to Credock. The witnesses in that case stay in Steinsberg, and they've got to travel to Venterstad. Because of the geographical setting, the investigating officer had to assist the court by fetching those witnesses herself with a police van to come to court. And if the investigating officer is sick for one reason or another, those witnesses never reach court. So these are the challenges that when we talk about realization of access to justice, they are really a package which we need to be activists, and which I, who has worked in these places, fortunately, similarly in Mushwa, Pedi, which has villages that will go as far as Mpegwe and Fish River, and the court is in the little town of Mushwa, you can understand the challenges that our people experience.
Then you, JP.
Thank you, CJ, and good afternoon, Mr. Ngumse.
Good afternoon, JP.
Yes, what a promotion. Yes, thank you. At your previous interview, you were asked as to whether were there any commercial cases that you were just on at the time. And you said you do not have then, you will rely on cases which were still in progress at the Pretoria High Court.
Yes, Chief.
What is your answer now? Has it changed or does it stay the same, and if so, what?
Well, JP, those matters had been finalized, which I was dealing with in the North Gauteng High Court. So that's the experience that I would claim now, much as I have not had an opportunity in the Eastern Cape Division to deal with major commercial matters. I have dealt with one in the Eastern Cape, yes, of a hotel in a place called Berlin. So, yes, I have, here and there dealt with some of the commercial matters.
Yes. Your last acting stint was in 2022.
2023, yes.
2022, in December.
Yes, JP, yes.
Knowing that there are always new developments in law, how have you kept yourself abreast with the developments, seeing that there's already 3 years and 3 months that you have not been in the High Court?
Yes. Well, JP, because I always had the aspiration, I had always kept myself abreast with what is happening, the developments, case law, and I was more interested in what is happening, as if I'm there. So yes, much as it has been a time since my last stint, but I am still quite very advanced in what is going on. I am reading quite a lot. I'm keeping myself abreast, the judgments that come out. So yes, I've kept myself in tune on reading for myself in terms of legal developments and authority.
Giving you a blank check, any development that you can mention that you have noticed since then up to now?
Well, if one were to refer to the legal authority from the Constitutional Court, I'm not sure whether would that satisfy the question.
Just one thing you can mention, one just to bolster your answer and to keep yourself abreast.
I have been interested in reading on the topical judgment of the Constitutional Court regarding Section 10 of the Customary Marriages Act, which was something spoken about. So, typical of that, I would then read other matters that come from the High Court or the Constitutional Court or Supreme Court of Appeal.
Thank you, CJ. Thank you, Mr. Mumsa.
Thank you, JP.
DP?
Hi, good afternoon, Mr. Mumsa.
Good afternoon, DP.
Thank you. Okay. I just need your comment. The GCP says you don't have sufficient experience in the High Court. What is your comment?
I may have missed that part, DP. However, if I were to just answer DP from the question, I have had an interesting experience in the High Court. In the Pretoria North Gauteng High Court, which I've indicated is a busy court, without any assistance, I came out from that court getting thumbs up from the former Judge President, the DCJ, even in the Eastern Cape Division. There's never been complaints on all the judgments that I've written, which I've indicated maybe in the region of 76. There's never been any complaint. I have dealt with motion court of over 120 cases in Mthatha. I've dealt with heavy matters in Gqeberha. There's been never a complaint. In fact, in the Eastern Cape, there's only one judgment of mine that was overturned. It is the Manqina judgment, but all other judgments have passed muster. Even those that have been taken on appeal had been confirmed. In North Gauteng High Court, I have no judgment that was taken on appeal and overturned. I see there is a mistake somewhere, I'm not sure whether it's the GCB, I think so, that refers to two judgments of mine that were overturned. No, it's one judgment. The other judgment that was overturned, it's a judgment in which I sat with Judge Mandisa, which therefore I was no scribe on that judgment.
All right, thank you very much, CJ. For your own benefit, my question arose from paragraph 14 of the GCP comments. Thank you.
Well, you may not have been a scribe in the judgment, but you did concur in the judgment, not so?
Yes, I did concur, CJ.
Commissioner Mangel?
All right. Yeah.
Yes, it is exactly that point that I wanted to talk to you
All right,
about.
okay.
And the CJ flagged it.
All right, right.
And you accept that?
Yes, Commissioner.
Once a judgment, you are part of the panel.
It's attributable to me.
Yeah.
All right.
Because the SCA says that the panel considered irrelevant issues. But in the scheme of the judgment, the SCA judgment, it is said that, one, you downplayed the significance of the legislation meant to protect members of the public against practitioners. Two, you failed to, you ignored precedent, and it refers to two judgments, LSNP versus Mamato and Hewitson versus LSNP, in terms of how a court adjudicating a complaint from the LPC should approach the matter and what considerations should be taken into account.
Yeah.
Yeah.
I accept that, Commissioner. I accept that.
Thank you. But otherwise, an impressive output. It's surprising that you were never called back since 2022.
It is. May I not comment, Commissioner?
Please don't.
Let me know.
Thank you, CJ. Good afternoon, Mr. Mumse.
Good afternoon, Prof.
I must say that your mention of Pedi Ngushwampe when it takes me back home.
Oh, man.
I just wanted to ask you if you can take us through your process of writing a judgment and what informs it.
Well, the process of writing my judgment, I wish to understand properly whether the structure of the judgment or not the structure, but
what informs it. You can also talk about the structure. I just want to get sense of what goes into your thinking when you're about to write a judgment.
Well, first of all, Prof, it's for one to determine what is the cause of action and what are the issues here. What is the relief sought by the applicant or plaintiff in this particular matter? What is in the notice of motion for me to understand what really is it that I must deal with? And then I would certainly then apply myself to those constituent elements. I refer to them as constituent elements of then the issue before me, and then start from there, understanding what is it that is the cause of action here, and what relief is sought by the parties. And then, of course, from there, I elaborate.
Thank you. Thank you, CJ.
Thank you, Prof.
Anyone else? Commissioner Steinberg?
Good afternoon.
Good afternoon, Commissioner.
The judgment that was overturned on appeal that was spoken about earlier.
Yes.
The criticism was about, I suppose, the judge straying out of his lane.
Yes.
I wonder if you can talk to me about how Paja and the cases that have been decided using Paja as a legislation deal with when a judge should substitute an administrator's decision for his own decision.
Well, I guess, Commissioner, we are talking about the Manglina judgment. Yes, the Manglina judgment. Well, I'm not sure whether should I first explain how I got off the tangent. Is that what the Commissioner wants?
No, I'm asking, based on that criticism.
Yes.
I'm asking a more general question. That Paja and the cases that have been heard around Paja give guidelines to judges about when they should substitute an administrator's decision with their own decision, and I'm wanting you to talk to your understanding of that issue.
I think, Commissioner, and please help me if it's me who is lost. I think I don't follow you quite perfectly if you say the judgment dealt with perjury, because that one did not deal with perjury.
No, I'm not saying the judgment dealt with perjury.
Yes.
I'm saying that perjury gives judges guidelines.
Right.
And I'm wanting you to talk about, in general terms, what those guidelines are. When judges should substitute a decision of an administrator for their own decision, or when they should remit it to the administrator to remake a decision.
Well, it is in instances where a decision would not make any sense to be referred back to the administrator, and that the court can look at whether it should not, without usurping the powers of the administrator, but then effect on that decision what would have been the case. There is one decision that comes to mind, and unfortunately now the citation thereof is just missing me, which I had to deal with, where the administrator in that particular decision would not make a decision for an applicant for mining rights, to get a license. And of course, there was a complaint, an appeal to the next level, to the minister, and then the application was for the court to make the decision for the minister. In that particular matter, I did not fall into that trap. Of course, perjury was applicable there, of making the decision for the minister. I referred the matter back to the minister. So I'm trying to say it is in certain instances where the decision would be obvious that the administrator would have taken, and of course maybe the period that would guide if the court should rather insert that decision for the administrator.
So what would make it obvious for a judge to make the decision himself or herself? Give an example.
Well, in a case where the administrator is not taking that decision, which she or he should obviously have taken in that matter.
No, that's not correct. Then it has to be referred back to the decision maker to make a decision. The courts have said it's things like where it's entirely a matter of law, where there's bias, where the decision would be a foregone conclusion.
Yes.
There are some listed grounds, but they're exceptional circumstances. And one of them certainly isn't where the administrator failed to make a decision.
I agree, Commissioner.
Thank you.
Thank you.
Anyone else? Thank you, Mr. Ngumse. We have. Oh yes, sorry. Commissioner, how could I forget? Please.
Mr. Ngumse?
Yes, Commissioner.
Good afternoon.
Good afternoon, Commissioner.
Yes. I note that your last acting stint as a judge was in 2022.
Correct, Commissioner.
But of course, as a judicial officer, you would have been aware of the anti-sexual harassment policy?
Yes, I am aware of the policy.
Have you acquainted yourself with the policy?
Yes, Commissioner, I have.
Are you willing to subscribe to it?
Yes, fully commissioner.
Do you have any further input or comments to make about the policy?
Not at this stage, Commissioner, because it is a document in progress and that there is ongoing training regarding the policy. So I believe that as time goes, it becomes a living document. There can always be suggestions made to the policy.
Thank you, CJ.
Thank you.
We have indeed finished now.
We have.
Thank you very much for making the time for us, Mr. Ngumse. You're excused.
Thank you very much, Chief Justice.
I know your village.
Thank you so much.
Has there ever been a judge in that Limote village?
Come again, Chief Justice.
Has there ever been a judge in that village, from that village?
Not from that village, Chief Justice. Not from that village.
All right. You are well, I can see.
I am, Chief Justice, as are the circumstances.
Okay. You're a practicing attorney?
I am.
In Umtata?
In Umtata.
All right. You studied there?
Yes.
At Wusu.
Yes, when it was UNITRA at the
Still
time.
UNITRA.
Yes.
And obtained a BURIS and LLB
And
degrees.
LLB. Yes.
Okay. For a brief spell, you were a sales rep or
Yes.
Med-Shield.
Med-Shield.
Did you sell insurance?
Yes, I did. It was for a very short time.
Were you any good at it?
I wasn't. I think I got only 2 clients.
Oh, that's something.
Yes.
All right. Then you decided to go and do your articles of clerkship with Hughes, Chisholm and A.
Yes, I was there as a clerk. Yes.
All right. You started just after I'd left for Cape Town, so we missed one another by a month.
I think I arrived when we were still there in 1999, Chief Justice.
Sorry?
Were you not there in 1999? I think you were still there when I was arriving at...
No, well, in June I was still there, but in July I started acting in the Cape Provincial Division, as it was then called.
Yes.
Okay. So you did your articles with Hughes successfully and worked as a PA at Mlonyeni and Lisele Incorporated.
King Williamstown.
King Williamstown, all right, but only very briefly.
Yes.
Then you moved back to Mthatha.
Yes.
All right, and you were PA there for another 6 months or so.
Yeah, a very short time with Vianney Kwebinlala.
And then started your own practice
in August 2004.
All right. And you are still running that practice to date as its director?
It is the position.
Sole director?
Yes, I am.
All right. What kind of work do you do?
Yes, it is a general practice, Chief Justice, covering a lot of work. The kind of work we're doing is contractual, commercial work. Constitutional law is the legislation, which is NCA. There is a lot of work that is in that office. We're doing intellectual claims against the state, for instance. Criminal law, that is the criminal work, is what we are doing as well, even though it is not too much. But you'll remember, Chief Justice, when we were still doing, it was in 2000, around 2000, there was this legal aid that was outsourcing the work because they didn't have the attorneys in-house. Then I managed to get much of criminal work when I was starting my practice from the legal aid. And I did a lot of it. Now with time that didn't, it reduced. I don't have much criminal work now. Another sphere of work, I've said contract is there, but there is a whole range. As I'm saying, it is a general practice. This whole range of work that I'm doing.
Okay. You chair the what is it? The
Church board? No, tax board.
The tax board. Yeah. How did you get involved?
I cannot say because I was called by them. I think it was as a result of the JP who forwarded my name there because I didn't make any application, but I was called by the revenue services to say that they want me to be part of the panel there, and I accepted that. And I was appointed since 2024. And
your term runs until 2029?
Yeah, until 2029.
All right. How is it going?
I haven't been given a work to do ever since I was given. I don't know the reason, but I was not given.
I hope you're not just window dressing.
Come again, Chief Justice.
I'm saying I hope you're not just window dressing. It's been 2 years now. That's quite old.
I cannot tell you the reason, Chief Justice. No one is communicating anything. And I went to the orientation and the manner in which we should do our work, but from there, no work was given to me.
All right. Just out of curiosity, you describe what is seemingly a busy law firm.
Yes.
And I just came to know recently that Umtata, small as it is, has a staggering number of law firms exceeding 200. How do you get enough work to sustain
Yes.
this seemingly busy practice?
Yeah, proximity to the community yourself. That's where I get most of the time the work to do, because those communities, most rural, and I'm closer to them. And there are a lot of things that are happening with them. Now I make it my duty to take those things, those challenges they are facing to the courts. And that's how I managed to get a lot of work. And that lot of work goes to the High Court. And ever since 2004, when I was starting my office, was bringing those cases in the High Court, and I practice there mostly.
Right. You've acted as a judge in that division since 2019.
Since 2019, Chief Justice. From 2019, was again appointed to act in 2023. From there up to today, and my last appointment ended with the term on the 27th of March.
How many weeks is that in all? Yes, actually.
44. My calculation, Chief Justice,
44
came
weeks.
to 44 weeks.
All right.
Yes.
And in your questionnaire, you say you've sat in civil court.
Yes.
You've done motions, civil trials and appeals, and in the criminal court as well. Criminal trials, bail appeals, reviews and petitions.
Yes, that's what that's what I'm doing. That's what I did. And my judgment reflect that.
Have you written any judgments?
92. There are no less than 92 judgments, that is written judgments, in a number of fields. As I've said, Chief Justice, that I did motion court, that is unopposed and opposed motion court, and I wrote judgments there in a number of those motion proceedings, that is mostly opposed, in a number of applications. Now I sat in criminal appeals. I wrote judgment. I was given an opportunity to be a scribe. I wrote there's some judgment, especially in Bishop and in civil appeals as well. I sat and I wrote judgments as well there. Civil trials, a lot of them I wrote, and yes, reviews. That is automatic reviews. I wrote judgments even there. In every area, I was given an opportunity to do some work. I wrote.
Have any of your judgments been reported?
No less than 4. I calculated up to 4 that are reported, Chief Justice.
Okay. A matter of concern, the BLA has flagged an issue about your judicial temperament, as they call it, and they say you have even refused even the most insignificant requests made by practitioners, such as asking to go to the bathroom, that's taking a short comfort break. And I got worried about that. You know, patience and empathy are key qualities in a judge. Is there any truth in this complaint about you?
Chief Justice, there is none. Let me start by saying there's paucity of information around that complaint or around that concern. Context is everything. Remember, Chief Justice, I said in Umtata, Kwagombo, East London, Bisho, Gqeberha, Makhanda. I don't know where this happened. I don't even know the practitioner, if it is a practitioner, whom I refused an opportunity to take a comfort break. And that is against what I am. I know myself as a person who is accommodative, who allows people to do. Like, for instance, if now they're making submissions, then I allow a person to make his or her submissions to the detriment of me being delaying the proceedings. Now, asking that one must be given an opportunity to take a comfort break, that is so unlike me. I can't even comment on that because I don't even know what is it that they are talking about, and I cannot meaningfully respond to it because of lack of information. Because if now at least was given the person whom I'm said I refused an opportunity to take a comfort break, I would understand, at least I would be able. If I was given information about the place where this occurred, I would be able to favor this commission with information. But generally, Chief Justice, I can tell you, there is a fine line between being assertive and the issue of a negative temperament. If, for instance, you are saying when they are requesting to take unnecessary adjournment solely to delay proceedings, and you say that no, this is the position, and then we're just from adjournment, and then we cannot. Now, I'm not just giving you a general opinion, but I don't understand, I don't know this complaint or concern, where it comes from. I really don't know.
Mhm. When you submitted your application form, you listed a reserved judgment from September 2025 from the East London Circuit Court,
Yes.
and a apartheid matter in Bisho, at the Bisho High Court. What is the status of those matters?
That judgment was delivered on the 10th of February, Chief Justice. Yes, with regard to the apartheid, availed myself, that is sorted the matter, secured the week of the 7th, that is the recess, the week of the 7th until the 11th for me to proceed with that matter. But unfortunately, one of the practitioners was bereaved and he could not come to court, and as a result of that, that matter couldn't proceed either. And it is still reserved. It is still a parted matter that I haven't finished.
May I find out what caused the delay with SNR Electrical, the East London matter?
Not only it, I think there are three, Chief Justice, there are 3 or 4.
You mentioned one here.
Yes, no, therefore, these are matters, Chief Justice, that were complex in nature, including this SNR. The other one is maximum profit, and Sitato is the third one. They were very complex. Now, those judgments I reserved together with many other reserved judgments because I was doing back-to-back motion courts, because I was from Makhanda to East London, and I picked those reserved judgment in Makhanda. And when I was going to East London, that is Kwakombo, I picked other reserved judgment following 1 week following the other, no space in between. It was as a result of that, and they were complex and voluminous, because it's those judgments when you put and then it just scattered all over the desk, and if you put it up and then it goes up the wall. They were the kinds of judgment I was dealing with, but nonetheless they were little more than 3 months, but still less than 6 months.
Well, if it was delivered, this one you've listed was delivered in February.
10th February.
having been reserved from September 2025. That's not
Yes.
2 months, that's 6 months.
Is that
Unless
6 months?
Unless
Exactly.
my arithmetic is wrong.
Yes, but let me put it in this way, that none exceeded 6 months, although they were more than 3 months.
All right.
Yes.
Okay, I'm going to hand over to ADJP Dawood. Questions to you.
Thank you, CJ. Good afternoon, Mr. Zono.
Good afternoon, ADJP.
Mr. Zono, what unique skill sets will you be able to bring to our division?
Come again, Chief Justice.
What skill sets will you be able to bring to our unique skill sets will you be able to bring to our division?
An experience of 22 years is something I think I will carry and bring it into the division. Now, the access to justice in the form of a turnaround. Out of 92, I've only said that it's only 4 judgments that were over 3 months. All of other matters or judgments were delivered either within 2 weeks, but did not exceed a period of 3 months. That is the energy I will bring into the division. Now, it comes with the age I have, because I have this age which still allows me to be energetic, of a good health as well. That will contribute to the bringing justice to the people, because delaying judgments sometimes is perceived to be a denial or a delay in bringing justice to the people. That is what I will contribute. I'll come with the experience, the hard work and dedication, speedy delivery of judgments. This is what now the judicial record showed that I'm able to do that.
Thank you, Mr. Zono. Thank you, Chief Justice.
Premium.
Thank you, ADJP.
Nkosi kakhulu CJ. Molo Mhlekazi, good afternoon. Mr.
Good afternoon, Premier.
Firstly, just quick comment. Thanks for that commitment on agility.
Yes. Thank you.
Agreeing with you that justice delayed is justice denied.
Thank you, Premier.
But for me, someone with an experience, as you have indicated, surely you would have a picture of what are the issues, teething problems that are currently characterizing our system, particularly in the Eastern Cape. And what do you think needs to be done? What value do you think you'll be able to add to ensure that we are able to be much more effective?
Couple this with what I've said when answering to ADJP's question, because this is what I'll be adding to the division. Now, the problems that were there, I'll talk about the missing files, because there was that problem. And that problem seems to be slowly eradicated because of the introduction of the online court system. Because it seeks to eradicate, because now there is no more of that problem, that of missing files that we're experiencing as judges, because we're continuing with the matters on temporal files in some instances. But now, if it happens, it is happening at a very low rate. But now the files are always there because of the online system. I will support that this online system, if now it has problems, that they must be resolved, because it appears to be working for us to eradicate that problem of missing files, because it was a major problem for us.
Commissioner Trolley.
Thank you, Chief Justice. Good afternoon, Mr. Zono.
Good afternoon.
With regard to the Moseneke Commission's recommendation to relocate the Makanda High Court to Bishop in 2022, there have been 4 or 5 previous attempts to do so in the past 30 years. and it is now 2026. And after a number of gazetted extensions, it is still being opposed. Hence, it is described not by me, but by opponents like the Makanda High Court Action Committee as controversial. What is your opinion on the relocation and rationalization of courts in the Eastern Cape?
Firstly, that report, thank you, Commissioner. That report seeks to give effect to the section that is very important, Section 34 of our Constitution, access to justice. Now, if you take Bishop as our seat, that is the main seat, we relocate the main seat to Bishop. Now, looking at centrality, at how central Bishop is in the province of the Eastern Cape, it means that everybody will be able to arrive to access justice better than it was or it is today. It means that that will be a good move to access or to bring or to bring access to justice to the people of the Eastern Cape. Because if you're coming from the far-flung rural areas in the Elliot Dale, wanting to have access to the seat of the main seat of the province, means that you will have to arrive, you'll arrive earlier than you would if now you're going to Makanda. If you're coming from Bizana, for instance, you'll arrive earlier than you would if now you're going to Bishop than going to Makanda. Now, the whole purpose of access to justice will be achieved if now this report is accepted by all and it is given an opportunity to be implemented.
Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Mrimang?
Thank you, Chief Justice. Good afternoon, Advocate Zono.
Good afternoon, Commissioner.
Just curious also on the on your ordering a municipality of local Ebi Kuma local municipality to construct an access road.
Yes, Commissioner.
Yes. Does the court have an inherent jurisdiction to instruct the municipality to broaden the provision of basic services like access road?
I didn't get that, Commissioner. Can you please come again?
Does the court have a discretion?
Yes.
To order a municipality to construct an access road? Is that not a work that falls really outside the ambit of our courts?
Yes. The order, I think, I don't know where this judgment is in my bundle, but the order that was granted there was to compel the municipality to take all the necessary steps that would make that road to be constructed. Now, it is a constitutional imperative and obligation, like it is a statutory obligation for the municipality to do what now was compelled to do, that is construction of the roads, of the access roads, is a constitutional as well as statutory obligation. Now, a mandamus was the perfect tool to say, do what the law say you must do. Therefore, the court has that jurisdiction to compel the parties to do what they did not do in terms of the law. Thank you, Commissioner.
Thank you, Advocate Zono. Thank you, CJ.
Thank you, Commissioner Mrimang. JP Tlaleti?
Good afternoon, sir.
Good afternoon, JP.
Yes. Nadel says you should be afforded more opportunities to act, especially in different jurisdictions. And also that the GCB seems to be suggesting that in a matter of tax, security services, those corporations versus Simekasi, you refused leave to grant leave to appeal, and the SCA granted leave to appeal, and it made a finding that in that judgment, you did not make any credibility findings in reaching your conclusion.
Yes.
Yeah. What would your response be to the two?
Yes. I've seen the comment by the Nadel saying that I must be given, or I should be given, some more opportunities to act. They are building that on the fact that I am still young. Yes, I am still young, but that cannot be a reason for me not to be considered for appointment, because being young, I think, is an advantage than a disadvantage for me to be considered for appointment, because they were building that only on my age, and which I say my age is advantageous. Now, the judiciary will benefit better if now I start when I am at my early 50s than when I'm old, when I still have energy. They are not saying that the judicial record, written judgment of about 92, have made some mistakes which are of a nature that I am inexperienced or am unable to deal with the legal issues, or I'm unable to apply correctly the law into the facts. Coming to the Seneka's matter, it was in 2019 when I dealt with that matter. Yes, the Supreme Court of Appeal, or the full court, that is Seneka's, the full court criticized me of having failed to evaluate properly the evidence and failed to make credibility findings. Now, from there, Commissioner, you'll have seen out of these 92 judgments that have grown, there is no complaint at all. A certain number of trials, I do evaluate the evidence properly. I do make credibility findings where necessary. Therefore, meaning that I've grown significantly from that moment. Therefore, it cannot be a reason for me not to be considered for appointment. Thank you.
But then, objectively speaking, there are about 5 matters in which there were applications for leave to appeal against your judgments, and in all these matters, you refused leave. What is not known is what happened ultimately to these matters.
In some of them, I was taken on. The Supreme Court of Appeal was petitioned, and then those petitions were refused.
I see. And then they say there's still the GCB at 5.1. They say there is insufficient information in your questionnaire to draw any conclusions about your personal commitment to the values of the Constitution. Would you prepare any comment?
Yes. Gleaning it again from what the AFT is saying, that now, not only because I grew up and I'm much steeped in the rural setup, but I did cases. Now I cause access for those people in the rural areas to justice, and I successfully, many circumstances, fought for them, they attain justice. Now that judicial record is showing in a way transformative agenda that I'm able to use my skill, my profession to transform.
Well, I thought they are referring to constitutional values in your judgments, not your role in transforming society, especially in the rural area as you refer.
That is as far, Commissioner, as I can take. because I think it is part of transformation to fight for those to attain justice. But that is as far as I can take.
I see. So thank you, CJ. Neela asked a further question, but I know I'm restricted. Thank you, CJ.
JP. Commissioner again.
Thank you, CJ. Good afternoon, Mr. Zono.
Good afternoon, Commissioner.
Thank you. In relation to the comment by Nadel that you are young, and you have just turned 52 this year.
Yes, I'll be 52 in November.
That by no means makes you young. There are judges there are people who ascended to the judiciary when they were far younger than you are.
Yes.
You can talk about the DCJ, JP Hlophe, Justice Throne, and the current Chief Justice.
Yes, thank you, Commissioner.
You've got nothing to worry about. In fact, it is an advantage to the judiciary that you're coming in.
Thank you.
There is a matter of, let me get it here. It's worrying me. Lindega Nonwai and Mazuta versus Kin Sabata Dalinyabo municipality.
Come again with the name, Commissioner?
Non-nai.
Non-nai, yes.
Yeah, it's not in your bundle. I cannot blame you. If you can't deal with it, that would be fair enough.
Yes.
That matter was about a review application. The applicants were the occupants of a property. The municipality disconnected the power on the basis that the owner of the property had authorized them to disconnect that power. So the applicants came to you or to court, and you presided over the matter, and they were saying that they are asking the court to order the municipality to reconnect the power. You dismissed that application on the basis that they were not consumers of the electricity. And I failed to, and you relied on the municipal policy, on the fact that they did not make an application to be provided with power. And secondly, you said that the municipality, when it disconnected the power, was not exercising public power. Do you care to explain why you found that? Because in the judgment, it's not very clear to me.
Yes.
Why you say that the municipality was not exercising public power.
Yes, you'll correct me, Commissioner, if I'm wrong, but what was an issue in that matter was that there is an agreement between the ECDC, yes, ECDC and the municipality. And that agreement allowed the municipality to provide electricity to ECDC properties. Now, it was on the basis of the cancellation of that agreement that power was disconnected. There was cancellation at the instance of ECDC of the agreement. That was the source of provision of the power to the ECDC properties. That property was an ECDC property. Now, it is on that basis that it is said that the doctrine of privity of contract was applicable, because only those who are parties to the contract that are affected by it. Now, the parties who came before court were not parties to the contract, neither did they have an agreement with the municipality or the ECDC. They were just people who just came into the property and occupy it without knowledge of ECDC and the municipality. And now the municipality and the ECDC terminated their arrangement, and there was no basis for the electricity to be provided if now the contract was cancelled or was terminated, which was the real source of the provision of the power. Another thing that I think it is there, you'll correct me again, because I didn't check that judgment, is that the bylaws, when they talk about the contract and the cancellation thereof, they say that a party who thinks that he needs that power must approach the municipality for him now to be responsible for the payment or whatever that needs to be an obligation between the municipality and that party. Now, according to the papers that serve before me, if my memory serves me well, the municipality more than once approached the occupants of the property to tell them that this power will be terminated. Now, you must know that if you want to have an arrangement with the municipality, take that opportunity. They did not, then I think it appears in the judgment.
We are pressed for time, but there's something fundamentally wrong with that.
Yeah.
Because the municipality cannot despoliate. Even if the municipality may have went to them previously and told them that they do not have the right to power, the municipality should have come to court to get an order to disconnect. You get where
I take that point. I take that point, Commissioner.
Thank you, CJ.
Thank you, Commissioner Poso. Your turn.
Thank you, Chief Justice. Good afternoon, Mr. Mumse. Oh no, well, sorry, Mr. Zono.
Thank you. Good afternoon, Commissioner.
On your way back, do say hello to the folks in Zitatele. That's my home.
Oh, yes. I didn't know that.
As a judicial officer, you must be aware of the anti-sexual harassment policy, are you?
I am. I am aware that it was introduced on the 9th of August 2024, and I familiarized myself with it.
And do you think it's implementable in its current form?
It is. It is implementable in its current form, because it is so important for it to be implemented, because it touches on a number of important rights of individuals. One of those rights is Section 9 of the Constitution, which guarantees the right to equality. No one should be abused or be treated in any manner on the basis of gender. And it touches on that. Now, it should, and the right to dignity as well is implicated in the sexual harassment policy. So it is so important for it to be implemented as soon as possible. Thank you, Commissioner.
Thank you, Chief Justice.
Thank you. No one else? Thank you, Mr. I'm sorry, my back is killing me. Thank you very much for making yourself available for this interview, Mr. Zono. I wish you all the best. You're excused.
Thank you very much, CJ. Thank you very much to the commissioners for the opportunity given to me. Thank you.
Oh, there they are.
That is, thanks, Chief Justice, that is understood.
Yeah. Well, thank you for coming back. We are grateful to you.
Yeah.
You obtained a BUris and LLB degrees from the University of Transkei.
That is correct, Chief Justice.
And then started working in the Department of Justice. Just take us through, I'm just trying to think of a quick way of doing this. Just take us through your career briefly. Just give us the highlights. And if I need more information, I'll ask you to flesh them out.
Yes, thank you, Chief Justice. The highlight is as follows. Immediately after I completed my degrees, I worked in Butterworth as a prosecutor on a voluntary basis. This is the stage when the National Prosecuting Authority then would give students an opportunity to work in court just to expose them and empower them. And the scope of my duties at that point was not to decide whether to prosecute or not, because I didn't have delegation. It was legal education and practice. From there, I was appointed at Zwelitsha as a public prosecutor, but I was a temporary prosecutor. Fortunately, there were posts advertised. I went for interviews after I was shortlisted. Then I was permanently employed as a public prosecutor. I started working, doing my practicals in Gqeberha. Then my station that was allocated to me was Butterworth. So in Butterworth, I was appointed in the district court. I didn't spend a lot of time there. I was elevated to a rank of a regional court prosecutor. I was working in a backlog court, which was known as Tramatex, a court that is situated in Nika Township.
You were there for 3 years?
Yes, yes, Chief Justice. And then I developed interest in pursuing my career in the prosecution. I applied for a job of a state advocate in Witwatersrand, as it then was. I spent some time there doing prosecuting matters on behalf of the state. I requested for a transfer. Then I was transferred to Makanda, DPP's office. From there, on the 1st of October 2006, I was appointed as a magistrate in Fixbeck. Some few years later, I got a promotion as a senior magistrate in Putadichaba. So in that area, I was a senior magistrate and the head of office. Then in 2015, in April, I was appointed in Zwelitsha as a regional magistrate. And this is where I am to date. Thank you, Chief Justice.
So how long were you in the National Prosecuting Authority?
I would say plus minus 5 years, Chief Justice.
And as a magistrate?
I've been a magistrate for 2 decades, almost, yes.
Yeah. And you are currently serving as a regional magistrate?
Yes, Chief Justice.
Okay. Since 2015?
Since 2015, yes.
All right. You have acted as a judge in the Eastern Cape Division of the High Court well, it transpired that you had acted for more than the period stated here. You said 61 weeks when you submitted the questionnaire, and you added a further period. How long is it in all?
The total is over 70 weeks, Chief Justice.
And when did you start acting as a judge?
I started in April 2023, but I was acting sporadically.
Yeah. Have you written any judgments as a magistrate?
A lot of judgments, Chief Justice.
Both in the district court and in the regional court?
That is correct.
In the civil and criminal law spectrum?
Yes, Chief Justice.
All right. And as an acting judge?
As an acting judge, I've written a lot of judgments, both in public and private law.
In the criminal court? Have you sat in the criminal court?
A lot, Chief Justice.
Have you done trials?
Trials, yes.
Appeals?
Yes.
Reviews?
That is correct.
Bail appeals? Well, you have
Bail
done those?
Yes, that is correct, Chief Justice. Actually, if I may just add, insofar as bail up, I've sat in the full bench with at least 13 senior judges so far.
Right. You have had a very active life in addition to being a mother of many children. Four, you say?
Yes.
Membership with the South African Women Lawyers Association since 2023. A member, then later a national secretary of AMSA in the magistracy, and involvement with JOASA.
Yes.
For how long? Since 2006.
Yes, that's correct, Chief Justice.
And you rose in that association.
That is correct.
To their executive committee.
Yes.
And more importantly, you have been an active member of the Women Judges Association, SAG-IWJ.
That is correct, Chief
since
Justice.
2009.
That is correct.
And you've done all the good work which the
Yes.
judicial officers involved with that body do.
Yes, Chief Justice.
And what is that work? Highlights of that work.
Yes, briefly, Chief Justice, when I was in a senior magistrate in Puta de Chaba, I recruited a lot of members for the organization, in particular the magistrates. And then we had a lot of programs. The one that I can remember vividly is a program whereby we were mentoring students. So I was actively involved in that program, and we even wrote a report to the executive about it. And then when I was in the Eastern Cape, we were doing breakfast wellness programs wherein we would invite people like doctors and psychologists to assist us with wellness.
You have garnered a wealth of experience, administrative experience, as a magistrate. Would you be able, if you are appointed to this position you seek, would you be in a position to assist the Judge President of the division with the administration of the division, including issues such as case flow management?
Yes, Chief Justice, I was going to mention that exactly because when the norms and standards were enacted, I was already a senior magistrate, so I was actively involved when that document was created. So when it comes to case flow management, I think I'm passionate about it, and I believe that I will be in a position to assist. And even currently, I do assist because I'm the manager of my own court. So I'm able to unblock whatever blockages come my way so that justice can be served as speedily as possible.
I'm going to hand over to the Objections Committee representative to discuss an objection. Is it objection or objections that were raised against this candidate, Commissioner Shebu?
Thank you, CJ. It's one objection. Sadly, it comes from my former husband. And the objection committee actually considered it. And most of the allegations were found to be untrue. She was actually been, a criminal case was opened against her, and the prosecution declined to prosecute. And also they alleged that she was cheating on the travel allowance, but nothing came to the fore. And the objections committee decided these are unsubstantiated. She's got a good standing from SARS, she's got a good standing from whatever body she belongs to. That's why we are not proceeding with it. Thanks.
Thank you. Thank you very much, Commissioner. Acting Deputy Judge President, do you have questions for this candidate?
Thank you, Chief Justice. Good afternoon.
Good afternoon, ADJP.
Have you acquired sufficient practical experience and expertise in all areas of law whilst you've been acting as a judge?
Come again.
Have you acquired sufficient experience and expertise in all areas of law whilst you've been an acting judge?
Oh, thank you. Yes, I would say yes, Commissioner, because I'm an all-rounder. I'm working in all courts, criminal courts, family courts. In fact, I've been exposed to criminal law, admin law, family law, civil law, and all other, the motion proceedings, opposed, unopposed, bail appeals, criminal appeals, civil appeals. So I've been handling all those matters throughout my acting stint.
How long on average has it taken you to pen a judgment?
Mostly 3 months, unless in exceptional circumstances, Commissioner. For instance, I remember there's a case wherein I applied for condonation, and that case was delivered after the period of 3 months had expired. So it's mostly 3 months and some days, except the case that I've just mentioned.
Thank you. Thank you, CJ.
Thank you.
ADJP. Premier?
Thank you very much once again, CJ. Thank you once again. Good afternoon to Ms. Tengani Mbagaza.
Good afternoon, Premier.
Yes. I think I must just appreciate that indeed perseverance prevails, your resilience as a woman standing up against all odds. But I will just be interested briefly on your understanding of what is called medical legal that has been really ravaging or eroding the baseline of the Department of Health. What do you think about that? What could be done from where you sit as a judge?
What could be done in terms of, Premier, if you may just clarify the question?
The medical legal, there's been these ongoing cases of medical legal that have been imposed more often on the Department of Health, whether it is said it's negligence and all that. But there's been a lot of funny things around it.
Yes, I think what can be done is to ensure that there is proper training with regard to the manner in which the patients are handled by the doctors, but that is not the responsibility of a judge. Once a case comes before a judge, then it is a responsibility of that particular judge to assess the facts, and once the facts are assessed, to see whether there was indeed negligence. And then from there, the court will be in a position to make a decision. Otherwise, that is insofar as a judge can go, is to only be responsible once the matter is brought before them.
Thank you, CJ.
JP, can you say?
Thank you, CJ, and good afternoon, ma'am.
Good afternoon,
Yes.
JP.
You come highly recommended by the Organization of Women Judges South African Chapter. NADEL supports your candidacy, the LSS Law Society of South Africa, as well as the Black Lawyers Association. Just one aspect that I want to clear up with you pertaining to the GCB. They make a comment at paragraph 6.3 that you may lack some form of an understanding of certain aspects of procedural law, and they refer to a matter in which they believe that you refuse to grant cost order on attorney client scale against the defendant in a default judgment, despite the fact that it was part of the agreement. What would you say to that?
Thank you, JP. I've seen the comment, and my comment is as follows. They have specified the court on which that order was made. And in my recollection, and in fact, I've verified it, that I was not in Gqeberha in February 2026. I've also realized that they made some few mistakes, which we corrected in the sense that they tendered an apology in writing, and this relates to a judgment that they thought it had been authored by myself. So in that regard, I did not make that order. Thank you.
Thank you. And then at 9.2.4, they say the candidate's ability to structure succinct, clearly structured and reasoned judgment dealing with crisply with the issues placed before her for determination could be improved. What would you say to that?
Yes, thank you for bringing that up. Insofar as that is concerned, I requested through the Secretariat a copy of that judgment that they were referring to. However, instead, they tendered an apology to say, actually, the judgment was authored by another candidate, and they apologized for that particular mistake.
Is this on this one as well?
Yes.
I see. Okay. Thank you, PJ. Thank you, Ms.
Thanks, JP. And just for the record, none of these apologies you say were issued by the GCB were placed before this body. We have not, well, speaking for myself, I've not seen them. They're not part of my papers.
Yes. It is unfortunate, Chief Justice. When I was here yesterday, there was a copy in this bundle.
All right.
The copy of the letter.
Just to confirm, I've seen them.
Good afternoon, Mr. Gani Bagaza.
Good afternoon, Commissioner.
The Moseneke Commission made a finding some time ago in the rationalization of courts in the Eastern Cape that the High Court of Makanda should move to Bisho. It's been controversial. There's been opposition to it. There still is opposition to it. What is your feeling to it, about it?
Thank you, Commissioner. I'm very concerned about access to justice because I've worked in rural courts throughout my life. I understand the frustration that is put in the society because people are traveling long distances for them to access justice. For instance, in this case, if the main seat is in Makanda, then it means somebody from Queenstown has to travel a lot of distance before they reach the courtroom. So I think it is best to support, and I do support the notion of moving the court to Bisho for simple reason that we need to promote access to justice, which in my view is a constitutional imperative.
Thank you, Chief
Thank you,
Justice.
Commissioner. Anyone else? Commissioner Poswani-Rotolo?
Thank you, Chief Justice. Ms. Tsengani Mbagaza, I wish to reiterate my sentiments that I stated yesterday, that you are really a pride and joy to see a woman who has struggled through adversity and continues to struggle with attacks coming from the domestic realm, and to see that you have ably raised 4 children single-handedly, an architect and 1 in medical science. You are truly an inspiration.
Thank you, Commissioner.
Having said that, I'll ask whether you're aware of the anti-sexual harassment policy.
Yes, I'm aware, Commissioner.
Have you acclimatized yourself with it?
Yes, I have, Commissioner.
Do you have any suggestions for improving it in going forward?
Yes, it's work in progress, Commissioner, and I forwarded my inputs to the acting judge president at the time they were sought.
Thank you, Chief Justice.
Thank you, Commissioner Poso. Anyone else, colleagues? All right, well, that brings us to the end of your interview, Ms. Tsengani Mbagaza. Thanks very much, ma'am, for coming, and wish you all the best. You're excused.
Thank you, Chief Justice, and thanks to the commissioners.
Regional Court President Dunyo.
Good afternoon, Chairperson of the Commission of the JSC, as well as the Honorable Commissioners.
You sound quite cheerful, so I'm not even going to ask how you are. Thank you for coming back, RCP. We appreciate it.
Thank you, thank you, Commissioner Chairperson.
You are Regional Court President and have been a magistrate for over 4 decades.
That is true, Chairperson. I've been a regional magistrate for almost 13 years and I have been a judicial officer since 1984, meaning 42 years to date.
That's a long service.
That is true, Chair.
Your legal journey starts when you studied at the University of Zululand, where you did a B.Juris.
Yes, Chairperson.
And then you would go on to obtain an LLB from UNISA and later a master's, an LLM from the Nelson Mandela Metropolitan University.
That is true, Chairperson.
The last 2 degrees obtained when you were already in service.
That is true, Chairperson.
Government service.
That is true, Chairperson.
So you joined the Department of Justice as a grade 2 clerk in 1981. That's what your application form says.
That is true, Chairperson. I think that was my second year at university.
You're just a young man then.
That is true, Chair.
Then in 1984, you became a public prosecutor, legal assistant.
That is true, Chair.
And you remained there for about 2 years before joining the magistracy in 1986.
That is true, Chair. But I was already acting since 1984.
As a magistrate.
That is true, Chair. Yes.
So you worked your way up through the ranks, senior magistrate, regional magistrate, to where you are today.
That is true, Chair.
And interestingly, you started acting in the High Court in 2011 already.
That is true, Chair.
What has taken you so long to be sitting there? Well, I know you've come not so long ago, seeking appointment to the senior bench, but what took you so long?
As I indicated, Chair, one reason was the fact that some of my colleagues were aspiring to be judges. I wanted to give chance to them, I think 4 times. But I had a good passion for being a regional court president because that work is productive. You can see things that you are doing and you can show the results. And I was interested in making the stability which our regional court has thus far.
So you, excuse me, you joined NADEL. You were a member of NADEL at some stage.
That is true, Chair.
But you have been consistently a member of AMSA for 25 years now.
That is true. And at one stage, I was also the chairperson of AMSA in the region.
Yes.
Being a member then of the national AMSA. Yes.
Well, we know what kind of work is done in the courts in which you've sat, from the district court to where you are. And I would imagine that you've sat in a whole range, the entire range of cases that come before those courts.
That is true, Chair. I attended various courses for civil, for criminal, for leadership, specialty in sexual offenses, specialty in commercial crimes, money laundering, and others. There are many courses that I have attended thus far. Even the intellectual property course which I attended with the judges also here in Johannesburg. There is a lot of courses that I have attended in my lifetime, Chair.
Yeah. And you did not do only that. you've been involved in a number of initiatives meant to enhance access to justice, performance monitoring of judicial officers for regional courts, and you have collaborated with colleagues in the production of handbooks on judgment writing for magistrates.
That is true, Chair. I have done many things for the development of our legal system in South Africa, starting from the performance monitoring tools for stats, which I developed after the conference of the visit by Judge Malanjun from Malaysia. And that tool was meant for the judicial officer who is managing to know what he is managing, as well as for the accountability of all judicial officers, which is a work ethic which applies all over the world today. And I also, during the load shedding period, came up with an idea that we must also have the recording devices like which we call Olympus. And I've been very fighting for that tool to be given to all regional magistrates so that they cannot have a day when somebody cannot be able to work at court because of that reason. Also, Chair, I also think the fact that I also, in my court, although I'm not the real person who was the author of that, but in my court, in the case of S versus Wilmot, I came to a conclusion which was later accepted even by the Supreme Court of Appeal regarding the similar fact evidence, which is quoted even in our books of law of evidence, as well as in a case of Bunyoti, there was a confusion or a disagreement by judgments in Mtata. I remember when I did that case, which was about whether the accused can also be charged for murder when one of the accused has died during the fight with the police or security guards. And that judgment was confirmed by S versus Nkosi. That judgment was of 2016 by Supreme Court of Appeal, which confirmed the same principle that the accused can be convicted for murder in the same way as I had decided. Also, I am of the view that I have also contributed to the regional court system in the sense that I encourage finality in our cases to the extent that I developed a system whereby there must be case flow blockages group, whereby each and every case flow blockage will be reported on that particular day. And since I sit in a lower court performance monitoring committee with all the heads in that group, meaning the police, heads of legal aid, heads of justice and all that, I try by all means to resolve the problem there and then so that there must be no case flow blockages in that particular court. And I have also encouraged judicial officers that in the last meeting that we had, that we must use AI, because I remember I was with you, Chief Justice, when we attended the J20 summit, where we were told that internationally AI is being used, but it must be monitored. And I found that AI is good in the sense of summarizing facts of a particular case, not in any other purpose, like analysis of the judgment. I don't agree with that one. And I have encouraged then judicial officers in my region that that can be used. And recently also I have found that even a program which is called Grammarly can be used when you are writing a judgment, and it makes your work much more easier, and it makes your judgments to be delivered immediately because they are not going to be sent to a researcher. Grammarly corrects your language as you proceed with the judgment. Then those things, I have shared them with the judicial officers in my region, and I'm of the view that those things will help the development of our law as well as the development of the production of in our court system.
You are one of the leading figures in the judicial leadership, and you sit in, you've alluded in passing to the stakeholders with whom you interact. I imagine you were referring to your involvement in structures such as the PEC and the NEC.
That is true, Chairperson. It is true that from the lowest level, I'm the chairperson of the Lower Court Performance Monitoring Committee, which is involving all the heads of departments in the region, where all of them, prisons, you talk about justice, legal aid, chief magistrates, they are all there. I think we are almost 11 or 12 members because at times we invite even the Department of Health to solve common operational problems. And that is the venue where I share the meeting to the extent that I am called upon even by some stakeholders who are not part of the meeting to solve some of the related problems. And then that meeting on its own takes all the problems that it cannot solve to the PEC meeting. And the PEC meeting is a structure which is chaired by the JP, and that structure also meets regularly in order to deal with the problems of the region. That is how we interact as the region together. And lastly, we also take all our problems to NEC, and those are the meetings I attend, and which I'm of the view that the experience that I have gained in attending those higher judiciary meetings is the experience that can also be used even in High Court to assist even the JP at times in those instances, because we take important decisions. For example, I remember I was once invited by JP Sangoni to attend another meeting in the region for the appointment, or where we were inviting or requesting the department to appoint Deputy Judge President. And that meeting went well, and that resulted in the appointment of the DJP of Mtata as well as the DJP of Bisho at the time.
All these skills you mentioned, this experience, could you use it? Would you be able to use it to assist the Judge President of the division in the running of the division if you are appointed?
That is true, Chairperson, because the skills of interacting with various individuals and various stakeholders is the best skill because it makes things possible. And it is my view that that interaction that I had with the stakeholders, for example, our division is vast. I know most of the areas, and I have been to all the areas of the Eastern Cape, and that will also assist me to deal with the issues which we know about particular areas. And in my view, that interaction also relates even to the other departments. I remember at one stage we had 100 days challenge, the one which was propelled by Alrin, and it was a challenge whereby we are trying to deal with the backlog. I remember the Premier of the Eastern Cape was also involved in that. I mean, I do have communication skills and I do interact with many people in my profession, and that has made my job to be much more easier because of that interaction.
Have you sat in all the seats of the Eastern Cape Division of the High Court?
That is true, Chairperson. I have sat in Mthatha, and that is the longest period that I was trained in Mthatha, because Mthatha is the most litigating seat, more than all others. And that is where I got my civil training, because I was not given most of the criminal work there. I was trained mostly on civil. And I did sit also in Bishop. And I remember during that time, it was the time of Judge Lodlo, who was there and who was very friendly and welcoming also. And I have sat also in Grahamstown, which is my place of home as well. And I found that also work is there. And I found that even work all the way from Mthatha is taken to Grahamstown. More especially when you deal with the duty, you will have cases arising all the way from Kanduli and Flagstaff coming all the way to Grahamstown. And I've sat also in Port Elizabeth. Most of the time, I'm still sitting in Port Elizabeth as I speak since the beginning of this year. Even last year, I was in Port Elizabeth, Chairperson.
You mentioned that in Mthatha, you said you did get a chance to sit in the civil court. I was going to ask if you've been able to produce judgments in civil law, because the ones you've mentioned as having been endorsed by senior courts were on criminal issues. So you do have sufficient experience in civil law, you reckon?
Yes, Chief Justice, I do have a lot of experience in civil, because that is the law I was trained in. Most of the time, as I indicated, that when I was in Mthatha, most of my cases were, I was only put mainly in civil, because I do have enough experience in criminal work to almost saying I should be called an expert in that regard, because I've been there for 44 years. But when it comes to civil, yes, we were doing civil as heads of districts, for example, when I was stationed in Mount Elif, and even when I moved to Grahamstown, it is only then that I did not do civil, because of the fact that in regional court then, civil was not there. But the civil that I have hearing in the computer, I have experience in property law, RAF, as well as matrimonial law, delict and contract, procedural law, including other laws relating to tenders. I did a case in Grahamstown 2023, which was also dealing with municipalities and tenders. And my experience in civil at this stage is very enough, to the extent that from the beginning of this term, I was given civil all the way. From Mthatha, I was at Mthatha. I went to Port Elizabeth. I went to Grahamstown. I went to Port Elizabeth again. I did duties 3 times, meaning a duty. One of the duties I had to do duty this week and the following week, which something which is not necessarily done in most cases, because of the fact that it accumulates, the judicial officer accumulates more cases, more especially from the opposed motion. Therefore, even today, or this term, I'm also doing civil in Bishop as we speak. I don't have any challenge when it comes to civil thus far.
You have declared 2 health conditions, but you have not told us if they are under control, they affect you in the execution of your duties. What is your state of health?
My set of health chairperson is very good. I have been having diabetes as far back as 2014, if I can remember, even the high blood pressure. I used, or my doctors have prescribed me something very good for me. I don't have a problem. For example, my pressure is, for my pressure, I use Coexfort, which is very good and very making more stability. And recently, I was also in Johannesburg, where I was given another type of prescription, which is very good. My pressure, pressure as well as diabetes is under control, because also I have learned something that diet is best when it comes to diabetes.
That is true. All right. And if you are appointed, you would still have how many years to serve until retirement? Well, over 10 years, like by my count.
That is true, Chairperson, but I heard whether that is true or not, that maybe if you have served plus minus 2 years acting, maybe that is deducted. I don't know how far true that is. If that can be true, it would mean then -2 from that 10 years.
But you could work as a judge until you're 75 years old.
I can't do so, Chairperson, because I feel I'm very much energized at this stage.
Thank you, RCP. Judge Daud, do you have questions for the candidate?
Thank you, CJ. Good afternoon, Mr. Donua.
Good day, Commissioner.
Your CV and responses to the Chief Justice has demonstrated the invaluable skill set that you possess and have acquired over your illustrious career. Aside from assisting with interaction with relevant stakeholders, what other unique expertise will you bring to enrich our bench?
I didn't get the last part of the question, Commissioner. What does that mean?
What other unique expertise, aside from from assisting with interactions with stakeholders, will you bring to enrich our bench?
Thank you, Commissioner. Interacting with stakeholders, I have found that it solves many problems. Although in High Court there are certain restrictions in relation to the fact that maybe you may not phone correctional services and say, please bring the prisoners today because I want to proceed with that case. In an instance where, for example, the prisoner has not been brought before court. That is the style that I've been using. But at one stage, I did ask the JP, the current one, to do the same, where I was finding that whilst I was acting in High Court, that it was not possible. I was not going to proceed with the case because of a particular case flow blockage. My view is that interacting with stakeholders is the most important thing. For example, I remember that at one stage there was a case, or maybe let me put it this way. I visit many places in the Eastern Cape, more especially if I found that there is no production in a particular place, I go there myself. And then when I have gone to that particular place, I will myself interact with the head of prison, the head of police, and all the stakeholders to see to it that the court which I had gone to do will be proceeding in any event. That is how then I am able to solve the problems in that way, and my court becomes productive in that way. But I'm of the view that there are other skills that I would bring to the High Court. For example, I remember that at one stage, as the regional court in the Eastern Cape, we were of the view that virtual court must be used because we use it, the virtual court, using Section 159 of the Criminal Procedure Act. And more especially when it is a criminal court case, for example, where you find that the evidence is simple, like in a case where there is a theft of a motor vehicle. The only reason that witness will be coming there is to testify that I'm the owner of the vehicle, something was stolen from my vehicle. And then we have found that virtual courts cannot be used only for civil. And we are of the view as the regional court that virtual courts can also be used in criminal cases. For example, there is no reason why a person would come all the way from Johannesburg to Eastern Cape to testify about an issue of maintenance. Why should that person not testify from a court in Johannesburg? Now, that is another perspective that we want to influence the high courts also to adopt, because it saves money, cost, and it saves time.
Thank you. Thank you, Chief Justice.
Thank you, ATJP Premier.
Thank you very much, CJ. Good afternoon, Mr. Dunga, once again. I think let me just appreciate your patriotic work that you have been doing and the experience that you have been impacting. As I'm seated here listening, I'm also learning a lot about what is going on there on the ground. But my interest in the work that we have been doing is, to what extent have you been interested on transformation, understanding that we are in a very patriarchal society, which has been exacerbated by both the colonial and apartheid system. What's your attitude on that?
Thank you, Premier. Sorry, thank you, Commissioner. Commissioner, I have started with the issue of transformation in my own region. And in the sense that, as we speak currently, my region has 20 females who were appointed as regional magistrates. And in also, the way we do our appointment in the regional court, it is such that it must be the reflection of the demographics of the region. Meaning, taking from statistics, which population is the most represented one. For example, it must be African. And then you consider then all other races in a demographic and in a form which also represents the demographics of that particular race in that particular region. Therefore, the issue of transformation is my priority, and we have worked in that system, in that way in the region. Thank you. Thank you, Commissioner.
Thank you. JP Tlaleti.
Thank you, Chief Justice, and good afternoon, Mr. Dungwa Yerama.
Thank you, Commissioner, and good afternoon, Commissioner.
Thank you. You've given us a good account of yourself on your managerial skills and administrative skills in the judiciary. In the questionnaire that was provided, there was also provision for this body to be able to assess you on your judicial intellectual acumen and leadership, and that we should not only depend on your ipse dixit, let me say, on your say-so. I'm good at this, I've done this, and I've done this. And to deal with that aspect, you are requested to provide some judgments that this body can read and assess you on what you have written. On the judgments that you have attached, one deals with the stay of a warrant of execution. The second one is a bail application where you sit as a court of first instance at the High Court. The second one relates to, it's a special review in terms of the Criminal Procedure Act. And the fourth one is a criminal appeal where you sit in the High Court. Now, the GCB says what you provided to this body is not sufficient for us to positively say you have the requisite knowledge of the law, including constitutional law, to be appointed as a permanent judge. It's quite a long question. I hope you understand it.
I understand it.
They say for us to be able to assess you on what you provided to us is not sufficient for us to do that task. What do you say?
My view, Commissioner, is that that statement may be lacking something. Because, first of all, if you are in a court of law, you don't prescribe what type of judgments must appear before you. You are given, if for example, you are, let's say, a junior judge, the senior judge gives you certain files for you to do on a particular day. And it is not necessary then prescriptive for you to say, I don't want this one, I want a particular one. Therefore, judgments are as a result of the work which has been given to you. Secondly, in my view, I thought by bringing a case on review, I was showing my skill and my ability to deal with bail and my knowledge of the law which deals with bail and criminal law in general. And you can see in that review also that I understand what I was saying in that particular review. And that is why also the comment by Advocates for Transformation is also positive, in fact, to all the judgments that I have submitted. The other judgments about COIDA is also a judgment about civil law, and it also shows how I applied my mind in relation to issues of civil, as well as the special plea which was raised, and that also relates to procedural law in civil law. And then the other judgment also, which is the one of execution, also that one is about my knowledge also of procedural law, which relates to the rules of court which are to be applied. For example, I deal in that judgment with Rule 45A. And the rules are the most important part. I think, I don't know where I had it, that rules of court are the most important part which must be administered by somebody who is a judicial officer. If one has no knowledge of how the rules apply, that person is lacking when it comes to civil. Therefore, in my view, the way I have handled that judgment also, which relates to the rules, is an indication of my experience and knowledge of civil. The last judgment also, unless I've forgotten, the one which deals with sentence. That one also shows my skill and my expertise when it comes to dealing with criminal law and how sentences should be approached. And I've dealt with that at length, quoting various cases. In my view then, I don't think it would have been ideal for me to come with maybe certain judgments. For example, I have done judgments like on Paja, I've done judgments on matrimonial law, I've done judgments also on issues of tender, I've done many judgments. In my view, I don't think one should come with particular judgments in order for him to be assessed that he is the strongest judge ever. I think the issue of being who you are is directed at what you have produced. If you can be saying, these judgments I have quoted also. No, there was a misapplication of the law. There was something which was not done properly. I would understand then if one would say that, but not in the circumstances where somebody would prescribe that you must particularly submit certain judgments in order to be assessed. I don't agree with that.
I thank you, Mr. Dumia. Thank you, Chief Justice.
Thank you, JP. Commissioner Trolley?
Good afternoon, Mr. Dunya.
Afternoon, Commissioner.
I've asked you the question, I just want it on the record, around the Moseneke Commission's rationalization of courts and the relocation of the Makanda High Court to Episho. Yes. What is your feeling about that?
Let me take it first on a lighter note. I'm a resident of Makanda. I'm inclined to say the opposite. That was taking it in a lighter note. No, to be honest with you, I have read the Moseneke Commission myself, the report, and I remember that we were in one of the meetings of the Chief Justice when we came with those reports. I agree with the Moseneke report in the sense that the Bishop must be the seat of the High Court. And for example, let me take my position as a regional court president. I have an office in Port Elizabeth. Department of Justice is in East London. High Court is in Grahamstown. Now, I don't know where I belong between the two places. Therefore, I agree with the Moseneke report in that as long as Grahamstown will remain being a court with all the staff there, in the meantime, there is no accommodation in Bishop. Therefore, it will still take the Department of, our Department of OCJ a long time to build, or maybe Public Works to build accommodation for us in Bishop. But my viewpoint is that the Moseneke Commission is correct in saying we must go to the capital of the region, which is Bishop. And as long as the Grahamstown will not also be destabilized in the sense of the fact that there are judges which are bringing the economy also in Grahamstown and all the things which are related to the fact that High Court is still serving the interests of the people of Grahamstown.
Thank you, CJ.
Thank you, CJ. Hi, good afternoon again, Mr. Boone.
Afternoon, Commissioner.
The first thing is just a follow-up on the debate that we have been having with my fellow Commissioner, Justice Jalezi, with regard to the material that you provided to this body, for this body to assess your competency and suitability for you to be considered for appointment. My understanding of the GCP concern is that the material that you provided to us in the form of judgment, it's not adequate for this body to assess your suitability. I've got no doubt that you might have done something on law of contract, you might have done something on the company law, but you did not provide judgment on company law or the law of contract. And That is where the lacking comes in. That is just a follow-up on the question. But that is the follow-up comment. But my specific question to you relates to the judgment of Tsegiso and the Minister of Justice, and which concerns Section 35 of COIDA. You set out the provision of COIDA in paragraph 45 of the judgment, and then in paragraph 66, you make a finding. Besides the typographical error there, you wanted to say a right, but you said a fight. It's in line 4 of paragraph 66. My concern there is you made a reference to ill employee when in fact we're dealing with an injured employee. What does the reference to ill employee, does it have any connection to the issues that were before you?
Sorry, Commissioner, that there's part, maybe is because I was trying to page, there is part which I did not get from the question. I request you, Commissioner, to repeat the question for the second time.
Okay, all right.
Because I'm here now, I'm with the Judicial judgment, I have found it now.
Okay, thank you. Yes. In that judgment, you are dealing with the Section 35 defense that was raised by the police. You'll recall that it's a matter that relates to the shooting by a fellow employee.
I agree.
Yes.
I agree, Commissioner.
And your conclusion is at paragraph 66 of the judgment.
Yes, I'm there, Commissioner.
And then in line 4 of the judgment, I'm sure there's a reference to fight, but when I read it, that reference to fight is supposed to mean the right. Do you agree with me?
That reference to?
Fight. There's a line 4. Just look at the line 4. Paragraph 66, line 4.
I think it refers to a right.
Yes, but you said that the common law fight.
That was a typographic error.
All right, okay. But in the same paragraph, you seems to, well, there is a reference to ill employee. That reference, what is it intended to convey? Is it part and parcel of the judgment? Because we're not dealing with ill employee, but we're dealing with injured employee. Understand my question?
If I understand your question well, I think that ill is also a typography, in my view.
Okay.
Yeah, I don't agree that it was referring to ill as ill.
All right, so yes. I think that the learner's exercise there is that you have to check your judgment, the spelling using that tool that you have just referred to, the Grammarly.
Yes.
Because now it's...
No, I accept that.
It creates a problem.
I accept that, Commissioner. And in fact, after having discovered the Grammarly that I have, I found that Grammarly is so accurate, more than even the researcher that we are using, because we use the researchers in order to proofread our judgments. I agree, Grammarly is the best. I don't think I will make that mistake again, Commissioner.
Thank you, CJ.
Thank you, TP. Commissioner Mangena.
Thank you, CJ. Good afternoon, sir. I'm here. Oh, yes. I just want to take you back to the answer that you gave to the Premier regarding your commitment to transformation.
Yes, Commissioner.
Yes. You come with 44 years of experience in criminal court practice.
Yes, Commissioner.
And you are competing for these positions.
Yes.
Against 6 women.
Yes, Commissioner.
3 white females and 3 black females.
Yes, Commissioner.
Does your commitment to transformation includes commitment to gender transformation, which is a constitutional imperative?
Thank you, Commissioner. I'm very much clear about the issue that you are raising, in the sense that, as I indicated previously when I was responding to the questions by the chair, I specifically said that the reason for my waiting, I have been waiting, I think I had 4 regional magistrates who at different times of the advertisement applied to the JSC to be appointed as judges. To be honest, I did wait for all of them to apply. But when the post of Makanda and Mtata was advertised, I felt that the appointment of an African male has been not done by the JSC for the past 5 years. There was no male ever appointed during that period. And my viewpoint was that, at least now, men have been waiting, African male. Even in the last one, we had other races appointed, males also in other races appointed. But in my view, if we look at the demographics also of the country, African male as a dangerous species, which is not, which is, I mean, maybe let me put it this way, endangered species, which is also needed for the judiciary because they represent the highest population of this country, and in particular in this region of the Eastern Cape.
I will leave it at that, CJ. We are pressed for time.
Any further questions, Commissioner Littleton?
Thank you, Chief Justice. Good afternoon, Mr. Dunya.
Afternoon, Commissioner.
I will ask you the question about the anti-sexual harassment policy. What are your views on it?
I'm of the view that sexual harassment policy was long overdue because it is a tool which is going to be dealing with all the complaints which have been kept under the carpet. And I'm of the view that it is the policy which has to be respected, and it is the policy which must be introduced in all corners of our work. Hence, as regional court presidents, we were the first people to deal with this document of sexual harassment, giving our inputs, giving everything for, and after that we sent that document to the Chief Justice. I'm of the view that the policy should be given, as it is also prescribing, to all the people who are joining us as judiciary in our courts, meaning all people who are acting should be given the policy. And the policy also prescribed that there must be courses which must be attended by all permanent judges, by all permanent regional magistrates and magistrates, so that in that way everyone must not be caught unaware, but they must be able to deliver when it comes to the issue of the policy. And what I also like about the policy is that it does not necessarily cover instances between judicial officers themselves. It covers also instances which relate to other employees of the department, which is helping and supporting us, and including the members of public also, who must be protected by the same policy.
Thank you, Chief Justice.
Thank you, RCP Dunyo. We've reached the end of your interview. You're excused.
Thank you, Chief Justice, Chairperson of the Commission. Thank you, honorable members of the Commission. And I also thank the staff of OCJ for making our way to this place to be possible. And lastly, I also thank the members of the law bodies who has assisted us with the documents they have supplied us with.
Thank you. Shall we clear the room then for deliberations?